Who knows what is that?
There was a directions to post
Wait,
the
sir.
matter.
Give the memos, yes. One ನಿಮಿಷ ಒಂದೊಂದಾಗ್ತಾ ಒಂದು. Settlements ಕೊಡಿ. All settlements. Whenever you want, you just give it.
Limit, my lord. 13th.
Give all the settlements, make a mention of when you want. Pokso na? ತಗೊಳ್ಳಿ, yes. 2:30 ತಗೊಳ್ಳಿ. Give it, ಯಾವಾಗ ಬೇಕು ಬರ್ದು ಕೊಡಿ.
Fresh matter.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಕೊಟ್ಬಿಡಿ. ಒಂದ್ ನಿಮಿಷ, 1 by 1. Settlement is over. Withdrawal memos ಯಾವ್ದೆಲ್ಲ ಕೊಡಿ. All withdrawal memos. Then we will withdraw it. You need not wait. Yes. Now ಏನು? Pending matter. Posted for charge. ಇಲ್ಲಿವರೆಗೂ what were you doing? ಪರವಾಗಿಲ್ಲ, ಏನ್ ಮಾಡ್ತೀರಿ? ಅಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಅಲ್ಲ 2 months ಮುಂಚೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಅಲ್ಲ ಅಂದ್ರೆ 2 months ಮುಂಚೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ನಿಮಗ್ ಬಂದಾಗ ಅರ್ಜೆನ್ಸಿ ಆಗತ್ತೆ. ಸರಿ ಕೊಡಿ. ಎಸ್, ಟುಮಾರೋ.
This one also. This petition.
I'll stop taking memos if all of you are behaving chaotic. That's tomorrow. Give it. Yes. Tomorrow, 13th. ಯಾವತ್ತದು ಮೇಡಮ್? DA 13th ಅವತ್ತು ತಗೊಳ್ಳಿ. Yes. Covered by 2025 January. Yes. Next. No sir. MPMLA matter. ಮತ್ತೆ wait. Yes. Stay ಇಲ್ವಾ? Stay ಇಲ್ದರೆ ಕೊಡಿ. Take it. ಮಂಡೇಗೆ ಹಾಕಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮಂಡೇಗೆ ಹಾಕಿ. Do you have an interim order in your favor? Monday. Not to precipitate ಇದೆಯಾ? Monday, fresh matters. Tuesday. Wait. No intervening shouting here. Yes. ಆಯ್ತು ಕೊಡಿ. Monday or Tuesday, whatever. Adit, fresh matters, please don't wait. Everything on Tuesday only. Monday is a holiday. So all on Tuesday. Before that you want, please wait. Please tell me. And all of you don't say before that I want, unless there is urgency. Huh? ನಾಳೆ ಕೊಡಿ. It's tomorrow. ಮೇಡಮ್ ಇವತ್ತಿದೆ ಅಲ್ವ 7A cases? 13 ಇದೆ. 7A ಯಾವತ್ತು? ನಾಳೆ 13th Friday. Yes. Husband. Yeah. Pending matter. It will come. Yes. No problem. It will come. No, don't move pending matters. And please give pending matters no dates next week ಅಂತ ನಾನು ಹೇಳೇ ಇಲ್ಲ. Then don't create a ruckus here that next week ಹೇಳಿದೆ ಅಂತ. ಯಾವುದು ಇಲ್ಲ ಕೊಡಿ. If you want to give all the memos, please give. Please give all the memos. No pending matters. I'm giving dates. Please give it. Lord. No problem. Give it, sir. You give the memos. 2025 January, sir. Give it. Yes.
Vehicle release, my lord.
Vehicle release ತಗೊಳ್ಳಿ ಅದು.
Vehicle release.
Vehicle release ನಾಡಿದ್ದಕ್ಕೆ ಹಾಕಿ. Lord, one.
There was a directions to post the matter immediately after service to.
It will come, sir. It will
Posted
come.
for charge.
No problem. Posted for charge. When,
Trial
sir?
court. Next month ಅಲ್ಲಿ charge.
Next month ಗೆ ನೋಡೋಣ. Next month ಅಂದ್ರೆ?
ಅದೇ next month first week.
Next month October first week.
October first.
September last week ಅಲ್ಲಿ ತಗೊಳ್ಳೋಣ.
Date ಅದು.
Yes. ಬೇಡ move ಮಾಡಿ ಆಮೇಲೆ.
Lord,
When it comes to the brim, you move. Leave it. Yes.
Lord, in case of a cheating, Lord, I have been arrested.
Pending sir.
Fresh matters, Lord.
Monday ಕೊಡಿ. Tuesday ಗೆ. ಅದೇ ನೀವು ಹೇಳ್ತಾನೆ ಇದೀನಿ, ಮತ್ತೆ ಕಾಯ್ತಾ ಇದ್ದೀರಾ?
Lord, there is urgency, therefore I have submitted, Lord. Second effort.
Bail ತಗೊಂಡಿದ್ದೀರಾ?
Yes, I have been arrested. Statutory bail has been granted, Lord, to prevent me from coming out of the jail. Second FIR has been registered, Lord.
Give it. ಗಿರಿನಗರ್ ಡಿಸ್ಪೋಸಲ್ ತಗೊಳ್ಳಿ ಮೇಡಮ್ ಎರಡು. When did you join there, sir? And you are talking when I'm doing this? Wait. ವಾರಂಟ್ ಇಶ್ಯೂ ಆಗಿದೆ, ಯಾಕಾಗಿದೆ? ಕರೆಕ್ಟ್. ನೀವು ಕೋರ್ಟ್ ಹೋಗಿಲ್ಲ ಅಂದ್ರೆ ವಾರಂಟ್ ಇಶ್ಯೂ ಆಗುತ್ತೆ. ಸೀನಿಯರ್ ಸಿಟಿಸನ್ ಆದ್ರೆ ಏನಾದ್ರೆ ಅದಕ್ಕೆ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ? Tuesday, yes.
I'm suffering an interim order. I filed a vacating IA.
Give that, yes. Vacating IA, whatever it is, give it. At vacating IA, madam, kodi. Yes.
Officer not increases the bank account of 116%, including the bank accounts of the advocate. Complaint is only with respect of 3 lakhs rupees, someone his deposit is not refunded.
Tomorrow. Yes.
Matter on the aircraft act, Manoj, the petitioners of pilot NBW is issued straight away once the charge sheet is filed, Manoj. There is some.
You are not present on the date of
Manoj,
taking of
immediately
cognizance.
on the charge sheet being filed,
On
Manoj.
Tuesday, yes.
My lord, there was a mediation on 4th of
If it is fresh, please give it for Tuesday. Before that, don't make a mention.
My lord,
Wait,
for the
Yes.
settlement, they told they will come and talk, but they didn't come, my lord.
who will come and talk?
The other party.
What should I do? Make them talk?
No,
Then?
you told you will be posting it.
I
on
told.
5th. Yes, my lord.
What?
That it will be.
Pending or
posted
fresh?
on- Pending, my lord.
Give it, give the memo, no date. Yes. Vacating stay ತಗೊಳ್ಳಿ. Vacating stay ತಗೊಳ್ಳಿ. Passport, give that, yes. Why 2:30? ಆಯ್ತು 2:30 ತಗೊಳ್ಳಿ.
Yellow
12th, MPML matter 12th ಕೊಡಿ.
yellow says issued, Malo.
Smarter, but 7A.
ಇಲ್ಲಿ ಕೇಳ್ತಾ ಇಲ್ವಾ? ಟ್ಯೂಸ್ಡೇ ಕೊಡಿ ಸರ್, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅದಕ್ಕೆ ಮುಂಚೆ ತಗೊಳಲ್ಲ ನಾನು, ಕೊಡಿ. ಏನ್ ಅರ್ಜೆನ್ಸಿ? ಪರವಾಗಿಲ್ಲ, ಮಾಡಿದ್ಮೇಲೆ ನೋಡೋಣ ಬಿಡಿ. ಮಾಡಿದ್ಮೇಲೆ ಪಕ್ಕದ ಕೋರ್ಟ್ಗೆ ಹೋಗಿ ತಗೊಳ್ಳಿ. ಎಸ್, ಗಿವ್ ಇಟ್ ಸರ್. ಡೋಂಟ್ ಪ್ರೊಜೆಕ್ಟ್ ಸುಡೋ ಅರ್ಜೆನ್ಸಿ. 13th.
One matter, defreezing of bank account. Matter was directed
ಅದು
to be
ಇನ್ನೊಂದು ತಗೊಂಡ್ರೆ
listed today
tomorrow.
at 2:30 minutes.
ವೈ ಸರ್?
Yesterday it was directed to be listed today minutes.
ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಡಿಫ್ರೀಸಿಂಗ್, ಎಸ್.
My lord, the pending matter, Malo, there is.
ಗಿವ್ ಇಟ್, ಗಿವ್ ದ ಮೆಮೋ.
My lord, yellow says issued, Malo, it's the last Monday. and
ಆಯ್ತು
Friday.
ತಗೊಳ್ಳಿ ಅದು. ಗಿವ್ ದಟ್, ಪೋಸ್ಟ್ ದಟ್ ಆನ್ ಫ್ರೈಡೆ ಮೇಡಮ್.
Friday, please, Malo.
ಟ್ಯೂಸ್ಡೇ, ಎಸ್. ವಾಟ್ ಅರ್ಜೆನ್ಸಿ?
I have obtained interim order by this court. The investigating officer during the pendency of investigation had directed the retail outlet of mine to stop supply to me. In spite of receiving interim order of stay, he does not revoke that notice, and I run a retail outlet, a petrol bunk, my lord. So supply is not there for me. I'm put into a lot of hardship because of that. Though I have an interim order in my favor, he is not revoking the notice. That is the urgency.
ಕೊಡಿ. 12th ಹಾಕಿ ಅದು.
Other accused have already obtained.
Tuesday, yes. Tuesday.
The lordships for IA for vacating stay, my lord.
Give that,
The lordships, the respondent has no objections in allowing the petition.
seriously. Very good. ಅದು post it on 12th. No, it won't. It will be posted according to the date of the court, madam. Yes, give it. It will come, madam. Yes.
My lord,
No objection to all of this.
ತಗೊಳ್ಳಿ, ಕೊಡಿ. ಅದು ಎರಡು, ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಟು ಅಲೋ ಇರೋದು ನಾಳೆಗೆ ಹಾಕಿ.
My lord, the petitioner is the husband. Wife is
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್.
wife filed a case and he restrained to enter the premises, my lord, house.
ಅದು ಇಲ್ಲಿ ಹೆಂಗ್ ಬರುತ್ತೆ?
Allah, he has already filed a case.
ಅಲ್ಲ, how will that come here? If
He
wife has
filed-
got a restraint
already
order
civil
against you?
cases are pending before the trial.
Maybe, but how will that come here, sir?
Allah, criminal case ಹಾಕಿ ತೊಂದರೆ ಮಾಡ್ತಾ
ಆಯ್ತು,
ಇದ್ದಾರೆ.
ಮಂಡೇ ಹಾಕಿ, ಟ್ಯೂಸ್ಡೇ ಹಾಕಿ. ಫ್ರೆಶ್
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಪೆಂಡಿಂಗ್ ಆದ್ರೂ ಬರಲ್ಲ.
ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆ,
ಏನ್
ವಕಾಲತ್
ಪರವಾಗಿಲ್ಲ.
ಹಾಕಿದ್ದಾರೆ.
ಪರವಾಗಿಲ್ಲ.
ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ವೀಕ್
You are the husband ತಾನೆ?
Yes, ma'am.
No problem.
ಅಲ್ಲ, ಸಿವಿಲ್
It
ಕೇಸಸ್
won't
ಆರ್
come, sir.
ಪೆಂಡಿಂಗ್.
Maybe.
My lord,
Case and counter case, different investigating officer.
ಅಂತೇಳಿ ಕವರ್ಡ್ ಅಂತ ಹಾಕಿದ್ರು. Yes.
May I mention, Your Lord?
investigation matter, charge sheet was filed,
SIT,
SIT.
which one?
My lord's mining matters, the CBI which
ಆಯ್ತು.
came here. Adralli.
Fresh matter.
Alla, fresh matter alla. In that, what happened is, my lords, at the time of framing charges, we approached this honorable court. This honorable court would pass an order to defer the framing of charges and would exempt me from appearance because of me being a cancer patient and a senior citizen. Now, all this has happened in December 2023, my lords. After that, my lords, they have not sought for any modification of this order. Now, in the guise of saying we have a new investigating officer, a notice is sent and asking me to appear before the new investigating officer, my lords. We have filed an IA. It
Yes,
could be either in the end of the list today or tomorrow, my lords. I do.
but you serve a copy on Jagdish.
I'll send a
Yes.
copy. Tomorrow,
2:30.
please.
My lord.
Oh, ನಿಮ್ದ BS ಪ್ರಸಾದ್ ಸರ್ವ್ ಮಾಡಿ.
I'll give.
This matter was disposed,
Pending or fresh?
pending, my lord.
Ah.
This was disposed of in April in NCLT, whereas. the
NCLT,
National Company Law Tribunal. Your
what is that got to do before this court?
No, the petitioner had filed a petition to.
Fresh or pending, sir?
Pending, my lord.
It won't come. Yes, leave it. Yes.
My lord, is disposed of.
So
There is
what?
interim stay.
So what?
You gave interim stay here, your own again.
Did I grant a stay not to, for the NCLT not to proceed?
No, they filed
Then-
an application before the trial.
No, sir, don't tell me all this.
My lord, can you?
No, sir, I will not. Yes.
Please,
Why? ಏನಾಗಿದೆ ಅದರಲ್ಲಿ?
in crime number, anticipated bail was allowed for court use.
Yes. ಅದು ಕೊಡಿ, ವಿಂಗ್ಸ್ ಬಗೊಂಡು ಕೊಡಿ. ನಾಳೆ ಹಾಕಿ. ಹಾಕಿದ್ರೆ ಬರುತ್ತೆ.
My lord, being spoken to.
May I make a mention, your lordship?
NCLT has nothing to do with the crime here. If it has disposed, you challenge it in a manner known to law.
My lord, on the basis
May
of
I-
that, you granted a stay, my lord. On the basis of that
In,
order.
in 482,
Yes, your honor, my lord.
on basis of what?
On the basis of NCLT moratorium order,
All
you
right,
granted
give
a stay,
Give it.
but it has been disposed of, my lord.
ಯಾವ್ದು ಮೇಡಮ್? I have, it is disposed here.
That case on the basis of which you
Wait,
granted it.
wait. ಯಾವ್ದದು? ಆಗಿದೆಯಾ? ಅದು ತಗೊಳ್ಳಿ ನೋಡೋಣ. ಕೊಡಿ.
My lord, covered.
My lord, being spoken to certain modifications.
Give it, yes, tomorrow. Tuesday.
May I make a mention, your lordship?
PML.
Matter, complainant's petition, my lord, charge sheet is filed without the FSL report, which is a violation of this court's order. It's a fresh matter, may I request for Tuesday.
Tuesday.
Several times memo,
Hold on.
May I make,
several times memo has
No
been.
problem, sir. Tuesday, yes.
One
ಹೇಗಿದ್ರೆ ಬರೋಲ್ಲ, ಫ್ರೆಶ್ ಇದ್ರೆ ಮಾತ್ರ.
My lord, here, my lord, when the case was listed, the court has given time of 1 week to take steps and to consider the interim prayer. And still several times memo has been moved, my lord. 2023 matter, my lord, it is not coming.
ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್
Fresh, my lord, because interim order is not considered.
Tuesday, yes.
Covered judgment, my lord. PML.
PMLL covered.
Same connected.
25 January, ಏನ್ ಬೇಡ. Yes, next.
Fresh matter, my lord.
ನಿಮ್ದೇನು?
Fresh matter.
Tuesday, give it.
We were.
Payment of charges on, it's on 19th, my lord, finally, that's all.
Give it on Monday, 17th ಹಾಕಿ ಮೇಡಮ್.
The lord petitioner was before this court for quashing of FIR. Just before the
Charge sheet.
date of hearing. charge sheet was
ಲಿಬರ್ಟಿ
filed.
ತಗೊಂಡ್ರದ? ಅದ್ ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
This one.
ಅದ್ ನೀವು ಮೂವ್ ಮಾಡಿ ಆಮೇಲೆ. ನಿಮ್ದೇನು?
may,
Last week it was posted, vacating stay batch matters. It was missed today, tomorrow is here.
ನಾಳೆ.
Tomorrow, much obliged.
may I make a mention, your lordship?
1 minute, sir.
I'm a complainant in a case which your lordship is disposed of because parties settled the matter. Post disposement, he is not complied with the compromise. Anytime.
Give it, give it, give it.
Yes,
Tomorrow.
yes.
Yes. Huh?
Your lordship?
Yes, sir.
Your lordship had directed the investigation officer to be present today by 2:30 and the 10th, and the matter was supposed to be listed by 10th. As
It
per
is
your
not listed,
lordship's
is it?
direction. It is not listed, your lordship.
ಯಾವ್ದು?
He is going abroad on 12th. It has to be listed by today, your lordship.
NDPS. ದೃಢಪಟ್ಟಿರುತ್ತದೆ.
NDPS Act.
Why it's not listed? Date given? ಯಾಕೆ ಡೇಟ್ given ಬಂದಿಲ್ಲ ಅದು? Madam, these listed, then we'll take serious action.
I verified that, my lord. In fact, the charge sheet has been filed for section 27 for consumption. Though FSL report says that it's negative, but actually the charge sheet should have been filed for 20B because there is the possession of ganja.
ಏನ್ possession?
Possession ಇದೆ ಅವರ
What possession?
ganja. 15 grams
And
of
that
ganja
we
they
will submit, your lordship.
Grams
Section
of
50 of NDPS is not.
quantity.
ನಿಮ್ ಪಾಕೆಟ್ ಇಂದ ತೆಗೆದು ಅಲ್ಲಿಗೆ ಹಾಕಿದ್ರ? No
It
problem.
should have been that, unfortunately.
Should have been that.
Correct.
ಮುಂದೆ ಮಾಡ್ಕೊಳ್ಳಿ. We will quash this. This is not the way to function. Where is that man?
Now, it is there.
Get him at 2:30.
I'll
Yes.
get him.
Get him at 2:30.
It will be listed by 2:30, no, sir. Your lordship.
Yes.
Much obliged.
Lord, 406, 420 offense that had been quashed on the basis of settlement. My lord had observed that all consequential actions pursuant to registration of the FIR will also stand
All
quashed.
right. What happened?
Unfortunately, the police are not cooperating and not defreezing my account, saying there is no specific order to defreeze. Therefore, I'm seeking indulgence of the
Yes,
court to act.
Jagdish. All per consequential action taken to registration of crime. ಅದಕ್ಕೂ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಫೀಸರ್ ಹತ್ರ ಹೋಗ್ಬೇಕಾ? This court on 29th July 2024 had closed the proceedings recording the settlement between the parties in an offense punishable under section 406 and 420 of the IPC. The matter is moved again, being spoken to on the score, despite the observation that all consequential actions taken pursuant to the registration of the crime shall also stand quashed. The investigating officer is not directing defreezement of the account that was frozen on account of the registration of the crime. It is made clear all consequential actions would mean including the defreezement of the account. If the investigating officer is acting contrary to the directions, the matter would be viewed seriously. Therefore, the order shall be treated as part and parcel of the order passed. Yes, sons.
Grateful.
But two,
That's the date of charge sheet, minutes is recorded as 1/3/2018. It's my
You want
mistake.
warrant against witnesses?
Yeah.
Oh, sorry, second one. Sorry.
Second. That's the date of charge sheet is 27/11/2018.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ ಇನ್ನೇನಿಲ್ಲ.
ಯಾವ್ದ್ರಲ್ಲಿದು?
But that's page number 18, that's
This
the
court-
charge.
For that customs.
Yes, ma'am.
This court on 9/8/2024 had disposed the petition. The petitioner has moved the matter being spoken to on account of a inadvertent typographical error with regard to the date of the charge sheet.
Let's file a memo for that.
ಕೊಡಿಯದು ಮೇಡಮ್ ಅದಕ್ಕೆ ಮೆಮೊಲ್ ಏನಿದೆ ನೋಡ್ಕೊಂಡು.
That's one more
Part and
request.
parcel.
May I request, that's for the name of the council. My colleague's name was maybe recorded if it's firms.
ಏನ್ ಬೇಕು ಯಾರ್ದು? Her name? All right.
The other day we had to mention.
No problem. Young advocate's name, we will definitely do it.
But he was worked
Yes.
out for it.
ಅಲ್ಲಿ names ಅಲ್ಲಿ, what's your name, madam? So ಬರ್ತ್ ಕೊಡಿ. So appeared along with ಅಂತ ಮಾಡ್ಬಿಡಿ.
Grateful.
fresh matter still number 3.
This case, appear for petitioner, Your Honor. Filing a memo, I served the notice to the council appearing for complaint before.
Next date ಯಾವತ್ತಿದೆ?
24th ಇದೆ.
List the matter on 18th in the fresh matters list. One chance ಕೊಡುವ. Yes. Next.
Number 4.
For the petitioner.
Warrant against witnesses.
Yes, sir.
Why? Yes, Jagdish.
Check has been issued to the witness.
Check. Sorry.
138 proceedings.
Notice ಮಾಡಿದೀವಾ?
ಮಾಡಿದ್ವಿ ಸರ್. ಸಮನ್ಸ್ has been issued. ಸಮನ್ಸ್ ಇಶ್ಯೂ ಆಗಿದೆ. ವಾಟ್ಸ್ಆಪ್ ಮೆಸೇಜ್
ಇಲ್ಲ
ಕಳಿಸಿಲ್ಲ
ಸರ್ ಮಾಡಿದೀರಾ ಅವ್ರಿಗೆ?
ಅವ್ರಿಗೆ ಮಾಡಿದ್ವಿ ಸರ್.
ಇಲ್ಲ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅಲ್ಲಿ ಇಟ್ಕೊಂಡ್ರೆ ಎಸ್ ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ 18th in the fresh matters list. ಅವ್ರು ಡಿಸ್ಪೋಸ್ ಮಾಡು. ನೆಕ್ಸ್ಟ್
5.
MDR matter that you lordship may take up some other day. Then I have
ಕುಮಾರ್ ಇದೆ ಇವತ್ತು.
there are some instructions are not come. Today morning I spoke to secretary and I have informed secretary that the department is not giving proper instructions. I'm meeting him today. We'll have all these matters to be taken up.
We'll take all these MMDR matter. ಏನು ಅರ್ಜೆನ್ಸಿ ಏನು?
ಚಾರ್ಜ್ ಇತ್ತು.
ಚಾರ್ಜ್ ಇದೆಯಾ?
ಹೌದು.
ಎಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇರ್ತೀರಾ?
ಅದೇ ನಾಲ್ಕು ಸತಿ ಬಂತು.
Learned additional SPP submits that he would require some more time to secure instructions. ಬರೀಲ್ಲ non cooperation ಅಂತ. Some more time to secure instructions and make his submissions in the matter. List the matter on 20th at the request of the 19th at the request of learned additional SPP. The learned counsel for the petitioner submits that the matter is slated tomorrow for the purpose of framing of charges. In the light of the aforesaid submission, the framing of charges ತಾನೆ?
ಇವತ್ತಿಗೆ.
Huh?
ಹೌದು, framing of charges.
Framing of charges. The court shall defer its action of framing of charges till the next date of hearing. Yes, next.
Still number 6.
This after 4 weeks interim order subsisting shall continue to the next date of hearing. Now it's settlement ಆಗಿದೆಯಾ ಇದು?
Settlement ಆಗಿದೆ ಸಮಿತಿ. Respondent is not coming to the court notes for reporting settlement notes. Mediation
ಆಗಿದೆಯಾ?
Mediation report is there notes. It is appeal against acquittal notes.
It will stay it for now.
Not stay is already there notes.
Then leave it. Yes.
Notice ಆಗಿದೆ.
ಒಂದು ಚಾನ್ಸ್ ಕೊಡುವ. List the matter after 2 weeks interim order subsisting shall continue to the disposal of the petition. Yes, next.
8.
Now you are fit to stand trial.
At least director to provide proper treatment.
That I will direct. Yes. The petitioner is before this court calling in question an order dated 13/3/2024 passed and on an application section, we will permit trial to go on. Whenever needed, he shall be given appropriate treatment.
By a psychiatrist, at least.
By a psychiatrist, of course, yes. So and so. Passed on application 329 of the CRPC, seeking a direction to the jail authorities to provide proper treatment by a psychiatrist to the petitioner, as the contention of the petitioner was that the petitioner was not in a position to stand trial for an offense under section 302 of the IPC, owing to his mental condition. This court directed the state to get the petitioner examined by by NIMHANS, and the report of the said examination is placed before the court, which is dated 9/7/2024. The report of NIMHANS reads as follows. Reads as follows. In the light of the said observation or the forensic opinion of NIMHANS, there is no impediment for the petitioner to stand trial for the aforesaid offense. The only request of the petitioner at this juncture would be that when the petitioner is required treatment, he shall be treated by a psychiatrist. The submission merits acceptance, which is not opposed by the counsel, the learned additional SPP as well. In that light, the petition stands disposed, directing the petitioner, directing for the trial to be continued against the petitioner, with a rider that in the event the petitioner would require treatment of a psychiatrist, the jail authorities shall, without driving the petitioner again to this court, give such treatment from the hands of a psychiatrist. With the aforesaid observation, petition stands disposed.
Right.
Instructions ಬಂದಿದೆಯಾ?
Yes, my lord.
ಕೊಡಿ.
No, before that, my lord, your lordship may see statement of objection filed by the complainant.
ಕೊಡಿ.
And this is by respondent number 3, my lord. Your lordship may come.
Our objections, ಹಾಕಿದ್ದೀರಾ?
Versions of the respondent 3.
Question number.
I'll get back to you. Entry model ಕೊಟ್ಟಿದ್ದೀನಿ. Entry model 8, yes. ಎಲ್ಲಿದೆ objections R3?
Version
ಅಂತ last unit version ಅಂತ ಹಾಕಿ.
May place that.
But it is
I'll place it, madam.
around 250 pages.
250 pages.
Because flagged also.
ಇಲ್ಲ ಇದೆ ವರ್ಷನ್. If you give new names to objections, ಕಷ್ಟ ಆಗುತ್ತೆ. Version, all right. Yes.
Page 13, my lord.
13.
According to him, my lord, is the report of
ಅದು ರೋಮನ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಇವರು ಪೇಜ್ ನಂಬರ್ಸ್. ಅಡ್ವಾನ್ಸ್ ಆಲ್ ರೈಟ್.
According to him, my lord, is that the NI paragraph, yes, my lord.
ಎಲ್ಲ ಡಿಫರೆಂಟ್ ಆಗಿದೆ. ನಿಮ್ ವರ್ಷನ್ ಬೇರೆ ತರನೇ ಇದೆ ಬಿಡಿ. ಹೇಳಿ.
According to him, my lord, the NIITK report is that this is a bronze. What is required to be constructed is a bronze.
All right.
Now your lordship may look into the NIIT report.
NITK.
It's at page 282. He praised that report also.
Page 282.
Yes, ma'am.
All right.
I'm sorry, page 262, madam.
262. Report is here.
Yes, madam. The conclusion, my lord. Second line.
80% analysis, material used in the statute samples is brass.
Yes.
With a composition approximately 80% copper and 20% zinc.
It's not bronze.
ಅಲ್ಲ bronze ಅಂತ ಎಲ್ಲಿದೆ ಇದು?
The condition is to be construct a bronze.
Where is that?
That your lordship may see the petition itself. The page, document number 3, my lord, page 22.
You are the one who constructed, is it?
Yes, yes, ma'am.
Very good. Yes.
Document number 3, my lord, page 22 of the petition.
Page
22 of the petition.
Of the petition.
Yes, ma'am.
Proposed Parashurama bronze metal sculpture work including so and so. 108 ಅಂದ್ರೆ 1,83,00,000.
Now, they filed an affidavit, my lord, saying that this is a bronze. And they-
Where is that?
This is the affidavit, my lord, respond number 3 filed an affidavit.
Respond number 3.
Yes. Your lordship just saw that, my lord, page 13, yes.
Para 13, yes. Sir.
Yes, my lord.
All right.
ಅಲ್ಲಿ bronze ಅಂತ
Annexure
ಹೇಳ್ತಾರೆ.
20, one ನಿಮಿಷ. What is that annexure 20?
Annexure 20 is the same report, my lord.
Same report.
Yes.
All right. After placing the samples, experts have issued their opinion writing material used in statute. Bronze ಅಂತ ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಒಪಿನಿಯನ್?
ಕೊಟ್ಟಿಲ್ಲ. ಇವ್ರು ಬ್ರಾನ್ಸ್ ಅಂತ ಇವ್ರು ಹೇಳ್ತಾರೆ. ಕಟ್ಬೇಕಾಗಿರೋದು ಬ್ರಾನ್ಸ್, ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿರೋದು ಬ್ರಾಸ್. ಇವರು ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಬ್ರಾನ್ಸ್ ಅಂತ ಇವರು ಹೇಳ್ತಿದ್ದಾರೆ.
ಕಂಪ್ಲೇನೆಂಟ್ ಅಲ್ಲ, ನಿರ್ಮಿತಿ ಕೇಂದ್ರ.
ನಿರ್ಮಿತಿ ಕೇಂದ್ರ. So
ನಿರ್ಮಿತಿ ಕಂಪ್ಲೇನೆಂಟ್ ಇವರು.
Yes. So ನಿರ್ಮಿತಿ ಕೇಂದ್ರ, the way they place the material, my lord, discloses there's something more required to be.
ಇದು ನಿರ್ಮಿತಿ ವರ್ಷನ್ ಇದು.
Yes, yes. Whether the petitioner is innocent or not innocent, that different issue, my lord, but look at the manner in which the documents are placed before your lordship.
All right. Okay. ಇದನ್ನ DC ಒಪ್ಪಿದ್ರು ಅಂತ ಇನ್ನೊಂದಿದೆ.
ಹೌದು.
ಅದು ಯಾವುದು?
So they say that at the directions of the because the structure was dangerous for the people. So DC said remove it. DC only said remove it. In fact, my lord, that there is the half of this DC's document was placed. In fact, my lord,
ಈಗ 1,83 lakhs ನಿಮ್ಗೆ ಕೊಟ್ಟಾಗಿದೆಯಾ? ಅರುಣ್ ಶ್ಯಾಮ್ ಸರ್, 1,83 lakhs ನಿಮ್ಗೆ ಕೊಟ್ಟಾಗಿದೆಯಾ?
ಇಲ್ಲ ಇಲ್ಲ, only partial payment, Lord.
ಈಗ ಫುಲ್ ಬೇಡವಾ?
1,20 ಬೇಕು. ನಾವು ಕೆಲಸ ಮಾಡಿ
ಫುಲ್ ಪೇಮೆಂಟ್ ಬೇಕಲ್ಲ?
ಕೆಲಸ ಮಾಡಿ ಆದ್ಮೇಲೆ ತಗೊಳ್ಳಿ.
ಖಂಡಿತ ಕೊಡುವ.
this is the letter written by the DC, which conveniently, my lord, this Nirmiti Kendra is not produced.
ಏನಿದು ಲೆಟರ್?
This they say, ತೆಗೀರಿ ಅಂತ ಹೇಳಿದ್ದನ್ನ ನಿಲ್ಲಿಸಿ,
ತೆಗೀರಿ ಅಂತ ಹೇಳಿದ್ದನ್ನ
ತೆಗೀರಿ ಅಂತ ಹಿಂದೆ ಕೊಟ್ಟಿ ಡೈರೆಕ್ಷನ್ ನಿಲ್ಲಿಸಿ ಅಂತ ಹೇಳಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಆ ನಂತರ ವಾಟ್ ಇಸ್ ದಿ
ಯಾಕೆ ನಿಲ್ಲಿಸಿ ಅಂತ ಹೇಳಿದ್ರು?
Because of the investigation was pending before all these forums. That is the reason.
Now the statue is completely, sculpture statue is completely brought down?
Yes, it is brought down. In fact, my lord, even that the legs portion, that is not even brass.
Oh, ಅದು ಇನ್ನೇನೋ ಹಾಕಿದಾರಾ?
So my request, my lord,
ನಿರ್ಮಿತಿ ಕೇಂದ್ರ ಗೊತ್ತು ಸರ್. Less said the better about ನಿರ್ಮಿತಿ ಕೇಂದ್ರಸ್. Yes.
My request, my lord, let the investigation continue. We don't know who is the culprit. Maybe the petitioner, my lord, he may also may not have received the full money. He may have. We don't know what is his role. So let the investigation go on, my lord. Then we will know who is the real culprit in the entire episode.
Yes, Arun Sham sir.
My lord, my submission is this, my lord. This is purely a contract between the Nirmiti Kendra and the petitioner, my lord.
Nirmiti Kendra and
petitioner, my lord. There is a contract signed, and my lord, the work order has been
whose
granted.
money goes to you?
Lord,
ಯಾರು ದುಡ್ಡು ಕೊಟ್ಟಿರೋದು ನಿಮ್ಗೆ?
Lord, this is a various project, my lord, comprising of, my lord, one statue, then a film studio, then open theater.
Either money belonging to Nirmiti Kendra nor money belonging to the complainant. It is public money. Yes.
Lord,
so you can't play with public money like this.
Lord, my lord, I am a person who is duty bound to, my lord, complete the work within a time span, my lord.
Duty bound to complete the work as assigned to you.
Please, my lord. Since there was some, my lord, the issue regarding the model
alignment.
Which was alignment. Kindly see the pictures, my lord, at page 26 of the this version filed by at page 280. That axe, my lord, was independently, my lord, it was holding in the hand. Then, my lord, because of that weight, it was unable to carry. Therefore, my lord, they decided to touch it to the head of the statue. And you see the picture, my lord, at page 280. Now, my lord, this entire thing will be completed.
So according to it's only alignment problem.
Yes, my lord, alignment problem. That is why, my lord, entire statue is brought down.
Not because of the materials used.
No, materials, my lord, we will complete the
What
project.
did you use? What ನಿಮ್ ಪ್ರಕಾರ, ನಿಮ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಪ್ರಕಾರ ಏನ್ ಯೂಸ್ ಮಾಡಿದ್ರಿ ಅಲ್ಲಿ?
Same.
What material did you use?
My lord, this
clay na?
Copper and, my lord, zinc is, that is what the report says, my lord.
Copper and zinc.
Yes, my lord.
What was the contract awarded to you?
Lord, copper and, my lord, zinc.
That's all right. What was the contract awarded to you?
Of, my lord, the copper and zinc, my lord.
No, but what was the contract award, sir? What was the contract awarded to you?
Lord, contract says, my lord, bronze.
Why did you reduce it to copper?
No, my lord, copper and tin combination, my lord. That
It
will
becomes
become
bronze, is it?
brass.
Oh.
And my lord, the copper and tin, my lord, become bronze. That is how, my lord, the
In a
combination.
scientific report ಯಾವ್ದಿದೆ ಅದಕ್ಕೆ?
Lord, we will place it on.
No, ಇನ್ನೂ ಪ್ಲೇಸಿಂಗ್ ಇಲ್ವೇ ಇಲ್ಲ.
This is, my lord, today.
ಆಮೇಲೆ ಹೇಳಿ, you come on merits, yes.
This is the only.
ನಿಮ್ಮ ಮೆರಿಟ್ಸ್ ಏನು?
My lord, now merits, my lord, this is a, my lord.
Anyway, I have granted an entry order, you come on merits, yes. 409, 420 is an allegation.
Oh, 409.
Yes, sir.
Your lordship granted interim order solely on the basis of this NIT report.
I know, yes, I'm aware.
Even, my lord, the allegation is that, my lord, the quality of the work. That is, my lord, available for passing off. The very contract says, my lord, the annexure, my lord, document number 3 at page 25. There is a passing off of work, my lord. All works executed by the contractor will be to the entire satisfaction of the engineer in charge.
1 minute. Who gave you that certification? Nirmiti Kendra.
No, Nirmiti Kendra will give, my lord, after completion of the work. As of now, my lord, the Nirmiti Kendra says, my lord, redo it.
So it is an admitted fact that you have not used bronze.
Lord, that I may have to, my lord.
No, it's on record.
On
NITK report.
NITK report
says copper and zinc.
But my lord.
Zinc ಏನದು?
Zinc.
Copper and zinc.
Copper and zinc, my lord, that amounts to, my lord, the brass. The mixture amounts.
Copper and zinc amounts to brass. Who thinks?
Mixture, combination.
ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
Brass. That brass, my lord. But what we want is bronze.
Brass and bronze ಒಂದೇನಾ?
Brass, my lord, copper and tin, my lord.
ಅಲ್ಲ, brass and bronze ಒಂದೇನಾ?
There is a difference.
ಇಲ್ಲ.
Lord, we will, my lord, get instruction.
No instructions.
Lordship may pass over, my lord.
No,
take
pass.
Please, my lord. Then, my lord.
Public money is looted in the name of construction of a sculpture or a statue using shoddy material, making shoddy shoddy statutes.
Oh, my lord.
When we were used to put bronze, why did you choose something else?
My lord, I'll take.
When it is bronze, you better well do it with bronze. 1,83 lakhs is what is to be paid to you. That is public money, sir.
My lord, according to petitioner, my lord, what exactly? I'll take instruction, my lord.
No, everything is here on record. You need not take instructions. NITK report is there. It is copper and zinc. According to you, that turns into brass.
That is what, my lord, just now, my lord,
You will answer.
made some research. But, my lord, here two
Such
things.
people who play with public money should not be spared. ಉಳ್ಳಿಕ್ಕಿದು ಮಾರ್ದಾಗ ಬಿದ್ದೋಗ್ಲಿಲ್ಲ.
That is the reason why, my lord, it was.
ಅದೇ ಬಿದ್ದೋಗಕ್ ಮುಂಚೆ ಇದು ತಗ್ಸಿದ್ದಾರೆ.
That's
Because of the ಕಳಪೆ work.
The issue was not that, my lord, this, because of the load, my lord, of the.
Sir,
Totally.
what is the height of the statue?
35 feet.
35 feet. You think brass and zinc will hold 35 feet? You ought to have done it with bronze. There is a particular purpose in saying that it should be done with bronze. ಪರಶುರಾಮ್ ಸ್ಟ್ಯಾಚ್ಯೂ ಮಾಡಿ ನೀವು ಬ್ರಾಂಜ್ ಅಲ್ಲಿ ಏನೋ ಮಾಡ್ಬಿಟ್ರೆ?
Lordship may pass over, my lord.
This is criminal offense.
2.5 crores spent on inauguration of that.
Inauguration on the project, my lord. There is a difference, my lord.
ನಿರ್ಮಿತಿ ಕೇಂದ್ರ ಅವ್ರು ಮಾಡಿದ್ದ?
My lord, it is a park consisting of a theater, my lord, then a studio, my lord, then a photo gallery.
ಅದೆಲ್ಲ ಏನ್ ಮೆಟೀರಿಯಲ್ ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲ, ಅದೆಲ್ಲ ನಾವು ಮಾಡಿದ್ದಲ್ಲ, ಬೇರೆಯವರು ಮಾಡಿದ್ದಾರೆ.
ನೀವು ಓನ್ಲಿ ಪರಶುರಾಮ್ ಸ್ಟ್ಯಾಚ್ಯೂ ಮಾತ್ರ.
Parashurama statue is concerned with the petitioner. The other projects were ready, my lord. Therefore, they have decided to inaugurate it. This is one of the part of the that entire theme, my lord.
Absolutely.
It's a theme park.
Absolutely.
So the only for that reason, my lord, inauguration was conducted.
Anything else?
And they, Lord, I'll take
no instructions. I'm passing the order now.
Then, my lord, the lordship may kindly see.
ಅದಕ್ಕೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ
Page
come on merits ಅಂತ
25,
ಹೇಳಿದ್ನ.
there is an arbitration clause also.
Yes. Where is that?
Lord, 25. Any dispute which may arise during the currency of the contract is to be settled mutually. The decision of the Udupi
Page, sir.
My lord, 25.
Per 25. All right.
Page 25. Passing of work and, my lord, arbitration again.
All right. ಆಮೇಲೆ
May I read, my lord, the passing of work? I read only one.
ಪಾಸಿಂಗ್ ಆಫ್ ವರ್ಕ್ಸ್ ಅದ್ರ ಮೇಲೆ ಇದೆ.
ಹೌದು. Any work rejected by the engineer in charge will be dismantled, demolished, and
redone by the contractor at his own cost.
At his own cost, for which no compensation will be paid. All works.
Then you return the entire money that you have received.
By the engineer.
You return the entire money that you have received till now. ಎಷ್ಟು ಬಂದಿದೆ ಈಗ 65 ಲಕ್ಷನ 70 ಲಕ್ಷನ?
1,20,20,000.
1,20,20,000 ಬಂದುಂಟಾ? ಸರಿ.
But I'll complete the project, my lord, within the time and then let them examine, my lord, there ends the matter.
Why did you take 1,20,00,000 lakhs?
Lord, it was
For zinc and copper and zinc?
advance payment, my lord, for
Copper and zinc.
Lord, it was advance payment, my lord, to carry out work. It is a huge investment. Petitioner is only a small artist, my lord, who does the design, my lord, and also this statue.
ಇದೆಲ್ಲ ನಿರ್ಮಿತಿ ಕೇಂದ್ರ ಅವ್ರಿಗೆ ಗೊತ್ತಲ್ವಾ?
ಗೊತ್ತಿದೆ, ಅವ್ರೆ ನಮಗೆ ಕಾಂಟ್ರಾಕ್ಟ್ ಮಾಡಿಕೊಟ್ಟು.
ಅವರೇ ಕೊಟ್ಟಿರ್ತಾರೆ.
That is the contract signed. Kindly see
ಅಲ್ಲ,
page
ಆಮೇಲೆ
55.
ಈ ನೀವು ಸ್ಟ್ಯಾಚ್ಯೂ ಎರೆಕ್ಟ್ ಮಾಡಿದ್ರಲ್ಲ, ಅವಾಗ ಯಾರು ಇನ್ಸ್ಪೆಕ್ಟ್ ಮಾಡಿದ್ರು? ನಿರ್ಮಿತಿ ಕೇಂದ್ರ ಇನ್ಸ್ಪೆಕ್ಟೆಡ್?
They have, my lord, that they have
DC inspected. All right. DC inspected and gave yes, it is in order. ಅದು ನೋಡಕ್ಕೆ ಚೆನ್ನಾಗಿರುತ್ತಲ್ಲ ಅದಕ್ಕೆ.
ಅಲ್ಲ, that was, my lord, with the condition inauguration ಆದ್ಮೇಲೆ ಅದನ್ನ ರೀಡು ಮಾಡಬೇಕು ಅನ್ನೋ ಕಂಡೀಷನ್ ಮೇಲೆ that
Inauguration urgency.
inauguration, my lord, it was a theme park. They wanted to inaugurate the park. ಇದು ಅರ್ಧ ಆಗಿರೋದು ಸರಿ ಕಾಣಲ್ಲ ಅಂತ ಹೇಳಿ they, my lord, completed the work. Now, my lord, it is removed, my lord, and being redone.
Redone with what?
My lord, the whatever, my lord, they suggested now, as per the new plan which they approved, being done, my lord. But in the meantime, they have seized it, and therefore it is with the custody of the police.
ಈಗ ಬ್ರಾನ್ಸ್ ಅಲ್ಲೇ ಮಾಡಿ, right from the beginning. Nothing of what you have done will remain. You have to erect the statue right from its feet till the head in bronze, because you have received 1,20,00,000 of public money.
Yes.
If you are doing it in bronze with periodical inspection, we will spare you.
Please, my lord.
Yes, sir.
Because
Yeah, investigate. Bronze
no, that is one aspect, my lord. We need to see the role of the other people involved in allowing these kind of things to, because public money, as you have,
ನಿರ್ಮಿತಿ ಕೇಂದ್ರ.
the lordship may see that the affidavit filed by them, that itself shows something else.
May I make a few submissions?
ಹೇಳಿ.
My lord, since you have passed interim order based on this NITK report, my lord, my version regarding NITK report, my lord, regarding the question of reliability and genuineness of this report. What is the purpose of
NITK report itself is not genuine, is what you're saying?
Exactly.
All right, we'll see.
And one more thing is, it's not only relating to this statute, it's also about the illegal transfer of amount from Nirmiti Kendra to the account of petitioner. How did they?
1,20,00,000.
Yeah, means before giving any work order, before giving any quotation, on what basis did they transfer the amount? And one more thing I would like to bring to note.
When was the work order issued, sir? Quotation ಇದೆಯಲ್ಲ ಇಲ್ಲ, 6/12/2022, subsequent quotation 12/12/22.
I have misled this quote, my lord. Now I am giving the original quotation, the original.
6/12/20 quotation ಎಲ್ಲಿದೆ ಅರುಣ್ ಶ್ಯಾಮ್ sir?
They misled by saying annexure number 7 of their version as work order. That is not work order, my lord.
ಯಾವುದು? page 29.
Annexure number 7.
ಸದರಿ ಸ್ಥಳದಲ್ಲಿ ಭಯದ ವಾತಾವರಣದ ಕಾರಣ ಸೂಕ್ತ ಪೊಲೀಸ್ ಬಂದೋಬಸ್ತ್ ಅದ?
The work order, serial number 9.
Document number 3, my lord.
Of the version na ಅಥವಾ petition?
In their version, annexure number 7.
No, that is what document number 3.
No, annexure number 7. In our copy, they have given
ನಿರ್ಮಿತಿ ಕೇಂದ್ರಸ್ page ಹೇಳಿ.
This contract was signed on, my lord, 15/12/2022.
Page number 178 of their version.
One ನಿಮಿಷ ಅರುಣ್ ಶ್ಯಾಮ್. Official memorandum ಏನಿದು?
This is saying regarding sanction of amount. This is the order of sanctioning of amount.
1,34,00,000.
Howdy. This is not a work order. This is
That's
just
not a work order, it's all
this is
right.
the order, but work order has to be given
ರೂಪಾಯಿಗಳು
by them.
ಮಾತ್ರ ಮೊದಲ ಕಂತಾಗಿ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಹಾಗೂ ಅಧ್ಯಕ್ಷರು ಜಿಲ್ಲಾ ನಿರ್ಮಿತಿ ಕೇಂದ್ರ ಜಿಲ್ಲಾ ಉಡುಪಿ ಕೆಳಕಂಡ ಷರತ್ತುಗಳಿಗೆ ಒಳಪಟ್ಟು ಬಿಡುಗಡೆ ಮಾಡಲು ಮಂಜೂರಾತಿ ನೀಡಲಾಗಿದೆ.
But work order has to be given by Nirmiti Kendra.
ಅದು all right. ಬಿಡುಗಡೆ ಮಾಡಿದ್ದಾರೆ. ವರ್ಕ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
Work order.
That is page 22 ನಾ?
22, my lord.
That is 21/11/2019.
This is 15.
3 ವರ್ಷ ಆದ್ಮೇಲೆ ವರ್ಕ್ ಆರ್ಡರ್
15/12/2020.
No, this is 21/11/2019.
My lord, on 15/12/2022, they gave work order.
3 years after the release of the amount?
No, after 2 months.
Come to this Annexure 7, sir. It is dated 21/11/2019.
Yes.
3 ವರ್ಷ ಆದ್ಮೇಲೆ ವರ್ಕ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರಾ?
And before giving this work order, before giving quotation, they have transferred the amount.
This annexure, my lord, 7.
Kindly
just
see
to
this,
give, my lord, release of
Wait.
release of amount to the Nirmiti Kendra. From the
Amount to
tourism
Nirmiti for
department.
what purpose?
For the purpose of theme park.
Statue only.
Theme park, Abhiruddhi. To
Theme
overall.
park. 1 ಕೋಟಿ ಮೊದಲನೇ ಕಂತಾಗಿ 3 ವರ್ಷ ಆದ್ಮೇಲೆ who gave you this work order? Nirmiti Kendra, is it?
Yes.
Nirmiti Kendra gave this the work order.
His quotation is also on 6/12/2022.
Quotation is 612. Where is that? Where is that quotation? Give it. Madam Athori. You have not produced the quotation, na? Quotation produce madilla.
Illa produce ಮಾಡಿ.
6/12/22. 1,83 lakhs.
Now, before this itself, they have sanctioned the amount.
No, ಇದಾದ್ಮೇಲೆ sanction ಆಗಿದೆ.
ಇಲ್ಲ. I'm having a statement of petitioner here. Bank statement of petitioner.
ಅದು ತಗೊಂಡಿದ್ದೀರಾ? Okay.
ನಾನು ತಗೊಂಡಿದ್ದೆ. It was having.
6/12/22.
Yes.
ಯಾವತ್ತು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ?
On 21/10/2022.
15?
21/10/2022. Just before 2 months. In page number 2, it is there. 21/10/2022. First, they have transferred 21,87,500.
Intermittent transfers. And that they're
Further.
So what?
Further, not only that
My
transaction.
lord, after 4G exemption was granted by the government, my lord, wide annexure.
That is contention of before work order issuance.
For work order, they have granted.
That's all.
And not only about that. Once the amount is sanctioned.
How dispute is between whom for arbitration?
My lord, between the Nirmiti Kendra and the petitioner. The contract is between Nirmiti Kendra. Nirmiti Kendra is, my lord, society registered under Societies Registration Act. My lord, there, the engineers has to, my lord, decide, and they have to, my lord, give, my lord, pass off. Lord, my instruction is, my lord, brass, copper, and my lord, zinc is used to become, my lord, bronze.
To become bronze?
Yes, my lord. To get the bronze, they use brass, copper, and zinc.
Yes.
And that has been used, my lord, is my respectful submission. Lord, now there is a judgment, my lord, of this honorable court, where if the work is substandard, Lord, or the service is substandard, Lord, my lord Amit Gar, your lordships.
Lord, it's not
But,
about that transfer.
Wait, sir.
420 cannot be attracted. Para 17.
This is my judgment.
Yes.
Yes, sir.
Mask.
This is mask, sir. N95 mask.
Although substandard work was the allegation.
Substandard supply of mask.
Supply mask.
ಅದು ಹಾಕೊಂಡ ಮೇಲೆ ಕೋವಿಡ್ ಬಂದಿತ್ತು ಒಂದು ಸ್ವಲ್ಪ ಜನಕ್ಕೆ.
My lord, relying on, my lord, Sushil Sethi.
Yes, sir. So substandard work idre does not attract.
Assuming, my lord, if it is a substandard work, my lord. 420 is not. My lord, what happens is, my lord, this is politically motivated.
What is politically motivated?
He is a political office bearer, my lord, where he is the complainant. Yes, my lord. He filed a PIL recently, my lord, against the same issue that got dismissed. And my lord, when the Nirmiti Kendra permitted me to continue the work, they put, my lord, mud on the road so that nobody can travel to the theme park.
So he is from the opposite party, yeah?
Yes, my lord.
Wait,
Just
sir.
one, sir.
Wait. ಕೊಡಿ ಅದು ಕಾಪಿ ಒಂದು ಕೊಟ್ಟಿರಿ.
We will give it.
Just one submission.
Yes, sir.
In page number 5 of the same statement, my lord. What work do they have to transfer the amount to the account of project director of Udupi Nirmiti Kendra? What right do they have to transfer the amount to the account of project director?
That is personal account?
Yes.
Where is that?
In page number 5 of your statement, he is a project manager, my lord.
What's his name?
Sachin. On 10th.
Lord, we don't have copy, my lord. Let him
I'm giving-
ಇದೆಯಾ ಅಂತ ನೋಡೋಣ ತಾಳಿ ಏನು ವಿಚ್ ಪೇಜ್ ಸರ್?
Page number 5,
The pages are according to page number
5. Last page.
3 of 5, 4 of 5, 5 of 5.
Dated 10 February 2023, my lord.
10 to 23. Sachin.
He is project manager. What, and my lord, for
What is amount transferred?
1 lakh, my lord.
1 lakh.
Yeah, 1,27,000. And again, on 16 to 2023, it is 1 lakh. So on what basis did they transfer the amount? Was it a bribe or was it a gift? And my lord, here, project director, my lord, he was
Project director Nirmiti.
yes, project of Urmiti.
Sachin is not a project director.
Project manager is project manager.
All right.
Project director was handling this account, and for this very reason, my lord, for this
All right.
malicious
There
act,
may be problem with, he is an artist.
yes,
That is what he says.
but that artist, how can he bribe?
Whoever, don't use bribe.
Then can we consider it as this as
Bribe.
gift?
Alleged.
Alleged bribe. Okay, alleged bribe. Alleged bribe or alleged gift, whatever it may be. On what basis did they transfer this amount? And for this malicious act, my lord, project director is suspended.
Sham sir.
Please.
Bronze will complete.
Yes, my lord, we'll complete.
We'll see.
We'll complete, my lord. In a stipulated time, my lord. Now, since, my lord, it has been seized and, my lord, they didn't allow us to go there.
That's
And there is a
tentative-
direction from the police not to work.
Tentative opinion. We'll see what
But
orders to pass.
These material, my lord, since it is not a bronze, question of using the same thing does not arise anymore now.
We'll see.
But
But
my lord, they can't do any
dismantling-
business now because their GST account is already suspended by Commercial Tax Commissioner because they did not pay proper GST and also they did GST fraud by showing that they have paid GST to the government, my lord. So they can't conduct any more business again. On suo motu basis, this GST account is suspended. How can they conduct any business?
That, my lord, GST authorities will take care, my lord, not, my lord, for, my lord, this is the problem, my lord.
But
Now this
they
is a, my
pay-
lord, tender, my lord, and my lord, there is a contract. My lord, if a public person claims to be a public spirited person, who is, my lord, a office bearer of a political party, my lord, who is a rival political party, my lord, and the MLA, my lord, and the
You are the
earlier-
MLA na?
earlier MLA, my lord, belonging to, my lord, the other political party, and now the
Other andre idyao political party.
defeated political party person, my lord, goes to the studio of the petitioner and, my lord, ask the police to seize. In his presence, it was seized. This is how, my lord, politically motivated. Now the entire, my lord, idea is to stall this project and, my lord, so thereby, my lord, earn a bad name. So this was done during the earlier government. Now the entire theme is this, my lord, to tarnish the image and reputation of the MLA as well as the earlier minister and government.
But what they are claiming is, my
The,
lord,
the very presence, I have produced along with the photograph, the defeated MLA of the constituency. He goes to the spot and, my lord, he direct the police to seize. He belongs to the ruling party, my lord, his office bearer. And in his presence, police seizes, my lord. Their photographs are there. This is how, my lord, it is politically. Kindly see, my lord, my IA, my lord, dated 1982, my lord, the photographs, which clearly shows
Oh, the
the-
last time
how
ತೋರಿಸಿದ್ರಲ್ಲ?
the defeated candidate ಹೋಗಿ seize ಮಾಡಿಸಿದ್ದು, and they put, my lord, mud on the road so that I can't go to the project.
Next 21 year.
ನಿರ್ಮಿತಿ ಕೇಂದ್ರದಲ್ಲಿ ಆಫೀಸರ್ಸ್ ಯಾರು ಪ್ರಾಜೆಕ್ಟ್ ಡೈರೆಕ್ಟರ್ ಅಂತ ಇರ್ತಾರ? ಪ್ರಾಜೆಕ್ಟ್ ಆಫೀಸರ್.
Project director, the contract base ಅಲ್ಲಿ ಇರ್ತಾರೆ. It's a ನಿರ್ಮಿತಿ ಕೇಂದ್ರ registered body under.
That I know, yes.
And government ಇಲ್ಲಿ they misunderstood. Government DPR ಮಾಡಿದ್ರು. Detailed project report. Based on that, the government issued the detailed project report. And thereafter, based on that report, ಒಂದೊಂದು ಏರಿಯಾಕ್ಕೆ ಅಂತ ಒಂದು ಅಮೌಂಟ್ ಫಿಕ್ಸ್ ಮಾಡಿರ್ತಾರೆ. Thereafter, the government has not paid the amount. Here, question comes, had the government paid the amount here? They're saying that cheating the person between two persons. He is not the person who paid the money. And we utilize our administrative fund.
The public money.
It's not public fund. It's not public fund.
What fund is?
Administrative money ಅಂದ್ರೆ government ಈಗ ಇಲ್ಲಿ
ಎಲ್ಲಿಂದ ಬರುತ್ತೆ ಅದು?
ಸೊಸೈಟಿ
ಸೊಸೈಟಿಗೆ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ?
ಸೊಸೈಟಿ ನಾವು ಬೇರೆ ಬೇರೆ ವರ್ಕ್ ಮಾಡಿದ್ರಲ್ಲಿ 5% ಅನ್ನ ನಾವು
ಕಮಿಷನ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಚಾರ್ಜಸ್.
ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಚಾರ್ಜ್ ಎತ್ಕೊಡ್ತೇವೆ. They are executing the work.
This PAL was dismissed by
body,
DA
yes.
on the same cause of action.
And for.
And he suppressed, my lord,
employees
throughout
salary
that he is
and
a office bearer of a political party.
ಸೇಮ್ ಕಂಪ್ಲೇಂಟ್
ಹೌದು.
ಹೌದು.
ನೀವು ಪೇ ಎಲ್ಲೂ ಹಾಕಿದ್ರಾ?
ಎಲ್ಲ ಆಗ್ತಾರೆ ಅವರು.
Which,
And he suppressed
not
that
on
he is
same
office
cause of
bearer of
action.
a political party.
It is not regarding same cause of action.
And,
It is
it was
regarding
dismissed
another
without
fraud
notice, my lord,
which had
otherwise
taken
it would have
place in
brought
the
to-
same Parashurama theme park. That is regarding inauguration. How the inauguration was done. On what basis did they use the funds was allocated for inauguration?
Anyway, this is dismissed.
Of course.
Without notice, it was dismissed, my lord, but he
Without
suppressed
notice.
the fact that, my lord, he belongs to a political party.
All right, we'll see.
Just
My lord,
because I'm
this is
belonging
how,
to
my lord,
political
they want to
party, my
stall
lord,
the project.
I am not
That is the
being-
only thing. Lord, there are two other proceedings, my lord. One is already stated, my lord, by the coordinate bench. Your lordship observed in the order. That
yeah, they are-
CAD inquiry has been ordered.
Also stayed.
That has been stayed.
What is that?
CAD inquiry on the same issue, my lord.
ಅದೇ ಟ್ಯಾಗ್ ಆಗಿದೆ ಇದಕ್ಕೆ?
ಇಲ್ಲ, tag ಆಗಿಲ್ಲ.
GM ಅದು?
GML ಇದೆ.
ಹಾ, ಸರಿ.
A stay has been granted, my lord.
Right.
There is one more, my lord, inquiry commission appointed, the Justice Nagmohan Das Commission.
That also I've
They
I've
issued-
observed everything in the order.
Observed, my lord. But only thing is,
What
my
has
lord,
happened before the committee, just Nagmohan?
nothing has happened, my lord.
Actually,
Only-
Justice Nagmohan Das committee doesn't have anything to do with this one. Because Justice Nagmohan Das.
Release of funds ಮಾತ್ರ ಅದಿರೋದು.
ಇಲ್ಲ. It is not, this complete construction of Parashurama statue is done by not PWD department or other department. It is done by tourism department. So Justice Nagmohan Das committee is considered. only with
PWD and
respect-
BBMP.
Yes, PWD department, Commercial
Great.
Commodity, that one,
Will
not
consider.
this one.
They issued notice.
Heard reserved. You commence later if the
last-
order is.
Yes, my lord. Last portion of the order in the interim order, my lord, is missing, my lord. It is not typed actually. Lord, your lordship, after passing the order of interim order, dictated, my lord, 2 lines, my lord. That is not part of the.
I've deleted that. They're permitting you to continue the work.
No, the submission was that, my lord, permit me to continue the work. Lordships observed that if anything, my lord, then the
We'll see. Heard
contractor
reserved.
is held responsible. He cannot be blamed, my lord. The officers
see.
will be.
Heard reserved.
But synopsis, my lord.
ಕೊಡಿ. ನಿಮ್ದು ಏನಾರು ಇದ್ರೆ ಕೊಡಿ.
Lord, may I place the photographs, my lord, how it was looking and.
I can't extract the photographs, sir. Synopsis ಸಾಕು.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಈ ತರ, Lord, the difference is this, my lord. Angle change ಆಗಿದೆ. ಈ ಕೊಡಲಿ weight ಗೆ ಅದು ತಡಿತಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಈ ಕಡೆಗೆ ಮಾಡಿಲ್ಲ.
In Parshuram of your own vision, is it?
Lord, only, my lord, on the basis of history, my lord.
All right.
So the leg have been
This was
told, my
the-
lord, it's a fiber. The
May I
leg.
place it on record, my lord?
ಏನ್ ಬೇಕಾದ್ರೆ ಕೊಡಿ ಸರ್.
Please.
Yes. Yes. Heard reserved. Next. Heard so and so. Interim order subsisting shall continue till disposal of the petition. Great.
Objection of Nirmiti Kendra, my lord, your lordship may.
Yeah. You. Yes, sir.
11.
Objection of the Nirmiti Kendra, my lord, mayor, they said that it is a bronze based on NIT report. Your lordship may observe something on that.
Eight. ಅದೇನಾರು ನಾಳೆ ತಗೊಂತೀನಿ ಅದು. 10 ನಾಳೆ ತಗೊಂತೀನಿ. I'll take it tomorrow. Please. I left the file at home. Please, reading it, yes.
11 minutes.
Recalling of witnesses. We'll allow it. What is the age of the POCSO, na?
Please, my lord.
Age of the victim, madam?
5 years, my lord.
Seriously?
Please, my lord.
Now what is the age of the victim?
No more, lord. She is no more, my lord.
No more.
No.
What happened? 302 ಇದೆಯಾ?
32 ಇದೆ, my lord.
302 ಇದೆಯಾ?
11 application.
ಯಾಕೆ 17 ಇಂದ ಮುಗ್ದಿಲ್ಲ ಈ ಕ್ರೈಮ್?
Then when in custody, my lord,
No, whatever it is, in a case of rape, POCSO, murder, if you take 8 years to complete the crime, where will they stop?
Correct.
These things should be done fast, sir.
but the law says that it has to be done within 1 year.
So what? 7 years ಆಗಿದೆ. Special CC 412 of 2017.
Yes.
We are in 2024. And all are heinous offense. The allegation is rape of a 5-year-old girl and murder. ಇದ್ರಲ್ಲಿ ನೀವು ಕಂಪ್ಲೀಟ್ ಮಾಡಲಿಲ್ಲ ಇನ್ಯಾವ್ದ್ರಲ್ಲಿ ಮಾಡ್ತೀರಾ?
The stage is already arguments, my lordship. They have filed, they
Three
approached the
times
court
recall
now.
application. Many times recall applications also seems to be.
How many times did you file recalling applications earlier? Why did you not examine them? Law should not be misused like this to keep recalling the witnesses. ಯಾವ್ಯಾವ witness ಹೇಳಿದಿರಾ ಈಗ ಹೇಳಿ?
8, 9, 19, 23, 25, 26, 32.
ಅಲ್ಲ ಇಲ್ಲಿ ಪ್ರೇಯರ್ ಇರೋದು ನಾನು ನೋಡ್ತಾ ಇದ್ದೀನಿ ಅದು. ಈಗ ಏನ್ ಕಾರಣ ಏನು?
They are all the material witnesses.
ಈಗ CW8 is PW6.
Please,
Have you not examined PW6 earlier? ಒಂದ್ ಸರ್ತಿನೂ ಆಗಿಲ್ವಾ? ನೆಕ್ಸ್ಟ್ ಯಾರ್ಯಾರ್ದು ಒಂದ್ ಸರ್ತಿನೂ ಆಗಿಲ್ಲ, ಯಾರ್ದು ಫರ್ದರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹೇಳಿ?
ಎಲ್ಲಾರ್ದು ಯಾವ್ದು ಫರ್ದರ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿಲ್ಲ. ಎಕ್ಸಾಮಿನೇಷನ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿಲ್ಲ
ಯಾರ್ದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿಲ್ಲ? ವೈ?
That time my lord, advocate of the petitioner, counsel petitioner was not well.
Oh. Now the counsel is well?
Many times the cost was imposed. Cross examination. Your lordship may allow, my lord.
No, see, then tomorrow
Your
it will
lordship may allow, my
be allowed on the ground that they were not permitted to cross examine at all. I will give only one chance and direct the court to conclude the trial within the next 6 months. Or even next 3 months, because it is 7 years old in the case of rape and POCSO. And it's a 5-year-old girl. Idral mugsala ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಮುಗಿಸ್ತೀರಾ ಸರ್?
3 months, my lord, with direction not to seek adjournment.
You are accused number 2. Why are you? He's in custody, is it?
No, my lord.
Then who is accused number 1?
Accused number 1. Mallikarjun.
Again, against whom is the allegation?
Same.
Hello, madam. Allegation. Yes, Jagdish. Who is the accused, sir?
Mallikarjun alias Muga.
How are you involved in this? Accused number 2.
In her house only, the
A1 is Mallikarjun, A2 is Chandana, that is you. Where is your application? Objection ಹಾಕಿದ್ದೀರಾ?
28, sir. Page number 28.
The petitioner, accused number 2, is knocking at the doors of this court, seeking recalling of witnesses. Madam, ಇಲ್ಲಿ ಪ್ರೇಯರ್ಲಿ ಯಾವ ವಿಟ್ನೆಸ್ ಅಂತ ಇದೆ ಅದನ್ನ ನೋಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಮಾಡ್ಬೇಡಿ. Recalling of witnesses so and so. In special case number 412 of 2017, arising out of crime in crime number 245 of 2017, registered for offences punishable under section 376(2)(I), 302 of the IPC and section 468 of the POCSO Act, read with section 75 of the Juvenile Justice Act 2015. The petitioner and accused number 1 get embroiled in a crime for the aforequoted offences on the ground that the accused number 1 had forcibly had, can't say that, forcibly had page 5 alida. And the petitioner had threatened to kill the victim after the said horrendous act on accused by accused number 1. The age of the victim at the point in time of the alleged incident was 5 years. The petitioner and the accused number 1 are charged of the aforesaid offences in crime number 245 of 2017. The police, after investigation, file a charge sheet against these accused, and the concerned court registers special case 412 of 2017. 8 years, close to 8 years have passed by after the registration of the special case after registration of a special C 412 of 2017, and the trial is yet to come to an end on notwithstanding the heinous offense alleged against the accused number 1 or the accused number 2, as the case would be. The reason appears to be repeated applications being filed by the petitioner seeking recall of certain witnesses on the score that they have not been cross-examined, or they are required for further cross-examination. Two such applications had been allowed in the past, imposing certain costs. This is the opportunity was not availed of on the score that the advocate who was conducting the trial was not well on the said date. The third application is filed by the before the concerned court by the present petitioner accused number 2, seeking recalling of the aforesaid witnesses. The application comes to be rejected on the score that it was only a ruse, ruse to drag the proceedings. It is this order that has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that the witnesses that are now sought to be recalled is for cross-examination and not for further cross-examination, as they have not been cross-examined at all. She would submit that it cannot be, the offense may be heinous, but it cannot be a case where there is no cross-examination of the witnesses at all. He would seek grant of one opportunity to cross-examine the witnesses on the date fixed by the concerned court and would not by the concerned court. The learned additional SPP would learned HCGP would refute the submissions to contend that the trial is being dragged on one pretext or the other throughout, and in the offense, the offense being heinous and the facts being horrendous, the trial is required to be concluded expeditiously owing to the folly of the counsel who had represented the accused in the trial, who did not cross-examine on the dates fixed for such cross-examination. I have given my source. The aforementioned narrated facts are not in dispute, as they are all a matter of record. The petitioner is accused number 2, who is said to have threatened the victim threatened to kill the victim after the incident that has happened by the hands of accused number 1. Therefore, accused number 1 and 2 are charged of the offenses punishable and so and so. The facts are horrendous, the offenses are heinous. The petitioner, the accused, filed 2 applications before the concerned court and 2 applications for seeking recall of witnesses and did not avail of the opportunity. In the normal circumstance, repeated applications would not be entertained, as it would become an abuse of the process of the law. But in the fact circumstance that the petitioner has not cross-examined the witnesses at all, as would reveal from the records, I deem it appropriate to grant one opportunity to the petitioner, and the cross-examination of those witnesses shall be completed on the dates on which they are fixed by the concerned court. It is made with a rider that the petitioner shall not seek any adjournment for further cross-examination of any of the witnesses, and no other application of the kind that is now presented before this court shall be entertained by the concerned court. The offense, as observed here and above, the offenses of the year 2017, the offenses of rape and the ingredients of POCSO, as also POCSO and murder, as the child with whom the accused number 1 had forced sex dies. In such cases, if the trial is not completed within the time that is prescribed under the statutes,
1 year.
i.e. the POCSO Act, 1 year, it would 1 year, it would become travesty. Therefore, I deem it appropriate to direct the concerned court to conclude the trial within 3 months from the date of receipt of the, within 3 months after the cross-examination of the witnesses. How many witnesses are there?
9 witnesses.
9. The cross-examination of the witnesses shall happen on a day-to-day basis, i.e. 9 days from the date of its commencement, and no adjournment shall be granted to the counsel for the accused to for cross-examination. If in the event the complainant, the accused would not avail of the opportunity, it is open to the court to proceed further in the trial. This is the last straw, STRAW, of opportunity granted to the petitioner. Is ordered accordingly.
12,
The petitioner speech.
immoral traffic.
3, 4, 5 of the.
ITP A1 and A2.
Nothing immaterial has been seized, my lord. And
What is seized?
cash of is 2,000 and swiping machine.
ಇದು ಸ್ಪಾನಾ ಅಥವಾ ಹೋಟೆಲ್?
Sparmans.
What did you see?
My lordship, in the victim has have stated, my lord,
ಏನಂತ?
they are forced to
Forced to what? Sumne, don't dub the victims also as doing that work. ಎಲ್ಲಿ ಇದು?
Indranagar, Bangalore.
immoral traffic.
161, huh? Where are the statements?
Sir.
But your 1 and 2, sir, difficult.
Owner and the manager.
Hmm?
Owner and the manager.
Of course, yes. They are the ones to be alleged.
And this is suo motu complaint, my lord.
Maybe.
My lords, can you look into the merger if 15+2 is complied with
15.2 is not mandatory.
of the ITP Act? my lord.
Not mandatory. RAH Seguran, Supreme Court, 2017 8 ACs. Not mandatory. Went from this court, which had held it to be mandatory, Supreme Court has reversed it. Huh? The owner and manager, adu gottu. But what did you find there? Nothing. 15,000 rupees cash swiping machine ಎಲ್ಲ ಕಡೆ ಇರುತ್ತೆ.
2,000 rupees.
2,000 rupees. ಆಯ್ತು, ಅದು ಎಲ್ಲ ಕಡೆ ಇಂಪ್ಯೂಟ್. ಅದು ಬಿಟ್ಟು ಬೇರೆ ಏನು ಸೀಸ್ ಮಾಡಿದೀರಾ ನೋಡಿ. If there is any other seizure, tell me.
Tomorrow, my lord.
List tomorrow in the fresh matters list.
Please.
Because you have been searching every spa. Only if you find something, definitely you tell. Otherwise, you can't dub every spa as hubs of prostitution. And thereby declaring those people who do that massage as prostitutes. Not correct. Unless you find something, yes. No problem. ಈ technical argument ಬಿಡಿ, 15.2, 13.2 ಇವೆಲ್ಲ ಇಲ್ಲ. Yes.
Please.
13,
My lord.
326.
Senior is little busy. Pass over.
No grounds. Difficult. Passed over to next Tuesday. Passed over by 1 week. List after 4 weeks, entry order subsisting shall continue. Vacating stack idira.
No, my lord, settlement talks are still going on, my lord. For the
Still going
respondent
on.
number 2 in this case.
All right, council, both the councils in unison would submit that the talks of settlement are afoot, AFOT. Therefore, lest this matter after 4 weeks, entry order subsisting shall continue to the next date of hearing. Next.
15,
Arilva. No representation, list after 2 weeks.
My lord, serial number 15, I appear for the.
ಏನ್ ಮತ್ತೆ?
My lord, he is for the
Huh?
R2 in the serial number 15, my lord.
15 ಅಲ್ಲ ಟಾಕ್ಸ್ ಆಗ್ತಿರೋದು.
Please, my lord.
ನೀವು 14 ಗೆ ಹೇಳ್ಬಿಟ್ರೆ
I appear for 14, my lord.
ಮೇಡಮ್ 14 ಗೆ entry order entry order subsisting shall continue till the next list after 4 weeks. interim order subsisting will continue to the next date of hearing. 15 ಅಲ್ಲಿ ಅದೇನು ಹೇಳಿದೆ foot ಅದಕ್ಕೆ ಹಾಕಿ. Yes.
Much problem.
ಅದ್ರಲ್ಲಿ interim order ಇದೆಯಾ ನೋಡಿ. ಇಲ್ಲಲ್ಲ? ಇದ್ರೆ continue. Yes. All right. Next. Post immediately after service of notice upon the second respondent, interim order subsisting shall continue to the next date of hearing.
Lordship, interim order is only for 5 and 6, 4 and 5, my lord. There is no allegation of.
No.
Your lordship,
No, sir. Let the complainant come.
This property belongs to the petitioners, my lord. Therefore, I request before this court.
Already agide order. We'll consider after appearance. Let them appear. Yes.
Date maybe.
Post in admission ಅಂತ ಮಾಡಿ. Post in admission. Post immediately in admission after the receipt of the notice. So on. Yes. ಇದು MMDR ನಾಳೆ.
Forest Act.
Forest Act ಇದು.
They use the forest to make road.
ಅಲ್ಲ.
ಅದೇ ಮೈನಿಂಗ್ ಮಾಡಕ್ಕೋಸ್ಕರನೇ ಫಾರೆಸ್ಟ್ ಅಲ್ಲಿ ರೋಡ್ ಮಾಡ್ಕೊಂಡು ಹೋಗಿ ಮೈನಿಂಗ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಫಾರೆಸ್ಟ್ ನೋದಲ್ಲಿ.
Yes sir.
But kindly go through the page number.
ಬಿಟ್ಬಿಡಿ road na.
Kindly go through page number 40 minutes.
I will go through anything. Now if you have made roads in forest, leave it.
No, Malaship, the land belongs to revenue only.
Revenue na? It does not belong to you anyway.
No.
Does it belong to you?
No, not like that.
Then, yes.
Because kindly go to page number 41, Malaship.
File your objection.
Gramasthar upayogakagi.
Learned additional SPP seeks 2 weeks time to file statement of objections. List after 2 weeks. Next.
18.
List after 2 weeks. Interim order subsisting shall continue. ಯಾವ್ದಿದು?
Settlement
ಆಗಿದೆಯಾ?
Complaint, my lords, he had received the site and got registered, my lords.
ಎಲ್ಲಿದೆ ಸರ್?
This matter, my lord, I may oppose their settlement.
ಹೌದಾ?
Yes, because BDA land.
BDA land.
He is the complainant, my lords, he made the allegation. Now, my lords, he registered the sale.
ನೀವಿಬ್ರು BDA land ನ ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರ?
ಅಲ್ಲ. My lords, the complainant, the accused number 1.
Accused and complainant settle a land does not belong to them.
No, my lords. The land belongs to the accused number 1. My lords, the complainant, my lords.
Merits ಮೇಲೆ ತೀರ್ಮಾನ ಮಾಡ್ಬಿಡಿ. List after 2 weeks. Interim order subsisting will continue.
The interim order was granted because investigation was not done for 2 years.
2 ಅಲ್ಲ, even 5 years.
Therefore, my lord, I made a submission last time. DCP has passed an order now. Now, department inquiry has been initiated against the persons who are responsible for it.
Correct.
So therefore, my lord, the investigation may continue.
ಆಯ್ತು, let the investigation continue.
Now the complaint itself, my lords,
Wait, yes.
The reason, my lord, file also been.
ಯಾರ್ದೋ land ನ ನೀವ್ ಹೆಂಗ್ ಸೆಟಲ್ ಮಾಡಿ?
No, my lords, it's not the Yardo land. My lords, the land belongs to the accused number 1, my lords.
Give the investigation papers. ಎಲ್ಲಿದೆ?
No investigation was done. That is the last time, my lord,
He's
department inquiry initiate ಮಾಡಿದ್ದೇನೆ.
I gave that last time. I had given that.
That is, my lords, inquiry with respect to they have not conducted the investigation.
We'll see. List the matter on next Wednesday in the fresh matters list.
Other copy.
ಕೊಡಿ. ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎಂಕ್ವೈರಿ ಕೊಡಿ. ಅದನ್ನ ಸುಮ್ನೆ ಪೇಪರ್ ಟೈಗರ್ ಅಲ್ಲ.
ಇಲ್ಲ.
It should result in completion of proceedings and appropriate penalty being imposed. Yes.
Lordship may observe that also in this.
That is why next Wednesday in the fresh matters list. Next. MMDR ಯಾವತ್ತಿಗೆ ಹಾಕಿದೀವಿ? 19. Yes, Rajan.
Interim order, my lords.
Interim order will extend. ನಾನು ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ extend ಮಾಡಿ.
Complainant has filed a PCR before the trial court, my lord. Trial court dismissed this complainant on the ground that, my lord, he has not followed the guidelines issued in Priyanka Srivastava case, my lord. I have produced all the documents. I filed affidavit. Before filing complaint, I approached the police also.
Where is the order, sir? Impugned order ಅಲ್ಲಿ. Page.
Sorry. Page 24, my lord. 25, my lord.
25. ಎಲ್ಲಿದೆ ಅಫಿಡವಿಟ್ ಇಲ್ಲ ಅಂತ ಡಿಸ್ಮಿಸ್ ಮಾಡಿರೋದು?
Kindly 27, my lord. Page 27 page. Next page. 8 para.
Where is the averment in the complaint?
I have stated.
ನಿಮ್ಮ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ?
Complaint is at page, my lord, 10 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಸರ್.
10. ಎಲ್ಲಿದೆ ಅವರ್
ಪ್ಯಾರಾ 5 ಅಲ್ಲಿ ಇದೆ ಸರ್. ಪ್ಯಾರಾ 5, 4 ಅಲ್ಲೂ ಇದೆ.
ಖಾಸಗಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಹೆಚ್ಚಿನ ಚಿಕಿತ್ಸೆ
4 ಅಲ್ಲೂ ಇದೆ. ಆಮೇಲೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ವಿ. ಐ ಮಾರ್ಕ್ಡ್ ಆಲ್ ದಟ್.
ಫಸ್ಟ್ 154(1) ಕಂಪ್ಲೈನ್ಸ್ ಎಲ್ಲಿದೆ?
ಪ್ಯಾರಾದಲ್ಲಿ ಹೇಳಿದೀವಿ ಸರ್.
ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲಿದೆ?
ಪ್ರೊಡ್ಯೂಸ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
ಹಿಂಗಂದ್ರೆ ಪೇಜ್ ಹೇಳಿ ಸರ್.
ಅಲ್ಲ ಸಪರೇಟ್ ಫೈಲ್ ಮಾಡಿ. ಪೇಜ್ ನಂಬರ್
ಪೇಜ್
10 ಮೇಲೆ 10.
ಪೇಜ್ 10.
ಹೌದು ಸರ್. ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಮಾರ್ಕು ಆಗಿದೆ. ಎವಿಡೆನ್ಸ್
ಇದೇನ್ CC ಅಂತಿದೆ, ಯಾಕಿದು 287/21? ವಿಚ್ ಇಸ್ ದಟ್?
ಅದು ಬೇರೆ ಕೇಸಲ್ಲಿ ಇದಾಗಿತ್ತು ಅಂತ ಆಗಿದೆ.
ಬೇರೆ ಯಾವ ಕೇಸಲ್ಲಿ? This is dated 20th September 2000, July 2014.
ಪ್ಲೀಸ್ ಮಾಡಿ.
ಅವತ್ತು ಕೊಟ್ರ ಕಂಪ್ಲೇಂಟ್?
ಇಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದು ನಾವು 30/12/2021.
ಎಲ್ಲಿದೆ ಅದು? Where is that?
ಮತ್ತೆ
This is 29/7/2014 sir.
ಅಲ್ಲ ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ ಸರ್. ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್.
ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲ. 154(1) your complaint is rejected.
Kindly see page 11. 23/9/2019. 23/8/2019 ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟು.
23/8/2019.
ಪೇಜ್ 11 ಬಾಟಮ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ ಸರ್.
23/8/2019. ಇದು 154(1).
ಹೌದು ಸರ್.
154(3) ಅಲ್ಲಿ?
3 ಅನ್ನೋದು ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ
ಎಲ್ಲಿದೆ?
ಪೊಲೀಸ್ ಮಹಾನಿರೀಕ್ಷಕ ಪೇಜ್ 12.
ಯಾವತ್ತು?
12. ಅದನ್ನು ಕೂಡ
10/2/2021. ಇದೆರಡು CC 287/21 ಅಂತಿದೆ, ಯಾಕೆ?
ಯಾವ್ದು ಬೇರೆ ಕೇಸಿಂದ ಇದ್ ಮಾಡಿದ್ದಾರೆ.
ಬೇರೆ ಈ ಕೇಸ್ ಕೊಟ್ಟಿದ್ದಲ್ಲ
ಈ
ಕಂಪ್ಲೇಂಟ್.
ಕೇಸ್ ಅಲ್ಲ, ಇದ್ರಲ್ಲೇ ಮಾರ್ಕ್ ಆಗಿರೋದು. ಸ್ವಾಮಿ. ಅಲ್ಲ ಇದ್ರಲ್ಲೇ ಮಾರ್ಕ್ ಆಗಿರೋದು.
ಮಾರ್ಕ್ ಆದ್ಮೇಲೆ ಯಾಕೆ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು?
ಅವ್ರು ಆರ್ಡರ್ ಅದು ಫಾಲೋ ಮಾಡಿಲ್ಲ.
CC ಆದ್ಮೇಲೆ ಯಾಕೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು ಕಂಪ್ಲೇಂಟ್ ನ?
ಅದನ್ನೇ ನಾನು ದಟ್ಸ್ ವೈ ಐ ಬ್ರಾಟ್ ದಿಸ್ ಕೋರ್ಟ್. ಇನ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೂ ಹೇಳಿದೀನಿ, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
Why you did not produce all this at the time of filing the petition?
ಫೈಲಿಂಗ್ ಅದು ಅವಾಗ್ಲೇ ಕೊಟ್ಟಿರೋದು ಸ್ವಾಮಿ.
ಆಮೇಲೆ ಯಾಕೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಿ?
ಇದು 37/21 PCR ರಿಜಿಸ್ಟರ್ ಆಯ್ತು. ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದು 30/12/23. ರೆಫರ್ ಆಗಿಲ್ಲ. 156 ಮ್ಯಾಟರ್ ವಾಸ್ ನಾಟ್ ರೆಫರ್ಡ್ ಫಾರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್. ಓವರ್ ಆಲ್ ಸೋನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಐ ಪ್ರೊಡ್ಯೂಸ್ ಆಲ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ along with affidavit also. They have recorded sworn statement, oral sworn statement also, evidence.
ಅಲ್ಲಿ ಏನು ಹೇಳ್ದೆ ಎಲ್ಲ ಇಲ್ಲಿ ಹೇಳಿರ್ತೀರ ಅದಕ್ಕೆ?
ಇಲ್ಲ ಮಾರ್ಕ್ ಆಗಿದೆ ಎಲ್ಲ.
The petitioner is before this court calling in question an order dated 30th December 2023 by which the concerned court rejects the private complaint in PCR 287/2021 on this score that it is not in compliance with the judgment of the apex court in the case of Priyanka Srivatsava versus so and so 2015 6 ACC page 287, as also the judgment subsequently so and so. The petitioner is the complainant. Initially seeks to register a complaint before the jurisdictional police on ಯಾವತ್ತದು ರಜೆ? On
30 ಫೈಲ್ ಮಾಡಿದ್ದು 37/20.
ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲಿ ಕೊಟ್ರಿ?
ಕಂಪ್ಲೇಂಟ್
on 23/8/2019. No action was taken and therefore the petitioner invoked subsection 3 of section 154 in registering a crime to the registering a complaint to the higher authority. This was also not taken note of. Therefore, the petitioner then invoked the court of the learned magistrate under section 200 of the CRPC by registering a private complaint. The sworn statement is recorded and the proceedings are taken forward for 2 years. And then comes the impugned order rejecting the complaint on the ground that it is not in compliance with Priyanka Srivatsava. Apart from the fact that there is no sanction to prosecute the accused as obtaining under section 197 of the CRPC. The petitioner, this order has driven the petitioner to this court in the subject petition. The learned counsel for the petitioner submits that all the documents necessary for it to be in compliance with Priyanka Srivatsava was placed before the concerned court. The concerned court has ignored all that and has rejected the complaint after taking the complaint to an advanced stage. where the matter was pending for close to 2 years. The learned counsel would seek to refer to the documents so produced before the concerned court, all of which would lead to an unmistakable inference that the order of the concerned court is erroneous and is required to be, and the complaint is required to be restored on the file of the concerned magistrate for it to be taken to its logical conclusion. For the aforesaid logical conclusion, in the light of the fact that the complaint was in complete compliance with Priyanka Srivatsava then and the judgment of the apex court in the case of Babu Venkatesh versus State of Karnataka, reported in 2022, SEC Online SC, page 200. In that, for the aforesaid reasons, the following order. Allowed, the order quashed, the petition, the complaint is restored to file of so-and-so court and Tharpade. Restored to file of so-and-so court, the concerned court shall regulate its procedure. Yes. Next.
20.
ಇದೆಲ್ಲ MMDR ನಾಳೆ 19th ಅಲ್ಲ 19th
20 and 21.
20 21 ಎರಡು 19th. Yes. Yes. Next.
22.
489 ಸುಯೋಗ್ ಅಕ್ವಿಟ್ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಎಲ್ಲರೂ
Acquit ಆಗಿದ್ದಾರೆ.
ಕೊಡಿ. ಯಾರ್ಯಾರು ಅಕ್ವಿಟ್ ಆಗಿದ್ದಾರೆ? ಪೇಜ್ ನಂಬರ್, ಪ್ಯಾರಾಗ್ರಾಫ್.
Accused number 1, my lords, 1, 2, 3, 5
One?
and 6. 1, 2, 3, 5 and 6, my lords. have
1
been
minute.
acquitted. A4, my lord, during the
1, 2, 3, 5 and 6. Your A4 is it?
A7,
A4
my lords, he expired, my lord. Pendency trial. Pending.
ಉಳಿದಿರೋದು ನೀವು ಒಬ್ರೇನಾ?
Page number 69 and 70, my lords, paragraph 76 and 77.
ಒಂದು ನಿಮಿಷ. 69 70.
Paragraph 76 and 77.
Sir, that is operative portion. Reasoning ಹೇಳಿ.
ಅಲ್ಲ, reasoning ಅಲ್ಲೇ ಕೊಟ್ಟು. 76 and 77.
Yes, the petitioner, accused number 7, is knocking at the doors of this court, claiming parity with the order of acquittal passed in favor of accused number 1, 2, 3, 5 and 6. The heard words. The petitioner, along with others, gets embroiled in a crime of circulation of fake notes of 200 and 500 rupees, and therefore becomes an offence punishable under 489C, D, E and 420 read with 120B of the IPC. The police conduct investigation and file a charge sheet, and the matter was tried before the concerned court. At the relevant point in time, the petitioner, accused number 7, was not available for trial. The concerned court split the case against the petitioner in CC 654 of 2011 and sought to try the petitioner separately. The concerned court, i.e. the Court of Session, in terms of its order dated 26/5/2015, acquits accused number 1 to 3, accused number 5 and 6. Accused number 4 died during the trial. The lone accused who is left in the proceeding is accused number 7, the present petitioner. The case against the petitioner is now sought to be tried as SC 40 of 2024. It is therefore he is before this court in the subject petition. The learned counsel appearing for the petitioner would vehemently contend that the reason so rendered to acquit all the other accused would inure to the benefit of the petitioner, and continuance of further trial would become contrary to law. The learned HCGP would, however, refute the submission to contend that the petitioner has escaped trial. To a person who has escaped trial, this court should not show an indulgence, and the petitioner should come out clean like other accused who have come out clean in a full-blown trial. I have given my anxious considerations also. The afore narrated facts are not in dispute. The accused getting embroiled in a crime for circulation of fake notes or counterfeit notes is a matter of record. The other accused 1 to 3, 5 and 6 get acquitted by the order of the Court of Session dated 26th May 2015, the reasons so rendered to acquit the said accused can be gathered from paragraphs 69 to 69 other 76 and 77. The quote marbudi. They read as follows. If the reason so rendered is to acquit the others are perused, it would undoubtedly become applicable to the case of the petitioner as well. The petitioner, though, has escaped trial and was not available at the relevant point in time, permitting further trial against this petitioner in SC 40 of 2024 would who would eventually get acquitted of the offense on the same reason would be a waste of precious judicial time. In that light, notwithstanding the vehement opposition of the learned HCGP, I deem it appropriate to deem it appropriate to quash the proceedings in SC 40 of 2024 on the score that all other accused have been acquitted in the trial for the aforesaid reasons also.
Denomination of 500.
Huh?
Only denomination of 500 rupees. Not
200 and 500 ಅಂತಿದೆ?
To 200 note man.
Oh, sorry. 200 ಮಾತ್ರ. Yes.
23.
Islamic. Is there a secure number 1, my lord? Yes, my lord, section 417, 424,
It is sought for IO papers in this. Lordship sought for IO papers in this case.
last date of hearing.
The petitioner, my lord, being the brother and mother of the respondent number 2, they have forged his signatures and then
Yes.
the property belongs to him has been given to.
Well, let the complainant come.
My lord, kindly press page number 35, please, ma'am.
We know.
It's affidavit and the compliance affidavit. The trial court of
Priyanka Srivastava.
No, not.
ಮತ್ತೆ?
Third to obtain the signature of the respondent. The not
Signature of respondent. ಯಾವುದಕ್ಕೆ?
number 2, my lord.
ಯಾವ signature?
Page number 35, respondent number 2 signature. It was not a without signature. Further complaints affidavit also.
We'll see, get the records.
Please.
The learned HCGP is directed, the registry is directed to secure the records in PCR 4394 of 2023 by the next date of hearing. List on Wednesday in the fresh matters list.
Till then,
No, sir.
please.
ಸ್ವಲ್ಪ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು.
Please,
ರೆಕಾರ್ಡ್ಸ್
please.
ಬಂದ್ರೆ ಏನ್ ಮಾಡ್ತಾರಲ್ಲಿ?
Please.
ಇಂಡೈರೆಕ್ಟ್ ಎಂಟ್ರಿ ಮಾಡೋದಲ್ಲ.
Please.
24.
I'll try to get some authority, my lord. I'll try to get,
Any amount of trial will not, let the trial begin.
I'll try to get some authority.
I told you,
Before
madam,
it
you
is
can't show the prime minister so light. I will not
To me, it
entertain
is
such
66A,
things.
my lord. According to me, it is 66A of IT Act.
According to you,
I'll try.
I will write the judgment, you take it.
Yes, my lord. Before that, anyway, I'll try to get some authority.
List the matter on 27th for further hearing. It is made clear pendency of this petition will not come in the way of the trial before the concerned court.
So there is no stay.
ಅದಕ್ಕೆ
There's no-
ಪೆಂಡೆನ್ಸಿನಲ್ಲಿ ತೋರಿಸಬಾರ್ದು ಅಂತ ಅಷ್ಟೇ. Yes, next.
25.
List on 20th.
7A of the PC Act.
20th. Yes.
Accused number 1.
ಏನು?
FIR against accused number 1 has been quashed by your lordship.
Washed against accused number 1.
1.
ಯಾವುದು?
Petitioner is driver of the accused number 1.
I told you Supreme Court ಏನಾಗಿದೆ ನೋಡ್ಕೊಂಬನ್ನಿ ಅಂತ ಕೊಡಿ.
Order passed by your lordship has been upheld by this.
Upheld? Yes. ನೋಡ್ ಎಲ್ಲಿ ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು? ನೋಟಿಸ್ ಆಗಿಲ್ವಾ? Learned counsel B.B. Patil is directed to accept notice for the first respondent, emergent notice to the second respondent. Que accused number 1, this court had quashed the proceedings in criminal petition 4807 of 2022. You are the driver, 2020. You have received the money.
ನನಗೆ ಹೇಳಿದ್ರು ಅಂತ ನಾನು
ಅಲ್ಲ ಅದು ಪೆಂಡಿಂಗ್ ಇರೋದೇ ಅದು. ಇಟ್ ವಿಲ್ ನಾಟ್ ಬಿ ಅಪ್ಲಿಕಬಲ್ ಟು ಯು.
ನಾನು ರಿಸೀವ್ ಮಾಡಿಲ್ಲ, ನನ್ನ ಜೊತೆಗೆ ಬಂದು ಕೊಟ್ರು ಅಂತ.
Whatever, yes, so and so. Accused number one question. The said order was tossed by the complainant before the apex court in SLP 15276 of 2023, which comes to be rejected on 30th April 2024. In that light, till the next date of hearing, there shall be an interim order of stay of further proceedings qua the petitioner. List the matter on 27th. Yes.
26.
But both matter concerning 3 and 7 of Essential Commodities Act, my lord. Essential Commodities
Both
Act.
ways.
My lord, in first matter, accused number 4, my lord, allegation is that at page para 20, my lord. 1, 2, 3 were seized at the spot, my lord. Accused number 4.
The FSL consider.
The FSL has been.
Yes, report in.
My lord, that could be at page number 45, my lord. Hence, it can't be determined that the seized bag belongs to Anna Bhagya Yojana or meant for public distribution.
1 minute, 1 minute. Hence, it cannot be determined that the seized bag belong to Anna Bhagya Yojana or meant for PDS. Yes. दाने दाने पे लिखा है PDS का नाम. ಆಗಲ್ಲ ಇವೆಲ್ಲ. Yes. The offense in the case at hand are the ones punishable under section 3 and 7 of the Essential Commodities Act. The rice that was seized from the hands of the petitioners was subjected to forensics by the FSL. The FSL report reads as follows, page 45. The report is clear that the rice that is seized cannot be determined to be belonging to Anna Bhagya Yojana or meant for PDS. In that light, the justification of the petitioner that it was procured in the open market stands to reason. Therefore, there shall be an interim order of stay there. Interim order of stay of all proceedings in CC 5592 of 2023 till the next date of hearing. List the matter on 26th.
My lord, in second matter, my lord, it has been subjected to FSL, but the report has not been annexed to charge sheet, my lord.
Early the report.
Report has
Same order ಮಾಡಿ.
second matter.
ಅದು ಎರಡು ಕನೆಕ್ಟೆಡ್ ಮಾಡಿರಿ. ರಿಪೋರ್ಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ. Yes. ಜಗದೀಶ್ ಅವರೇ, FSL ಕಳಿಸ್ತಿರಲ್ಲ, ಅಕ್ಕಿ ಮೇಲೆ ಬರ್ದಿರುತ್ತಾ PDS ಅಂತ?
Only reason, my lord, the FSL is being sent because I believe one of the
Whether it is rice or not ಅಂತ.
coordinate bench judgment, my lord, says that it has to be determined by FSL.
ಇಲ್ಲ, how do you determine rice that it belongs to PDS or otherwise? ಅದ್ರ ಮೇಲೆ ಏನಿರುತ್ತೆ?
Only if they have a sample, take that sample and compare the sample with that is the only way it has to.
ಅದಕ್ಕೆ ದಾನೆ ಪೇ ಏನಾರು ಇದೆಯಾ ಅಂತ ಹೇಳಿ. PDS ka ನಾವು. Okay, anyway, yes.
87.
The acid case, my lords. Petitioner 1 and 2 are withdrawn. As against petitioner 3, my lords have directed the respondent 2 to verify what are the allegations.
Yes, sir.
My lord,
3 ಮೇಲೆ ಏನಿಲ್ವಲ್ಲ. 1 and 2 horrendous, he has withdrawn.
3 ಮೇಲೆ ಅವರು ಇನ್ಸ್ಟಿಗೇಟ್ ಮಾಡಿದ್ದಾರೆ, ಸ್ಪಾಟ್ ಅಲ್ಲಿ ಇದ್ರು ಇನ್ಸ್ಟಿಗೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಇದೆ.
ಇಲ್ಲ, ಮೇಲ್ಗಡೆ ಫ್ಲೋರ್ ಅಲ್ಲಿ ಇದ್ರು.
ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್, ಅದ್ರಲ್ಲಿ ನಾವು ಎಲ್ಲೂ ಕೊಟ್ಟಿಲ್ಲ, ಅದೆಲ್ಲೂ ಹೇಳಿಲ್ಲ.
ಆಯ್ತು, ಎನಿವೆ ಇನ್ಸ್ಟಿಗೇಷನ್ ಅಷ್ಟೇ ಅಲ್ವಾ?
ಮೈ ಲಾರ್ಡ್, ಅವ್ರಿಗೆ ಯಾವಾಗ್ಲೂ
ಇನ್ಸ್ಟಿಗೇಷನ್ ಅಷ್ಟೇ ತಾನೆ?
ಇನ್ಸ್ಟಿಗೇಷನ್ ಇದೆ.
ಇಲ್ಲಿ ಹಿಯರ್ ಇಟ್, ಬಟ್ ಇಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ.
ಇಲ್ಲ,
ಕೊಟ್ಟಿಲ್ವಾ?
82 my lord.
That purpose only it was adjourned, my lords, for today.
All right.
My lord, page number 82.
82, yes.
ರಿಕ್ವಿಷನ್ ಮಾಡಿದ್ರು ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆ.
ಏನ್ ರಿಕ್ವಿಸಿಷನ್?
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಟೈಮ್ ಅಲ್ಲೇ 307 ಇದಾಗಿತ್ತು ಮೈ ಲಾರ್ಡ್.
ಅವ್ರ ಮೇಲೆ 1 and 2 ಮೇಲೆ ಬಿಟ್ಬಿಡಿ. He has withdrawn those petitions, trial will go on.
All the accused ಮೇಲೆ.
Instigation we will not permit 307 to go on. Yes.
Also ಪಂಚನಾಮದಲ್ಲಿ 2
accused the third petitioner herein is only instigation. In that light, the offense or ingredients of the offense under section 307 inter alia cannot be laid against the accused number 3, the petitioner number 3. Therefore, the further proceedings qua accused number 3 shall remain stayed. It is made clear that the petitioners 1 and 2, accused 1 and 2 have withdrawn the petitions. The trial against those 2 accused shall not be stalled on the score that the present petition is pending before consideration qua accused number 3 before this court. Yes. Ilda idin ತೋರಿಸ್ಬಿಟ್ಟಲ್ಲಿ ಟ್ರಯಲ್ ನಡೆಯಲ್ಲ. Yes, next.
Please, my lords. 28 and 28.1 are the accused number 1 and 2 in this matter.
Starts, my lord. I need some time to file my objection.
ಏನಿದು?
My lords, the allegation is that under section 207, I have disobeyed the summons issued to me. The complaint itself said that summons was not served on me. When it was not even served on me, how can I disobey it?
All right. Served, not served on you ಅಂತ ಹೇಳಿದೆ.
Complaint says, my lords.
Complaint.
Para 6 of the complaint, page 29.
Page?
29. Para 6, page 29, the second half, my lords. A copy of the summons is enclosed as annexure E.
1 minute, sir. Where does it say that it was not served?
A copy
the summons were returned undelivered with postal endorsement left. The accused did not attend the proceedings, so and so. How do you interpret the postal endorsement left?
I have changed my address. So subsequently, Shoka notice is issued to me. That Shoka notice
That changed address was, they were aware of it?
They were not aware of it. They were made subsequently aware of it. By way of, when the Shoka notice was issued to me, I replied that Shoka notice came to be forwarded to my new address. When I forwarded and I filed a reply to that.
You are aware of it, then if you have not heard him.
No, my lords. I was aware.
If they were aware of it.
May I make one submission? This copy is served to me yesterday. I've got instructions now. The officer has come to give instructions.
All right.
Your Lordship, the matter is posted on 19/9 before the trial court.
All right.
I'll file my objections on 18th.
I'll take
by
it on
18th.
I'll take it on 18th in the fresh matters.
I'll file it.
At the request of learned DSGI Shanti Bhushan, who seeks time to file statement of objections, list the matter on 18th in the fresh matters list.
Okay.
Next.
29.
My lords, my application for number 311 has been rejected.
311. Yeshne application.
My lords, only one. Second application, please. My lords, earlier.
Offense.
Offense 307, please.
We'll allow it. The petitioner is before this court calling in question an order dated 29/7/2024 passed in SC 64 of 2019 by which the application of the petitioner filed under section 311 of the CRPC comes to be rejected. The petitioner heard words. The petitioner, along with other accused, gets embroiled in a crime number 105 of 2018 for the offense punishable under section 307 of the IPC inter 307. The column number 2 only there, madam. All the offenses. 307, so and so of the 307 ilva?
307.
307 of the IPC. The police conduct investigation and file a charge sheet and the matter is pending as SC 64 of 2019. The issue in the list does not relate to the merit of the matter. The petitioner files an application under section 311 of the CRPC seeking recall of the PW1 and PW4 for further cross-examination. This comes to be rejected on the ground that the petitioner has filed the application only as a ruse to drag the proceedings. It is therefore the petitioner is before this court in the subject petition. The learned counsel appearing for the petitioner would submit that if one opportunity is granted, further cross-examination of PW1 and PW4 would be completed on the date fixed by the concerned court. The learned HCGP would, however, refute the submission to contend that the petitioner has been filing repeated applications only to drag the proceedings. I have given my so-and-so. The aforenarrated facts are not in dispute. The issue in the list lies in a narrow compass as to whether the petitioner should be permitted, or whether the application filed by the petitioner under section 311 should be permitted to be, or should be allowed or otherwise. The petitioner cross-examines PW1 and PW4 on a particular date, and the cross-examination was not complete. therefore files an application under section 311 of the CRPC seeking recall of PW1 and PW4 for further cross-examination. This comes to be rejected by the impugned order. The ಏನ್ ಕೇಳಿದ್ರಿ ನೀವು?
PW1 and 4
ಮೊಬೈಲ್ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಯಾರ್ದು?
PW1 and 4 both have communicated to accused number 1 stating that accused number 1 has been falsely implicated in the case.
So and so. The purport of section, the application, the reason for filing the application is narrated in the application. The concerned court ought to have taken note of the same, as also the purport of section 311 of the CRPC. The purport of section 311 of the CRPC need not detain this court for long or delve deep into the matter. The apex court in the case of Varsha Garg versus so-and-so 2022 SSC online SC page 986 has held as follows. The paragraphs in which so in that light, I deem it appropriate to grant one opportunity to the petitioner to further cross-examine the witnesses, i.e. PW1 and PW4, on the date fixed by the concerned court. It is made clear that this would be last straw of opportunity to the petitioner to further cross-examine PW1 and 4, and the applications of the kind that is now projected shall not be entertained by the concerned court. For the aforesaid reasons, the following order. Petition is allowed, quashed. The application filed with the petitioner is allowed. The concerned court shall permit further cross-examination of PW1 and PW4 on the date fixed by it, and it is made clear that the petitioner shall not take any adjournment on the said date and conclude the further cross-examination on the said date itself. The concerned court shall regulate its procedure thereafter. Next.
30.
Appear for the petition. Petition 424.
OV Nigam.
OV Samajad. Other corporation. Yes, sir.
Accused number 4 and 8, the FIRs have been stayed.
Data.
Page number 84.
I want that.
84.
84 number railway.
Not my orders.
And ಇನ್ನೊಂದು ತಮ್ಮ
Sanction ಇಲ್ಲ ಅಂತಾನ.
criminal
Order, I don't have a copy, my lord, that page number 84 is referring to.
ನೀವೇನು are you a government servant?
I am not a government.
Then sanction ಯಾಕ್ಬೇಕು ನಿಮಗೆ?
ನನಗೆ sanction ಅಲ್ಲ.
ಮತ್ತೆ ಯಾವ ಗ್ರೌಂಡ್ ಮೇಲೆ ಇದ್ದೀರಾ ಇಲ್ಲಿ?
If my lords have to kindly see the complaint.
ಇಲ್ಲ ಅದು sanction ಅಲ್ಲ, proprietor of some Anika enterprises.
There is one last word which has been incorporated my name, and except that there is no allegation as against me.
All right, we'll tag this petitions. Tag this petition along with criminal petition 8640 of 2023.
There is one more, my lords. Criminal petition 8225 of 2025. ಅದನ್ನ ತಾವೇ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀರಿ.
ಅದು ಕೊಡಿ, ಇದನ್ನ ಫಾಲೋ ಮಾಡಿರ್ತೀನಿ ಅಷ್ಟೇ ಅದರಲ್ಲಿ ಕೊಡಿ.
ಅದು 8225. ಅದು I am not a
ನಂಬರ್ ಬರ್ಕೊಡಿ, ಅದು ಬರ್ಕೊಡಿ. And petition so and so. The learned counsel for the petitioner submits that there is an interim order operating in the aforesaid cases for it having been granted by the coordinate bench initially. List this matter, tag this petition so and so, list these matters on 25th September.
It has been listed on 28th.
Why?
ಅವೆರಡಕ್ಕೂ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ತಾವು?
28th is Saturday, sir. So ಅದಕ್ಕೆ ಅದು ಬರುತ್ತೆ.
ಡೇಟ್ ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೀರಾ?
List this petition along with those petitions on 25th. ಕೊಡಿ ತಗೊಳ್ಳಿ. In the fresh matters list.
On special order, bail application, 324, 326, 307. The petitioner is in custody for more than 5 months.
Yes, what is the objection, madam?
My lordship, he has, in the FIR, there is an allegation, my lordship.
Allegation ಇದೆ ಅಂತಾನೆ ಮತ್ತೆ ಒಳಗೆ ಹಾಕಿರೋ.
5 ತಿಂಗಳಾಯ್ತು. It's under.
No, you should, in bail matters, you should get ready. It can't be like this. Pass over. I'll take it at 2:30. Be ready in the matter. Records ಕೊಟ್ಬಿಟ್ಟ ತಕ್ಷಣ your duty is absolved ಅಂತಲ್ಲ. Yes. ಬೇಡ ಬೇಡ bail Yes, next.
52.
My lord, I am for the prisoner. Offense under section 406, 417, 419, 420, 465, 467.
ಆಯ್ತು, ತುಂಬಾ ಇದೆ, ಸಾಯಂಕಾಲದವರೆಗೆ ಆಗುತ್ತೆ.
ಹೌದು.
ವಿಷಯ ಹೇಳಿ.
Challenging the order passed by the learned magistrate. At page number 10, your lordship kindly see. The matter was referred to investigating officer. It is against the provision of section 156 subsection 1 CRPC.
Effective investigation and place a report.
First
Should be to the jurisdictional police. What is this, sir?
IO of Bharati Nagar police station anta idu ಮಾಡಿ. It is against section 156.
ಭಾರತೀಯ ನಗರ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್
IO investigating officer.
ಇನ್ ಯಾರಿಗೆ ರೆಫರ್ ಮಾಡ್ಬೇಕಾಗಿದೆ?
Officer in charge of police station.
ಆಯ್ತು, ಅದು we will change the language, don't worry. ಅದ್ರ ಮೇಲೆ ಏನ್ ತೊಂದ್ರೆ?
ಒಂದು. Secondly, Priyanka Srivastava the guideline is not strictly complied.
Not strictly complied, but
yes.
complied.
Partly, your lordship kindly see page number 38, affidavit of the respondent number 2. Respondent signature respondent number 2 is not forthcoming in the affidavit.
ಎಲ್ಲದರಲ್ಲೂ ಅದೇ ತರ ಇದೆ. We want the records.
But the same was identified by the council and sworn before the notary public.
We'll see.
ಏನಾಗುತ್ತೆ ಇದು issue my lord that
No, ಅಲ್ಲಿ ಒರಿಜಿನಲ್ ಹಾಕಿರ್ತಾರೆ, ಅದು
Original
whatever.
ಹಾಕಿರ್ತಾರೆ.
No, ಇಲ್ಲಿ ಗೊತ್ತಿಲ್ಲ.
Certificate copy.
You don't know.
like second set ಇರುತ್ತೆ.
Second set ಅಲ್ಲಿ ಇದು. Second set ಇಲ್ಲ PCR ಅಲ್ಲಿ.
Second set.
ಇದು plaint ಅಲ್ಲ.
We'll see, we'll get it. They'll get the records. ಅದು ಚೇಂಜ್ ಮಾಡೋಣ. ಭಾರತಿ ನಗರ್ ಆಫೀಸರ್ ಇನ್ಚಾರ್ಜ್ ಆಫ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಆಫ್ ಭಾರತಿ ನಗರ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್.
ಇಲ್ಲ compliance of it Priyanka Srivastava not complied because signature dependent.
We'll send it back for compliance.
In fact, my lord, your lordship, this is one more recent Supreme Court judgment.
We'll send it back for compliance.
ಮತ್ತು ಇನ್ನೊಂದು ಏನಂದ್ರೆ ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಸ್ ಪೆಂಡಿಂಗ್ OS.
ಈಗ ಬಂದ್ರಿ ಮ್ಯಾಟರ್ಗೆ. ಎಸ್.
ಪೇಜ್ ನಂಬರ್ 30.
From Priyanka Srivastava.
ಆಮೇಲೆ
ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಪೆಂಡಿಂಗ್ ಮತ್ತೆ ಎಲಿಗೇಷನ್ಸ್ ರಿಗಾರ್ಡಿಂಗ್ ಎಲಿಗೇಷನ್ ಇಸ್ ನಾಟ್ ಫೋರ್ತ್ ಕಮಿಂಗ್ ದ ಅಫಿಡವಿಟ್ ಆಸ್ ಪರ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ ಆಫ್ ಪ್ರಿಯಾಂಕಾ ಶ್ರೀವಾಸ್ತವ. ಯಾಕೆಂದ್ರೆ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ
We'll send it back, sir. We'll send it back for the complaint to be in complete compliance with Priyanka Srivastava. ಅದ್ರ ಮೇಲೆ ಅಕ್ಯೂಸ್ ಗೆ ಸ್ಟೇ ಮಾಡಿ ವಿಕ್ಟಿಮ್ ಇಸ್
ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಸಿವಿಲ್ ಫೋರ್ಜರಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸೈಡ್ ಆಗಬೇಕು.
ದಟ್ ವಿ ವಿಲ್ ಸಿ. ಏನೇನ್ OS ಪೆಂಡಿಂಗ್ ಇದೆ?
OS ನಂಬರ್
ವಾಟ್ ಇಸ್ ದಿ ಅಲಿಗೇಷನ್?
ಪೇಜ್ ನಂಬರ್ 30 ಎಲಿಗೇಷನ್ ಇದೆ, ಕಂಪ್ಲೇಂಟ್ ಪ್ಲೀಡಿಂಗ್ ಮಾಡಿದ್ದಾರೆ, OS ಪೆಂಡಿಂಗ್ ಉಂಟು ಅಂತ.
ವಿಚ್ OS, sir?
OS ನಂಬರ್ 612/2020.
Where is the plaint?
Plaint ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ,
ಮಾಡ್ತೇನೆ.
ಶಾರ್ಟ್ ಡೇಟ್ ಮೆಕ್ಯಾನಿಕ್.
Produce the plaint.
Yes,
because the offense is forgery.
Civil dispute also pending. What has to decide? Civil court and
no, sir. If it's offense of forgery, both can spring. I myself held some acts may become offense under civil law and both criminal law. Adike produce that. Priyanka Srivastava weak ground.
ಅಲ್ಲ ಅಪಿದೆ ಐತಲ್ಲ,
Weak grounds.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಅಪಿದೆ ಐತಿಲ್ಲ.
Weak grounds.
ಮತ್ತೆ ರೆಫರಿಂಗ್
We will now differ with that.
Para 9 my lord.
As I have seen, yes.
ಅಲ್ಲ ಪ್ಯಾರಾ 27 ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಇವನ್ ಎಲಿಗೇಷನ್ಸ್ ಆಲ್ಸೋ ಬೇಕಂತ ಹೇಳ್ತಾರೆ, ಅಪಿದೆ ಐತಲ್ಲಿ.
Produce the plaint. List on 18th in the fresh matters list. The counsel for the petitioner to place on record the copy of the plaint of the OS registered by the complainant, which is said to be on the same cause of action. By the next date. Next.
33.
Vehicle is rejected.
Yes, Sir Ravishankar.
The release of the Maruti car came to be rejected by the.
Yeah, excise offense.
ಇಲ್ಲ 460, 467. There is a
Family dispute, my lord.
Family dispute car excise ಮಾಡಿದ್ದಾರೆ.
There is a FIR is registered. Pursuant to that, PF is filed, car is seized. I filed an application. There are two applicants.
Claimants,
claimants.
Who is the other claimant?
Claimants is the.
Car is in whose name?
In my name. RCI produced, page 25.
Their allegation is they have, by forging the document, they have changed the car from the.
ಏನು ಕಾರ್ ಇದು?
This is
Maruti Baleno.
Baleno.
2016 model, page 25. The trial court rejects on the ground that there is a civil dispute and a suit is pending.
Who is the other claimant?
Claimant is the first wife. I am second wife's daughter.
Second wife's daughter. First wife is claiming the car.
First wife's daughter is claiming the car.
Car. Maruti.
Ibru daughters.
2016 model. You better give it off. It'll be a liability then.
You lost me tag it on.
Litigation.
Listen.
The car will be a liability then litigation. Anyway, claimants irodhen notice ಮಾಡುವ. ಈ ಕಾರ್ ಯಾರೊಟ್ಟಿಗಿದೆ?
It is in the station.
Station ಒಟ್ಟಿಗಿದೆಯಾ? ಅಲ್ಲೇ ಇದೆ. Yes. The one HCGP2 emergent notice returnable by the 26th of September.
They lost me tag it along. Criminal petition.
ಇನ್ನೂ ಒಂದು ಕಾರ್ ಇದೆಯಾ?
ಅಲ್ಲ ಅದು FIR ಕ್ವಾಶನ್ ಹಾಕಿದ್ದೀನಿ ನಾನು.
ಅದು ಹಾಕಿದ್ದೀರಾ?
Criminal petition 9067/2024.
ಟ್ಯಾಗ್ ಬರ್ಕೊಂಡ್ರ ಮೇಡಮ್?
It has been ordered.
Yes.
It has been ordered to be listed on 20th.
20th. This also 20th along with that. Yes.
May I request me in the fresh matters list?
Yes. All right. Yes.
34.
No representation. Pass over. 498. Yes. Next.
35.
Oh, ಇದೇನು ಫ್ರೆಶ್ ಮೆಟಲ್ ಬಂತ? Yes, sir. Release ಮಾಡಿದಾರ ಅದು?
There is a small hitch in this matter. What has happened? He has submitted a bill for rupees. His bill already submitted bills for 1,504 crores.
No, ಅದಲ್ಲ. I have directed some amount to be released on consent.
I'll just explain 1 minute. Out of 1,500 crores, we have already released 967 crores.
All right.
Balance 530 crores only. Even the 967 crores, on undertaking given by him in writing that he will submit these reports, quality control reports. On the undertaking, be part
No, I passed a detailed order.
Please. Detailed order pass, my lord. I am producer the quality control report also. Connection
recalling that order.
Unfortunate, my lord, 2 months, my lord, time was
lot
granted.
of allegations.
Now I will direct release of the entire amount.
Lot of allegations are there. That's why.
Sir, whatever it is, on your accord, I have passed this order. No question of recalling.
I kindly appreciate this fact. They are not submitted the report till today. Kindly appreciate this fact. They are not submitted the report till today. Without quality control certificate, bill cannot be finalized or paid. In spite of the you have paid 967 crores.
Lord, I produced that certificate, my lord, election L and M. They have not disputed in their written statement of objection.
Sir, after hearing you, a detailed order was passed for release of 160 crores as against the amount claimed was 536 crores. That was on consent passed.
May only submission is. On that day, when the Lord was pleased to pass an order, on the ground, they said the quality control certificate are in place. Till today, they have not filed. No certificates are there. Till today, certificates are
What
not
certificate?
filed. Quality control certificates.
Yavada?
Quality control certificates.
Quality control certificates.
Therefore, I can't.
What is the quality control certificate? Already issued ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Illa.
Which is that,
That's
sir?
what I'm.
M, my lord, page number 223.
Page number?
223. Moreover, that quality control certificate has to be issued by them only. They are the agencies. I am not.
ಅಲ್ಲ, quality control certificate issue ಮಾಡೋದು ಯಾರು? Who's to?
Unless he submits the report.
What report?
Quality control reports.
What is this page 223?
That is pertaining to.
Bill number 7.
What is the claim?
Allah. Yes, sir.
That is only.
No, now I will direct release of the entire 536 crores.
Kindly appreciate my humble submission is like this.
This is not correct. This order is passed on
26/6/2020.
May humble submission only this 2 points. Yes. Only I have already released on his undertaking annexure R3 which I have filed. He will give the reports before April.
Quality control certificates ನೀವು ಇಶ್ಯೂ ಮಾಡಬೇಕಾಗಿರೋದು.
ಇಲ್ಲ ಅವರು ಕೊಡಬೇಕು. ನಾವು
ಸರ್ಟಿಫಿಕೇಟ್ ಅವ್ರು ಹೆಂಗ್ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ?
ಅವರು ಕ್ವಾಲಿಟಿ ಕಂಟ್ರೋಲ್ ಮಾಡಬೇಕಲ್ಲ ಅವರು.
ರಿಪೋರ್ಟ್ ಕೊಟ್ರೆ ನೀವು ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ತೀರಾ? Report you already given?
Already we have submitted the bill, my lord. That is the last bill.
That is what answer.
Bill number 7.
That is
the quality
This appears to be something else.
No, I'll tell you.
Because I guess you have not met them. Will pass necessary orders. Yes.
Well, kindly
This is-
appreciate, one more issue is there.
This is not correct. Yes.
One more issue is there. We formed a committee of all chief engineers. They found out lot of defects and irregularities in the work also. It also brought to the notice of the government also.
That's because he's claiming all this.
No. Just before that, in 2019, 2022, 2023, itself, I filed the reports along with this application.
All right.
There also, we have brought to the notice. No, even in spite of the quality control is not there. And defects are noticed by the engineers, defects are noticed by the public.
All right, list this day after tomorrow, we'll pass orders. On the application also, I'll pass orders.
Kindly, this
I'm going to direct release now everything.
No,
This
money,
is not correct. You challenge it, sir.
public exchange of money.
Oh, correct, sir. This is channagide. Contractors have spent all their money, and when it comes to payment, it is public money.
Estimate has been done.
Who has certified that estimate? Your officers, have you initiated criminal proceedings against your officers?
I'm not, Justice Nagmar.
Have you initiated?
No, Justice Nagmar's report.
No, that is nothing. Not a piece of paper has moved in that committee. For namesake, you appointed that committee.
That is also not awaited.
What is awaited? Nothing has happened there to await.
But money is.
ಇದಲ್ಲ ಬೇರೆದ್ರಲ್ಲೂ ಏನ್ ಮಾಡಿಲ್ಲ ಅಲ್ಲಿ.
It's not a small amount. Once money.
Who certified everything, sir? If the work is big, the amount is big.
I understand. Only thing is, without the quality control certificate, we cannot reduce the bill at all. And they are not submitted. I have gone on record. I gone on record.
You're repeating the same submission. I will pass day after tomorrow. I'll pass out. List day after tomorrow at 4 p.m. Next.
Can you appreciate the documents also?
We'll appreciate everything on Thursday.
Huge money
Yes.
is interim.
Huge project, huge money. What can be done? Who has certified everything? Your officers. Please.
Whatever it is,
Whatever it is, Allah. When your officers certify, how can you go back on that?
Correct, but we'll take action against the officers.
What action have you taken?
Money cannot part.
What action have you taken against them?
It's all report.
Criminal cases are registered. Departmental inquiry is initiated. You come with that information. What action have you taken against those officers who have certified this project and directed and permitted release of bills?
The process will be awaiting for the report of Justice Nagmar.
You get, sir. No, that report, Allah. According to you, there are so many shoddy things done. How did you release the amount? Why have you not initiated criminal cases against those officers?
Based on his own letter undertaking that I will submit the report, I have released. Annexure R3 will not kindly appreciate.
We'll do it. I'll go through it and pass orders on Tuesday. We'll direct cases to be registered against all the officers who have bungled in this. Yes, definitely, sir. Definitely.
Because it is a case of issues public.
No, definitely I will do it. Yes.
And the lordship's safe hands.
Safe hands.
Part with the money with the contractor, I cannot.
We'll see. Yes, next.
Interim order.
Interim order subsisting will continue to the next date. List on Thursday. Yes, next.
Respondent, my lord. It's a DV Act.
I know. Deposit is made. You withdraw the deposit?
Yes, my lord.
Next deposit is made?
My lord, 50%, 1 lakh has been made, my lord.
And now what is the arrears?
The arrears is 1 lakh and
Remaining.
1 lakh.
My lord, 50% has been paid.
Next deposit.
My lord, they filed objections. I may be given a copy of it. I haven't received.
All right. They will give you a copy. In exchange, 50,000 you give.
My lord, maybe
Arrears of the maintenance, sir.
Right, my lord.
List the matter. Learned counsel for the respondent to serve set of copy of statement of objections to the petitioner. List on 25th in the fresh matters list. The interim order subsisting shall continue subject to the condition that the petitioner would pay another 50,000 to the wife by the next date of hearing. Yes, next.
37.
Please.
Yeah, predicate offense, sir.
No, this is a PMLA proceeding. This is the predicate offense. I have been convicted.
Convicted.
Please. And that appeal is pending.
All right.
What we are trying to say.
Wait.
What we are trying to say here in this case is that the trial court itself, while passing the predicate offense case, says that I have no role to play. And I was merely a director of the company.
No, you said you are convicted.
So that conviction order has been questioned, Your Honor.
No, that's all right. If you are convicted, where is the question of saying that nothing is against you?
No, that sentencing.
Maybe that may be contradictory, but that's an appeal. How can I stay these proceedings on that? You are convicted.
Please, on the ground that if that gets acquitted, this unnecessarily I will be convicted here.
The acquittal ಆದ್ಮೇಲೆ move ಮಾಡಿ. I'll give you liberty.
But in the meantime, this conviction
Meantime, I
also.
can't help, sir. See, either discharge, quashment, or
And
acquittal.
the concerned persons have been discharged in between. The offending
Let
persons.
the appellate court decide that. I can't help. PMLA cannot be stayed on a convicted predicate offense.
The question is that whether there were proceeds of crime.
That's conviction set aside ಮಾಡಿಸ್ಕೊಳ್ಳಿ ಆಮೇಲೆ ಮಾಡೋಣ. Otherwise answering this whether there is proceeds of crime will be entering into evidence. I will not do that.
Your Lordship, I'm just, after the conviction order, the predicate offense.
I'm not hearing an appeal against the conviction.
I'm not drawing your Lordship
Yes.
also to that. It will be wrong on my part.
Yes.
What I am trying to say is, this proceedings was going on and the trial court has discharged them post the charge being framed also, saying that in view of their acquittal in that case, this case would not be sustainable. Now, if the substantial crux of the persons have all gone out.
Others have been acquitted, so PMLA is closed.
Please.
You have been convicted, so PMLA will not be closed.
No, I'm not questioning. Question is whether, end of the day, whether there was any.
Once you get acquitted, please move the matter.
I cannot say anything more.
How can I enter into this? I'll give you liberty to move the matter. So, this liberty is always available.
Please, I will, I'm with your Lordship at the most, then I may recall some of the witnesses too.
Or that you file an application if you want. If it is rejected, then we'll see.
Yeah, will, sir.
But the learned senior counsel, the Kiran S. Javli appearing for the petitioner. The petitioner calls in question the proceedings instituted under the provisions of the Prevention of Money Laundering Act 2002. The ground on which it is, the ground projected by the learned senior counsel is that it does not amount to proceeds of crime as is necessary under section 3 of the act. The learned senior counsel would further submit that in the predicate offense, while others get discharged, the petitioner is convicted, and the said conviction is challenged before the appellate court in criminal appeal. In criminal appeal, so and so. The apex court in the case of Vijay Madanlal Chowdhury, so and so, reported in 2022 SEC Online SC page 929, extract paragraph 467, has laid down certain postulates in which the offense under the Prevention of Money Laundering Act would get obliterated. Three such instances are whether if the accused would get discharged or the proceedings against the accused get quashed or acquitted by a competent court of law. Neither have happened in the case at hand. Therefore, entering into the evidence at this stage, particularly in the teeth of the conviction of the petitioner in the predicate offense, is not an exercise that this court would undertake at this juncture, leaving open the liberty to move the matter in the event the petitioner would succeed in the appeal and an acquittal order is passed against him. Acquittal, discharge or whatever.
Recalling.
Discharge. The petitioner is at liberty to get this order recalled on the said date.
Some witnesses.
Yeah, witness. That's the application haki alli.
No, Lordship may just.
That's not the
Because the court seems to be.
That's not, you file an application.
Much.
All contentions left open.
Please.
Adu recall beda. Liberty. Next.
38.
Let's kindly pass on.
The last time earlier, Sachin.
Notice has to go to the complainant. Notice and complainant.
Secure instructions. What has become crime 57 of 22, you know?
Subsequent to this incident, allocchuri agide.
I'll say one HCGP 2 emergent notice returnable by 27th. Next.
39.
Petitioner. Third, this petition is filed, my lord. The victim of a scam. They allege that, my lord.
Produce the records, my lord.
Why
complainant? My lord. Last hour, my lord.
Pass over agala. Tomorrow, fresh matters.
Please.
Next. But give the records, let it come to the file.
Yes, I'll place it.
Yes.
Connected matter ಇದೆ.
Yen 7A.
I need to collect a petition copy.
Connected matter.
No, I need to collect a petition copy, my lord. I don't have.
Give it, yes. Counsel for the petitioner is directed to serve set of papers upon the counsel for the respondent, Shri B.B. Patil. Agle agide kottilla copy inno? Copy kottilva? We will vacate the interim order then. Serve the copy right away. Just the matter on 20th.
ಒಂದ್ ಮ್ಯಾಟರ್ ಇದು ಕನೆಕ್ಟ್ ಮಾಡ್ಬೇಕು.
ಅದನ್ನ ಹೇಳಿ ಕಳಿಸಿದಾರ? Yes. Office objections ಏನು? The petitioner has not complied with the office objections after securing an interim order at the hands of this court. Therefore, the office objections be complied with in the next 2 days. In the event of it remaining uncomplied, the interim order would stand automatically vacated. The petitioner to serve set of papers upon the counsel Shri B.B. Patil. Neevu yarige? Neevu yarige?
No, she is for BBM.
BBMP. So to the respondents.
Like.
Yes, list the matter on 20th. Next.
41.
ಇದು ಮಧ್ಯಾಹ್ನ ತಗೊಂತೀನಿ. 7A ನಾ?
Suspension in DA cases.
ಎಲ್ಲಿ ಸರ್ಕ್ಯುಲರ್ ಸಿಗ್ತಾ?
ಎರಡು ಇಂಡಿವಿಜುವಲ್ ಆರ್ಡರ್ಸ್ ಆಫ್ ದಿ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ
ಕೊಡಿ.
Chief Minister also not has signed. One is visible, another is not illegible. I just
ಮತ್ತೆ ಇದನ್ನ ನೋಡ್ಕೊಂಡು ಬರ್ಬೇಕು ತಾನೆ, ನಾವೇ ಹೇಳ್ಬೇಕು ನಿಮ್ಗೆ.
I'm sorry. This is not a general notification, but not.
This is a note sheet, true.
The note sheet, not para 26, your lordship, kindly see.
I have seen this.
Please. The Chief Minister would also sign and the Chief Secretary.
This was when S.V. Rangnath was Chief Secretary.
Please.
Yes. But ನಿಮಗೆ ಹೆಂಗ್ ಅಪ್ಲೈ ಆಗುತ್ತೆ ಇದು?
This is also not 13(1)B.
ಈಗೇನ್ ಸಸ್ಪೆಂಡ್ ಮಾಡ್ತಾ ಇದ್ದಾರಾ?
Suspend.
ಯಾಕೆ?
ಇದೊಂದು maybe somebody wants to come to my position.
ಅಲ್ಲ ಅದು ಅದಕ್ಕೆ ಇರೋದು, ಬೇರೆ ಏನಿಲ್ಲ. What is the allegation against you? ಎಷ್ಟು percentage?
I just not made a synopsis.
ಮಧ್ಯಾಹ್ನ ತಗೊಂತೀನಿ with other cases.
ಇಲ್ಲಿ ಇನ್ನು ನೋಟಿಸ್ ಆಗಿಲ್ಲ.
ಪರವಾಗಿಲ್ಲ, ಮಧ್ಯಾಹ್ನ ತಗೊಂಡು further hearing cases ಜೊತೆ ತಗೊಂಡು.
Please.
52.
7A na?
All disproportionate asset cases, my lords. A batch of it is there today.
No, I'll take these along with that.
My lords, could we make one request? Even Mr. Prasanna also, my lords, on the question of law, my lords, we will make our submission because, my lords, can I just point out one aspect?
Certain facts in certain cases are glaring.
How do, but my lords,
I will not interfere on technicalities at all.
I'm not on technicalities. If my lords would permit us to make our submissions on the question of law, my lords, and then we will give, because we prepared synopsis in each of the cases. We are not going to shy away from giving the synopsis. But for any reason, my lords, if the court feels that on a question of law, if our submission is acceptable, then probably, my lords, the burden becomes much lesser. This is what we felt, my lords.
I'm going to apply the law with the facts.
My lords, we have got the synopsis anyway.
300%, 400%.
My lords, so kindly, when the matter is taken up in the afternoon.
Officers, unless there is something glaring, ಕೆಲವು ಕೇಸಲ್ಲಿ wives income ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Most of the cases, my lords, most of the cases that we find here are cases where they take family members into it, their income not taken. And I will be able to point out, my lords, so far as 13(1)E, which is 13(B), my lords, it's a
one I have dismissed where everything is taken. Even then he projects that there is some problem.
ಇನ್ನು ರಿಲೀಸ್ ಆಗಿಲ್ಲ ಕಾಣಿಸುತ್ತೆ, my lords. ಆಗಿಲ್ಲ ಇನ್ನು. So, my lords,
those are on facts. Law I have not said, because ಅದರಲ್ಲಿ wife's income is totally given up. And he had produced evidence to show that if that is taken, it goes negative.
So, my lords, my only request is, my lords, afternoon, if it's taken up at 2:30, my lords.
I'll take it at 2:30.
Yes, my lords. We will present the question of law also, my lords, and we have.
No, the further hearing matters, anything, I'll take it at 2:30.
2:30.
Yes.
So, my lords, we have 3 matters, my lords. Could I give the serial numbers, because all of them will come at the same time, disproportionate asset.
ಇನ್ನು ಲಿಸ್ಟ್ ಆಗಿಲ್ವಾ ಅದು?
ಅಲ್ಲ, ಇವತ್ತೇ ಇದೆ.
ಇದ್ರೆ ಪರವಾಗಿಲ್ಲ,
ಒಂದು
2:30ಗೆ.
Please.
Yes. Next.
53.
For respondent, special.
This is a matter where we had sought for interim bail on the grounds that the entire process of
There,
arrest.
110 crimes.
Ade. Now, my lords, kindly have my synopsis for a minute, my lords.
Yes,
I will point out what the three illegalities are, my lords. My lords, has a synopsis?
I have.
My lords, there are three crime numbers which are important, my lords. Crime number 467 of 2021, that's the first crime number. Crime number 449 of 2021 and crime number 8, my lords. These are the three crime numbers that are relevant, my lords. Now, in my synopsis, kindly notice the first crime number. My lords, prior to this, whatever the offenses that were there, bails have been granted. So I take 467 of 2021 as the lead case.
All right.
Now, kindly notice in 467, my lords, 4/10/2021, FIR gets registered and all these offenses are offenses punishable with less than 7 years, my lords.
Yes.
Now, on this basis, my lords, please notice serial number 4.
Why interim bail?
Arrest itself is illegal. I will point it out. Just give me a few minutes on this, my lords.
No, but you have not sought for regular bail?
My lords, my regular bail has been dismissed 2 days back, my lords. My regular bail has been dismissed. But if I'm able to demonstrate that this entire arrest is illegal, as done, how Supreme Court has also viewed it, my lords, I will point out, even in Supreme Court, my lords, the matter which went up from the High Court was on a writ petition. My lords, High Court did not entertain it. Supreme Court then says it was wrong. When grounds of arrest has not been given, the arrest
2024.
2024 Moore judgment, ಒಂದು 2023 ಎರಡು 2024 ಆದ್ರೆ ಈ ಸೀಕ್ವೆನ್ಸ್ ಅಲ್ಲಿ ಕೊಡುವಾಗ my lords, please notice, my lords, the last date there in the first page, 30/3/2024, my lords should get CID issues 41A, first page ali, my lords, I'm sorry, first page
33/24.
33/24. Now kindly notice the sixth serial number 28/5, I'm sorry, I want to go. Sixth serial number ali, my lords, in furtherance of this 41A, he goes before the investigating officer. Now, my lords, when you go before an investigating officer in furtherance of 41A, there can't be an arrest. That is exactly what, my lords, we have in Satyendra Kumar Antil.
Yes.
So, my lords, in that I have mentioned Satyendra Kumar Antil versus CBI and others.
No, on a 41A notice, you were arrested?
They arrest me. I go before the investigating officer on 28/5/2024. He arrests me. Now, my lords, first illegality takes place there. Now they arrest me, my lords. Immediately after that, please notice serial number 7, 11/6/2024, I am granted bail in this lead case.
All right.
467 ali bail granted. But my lords, 18/6/2024, I am not released, my lords, from 11th. 18/6/20.
Body warrant.
They take body warrant in crime number 449. Now comes crime number 449.
This 7 days, what were you doing?
Well, I was not released.
Despite granting bail.
Bail was granted, I was not released. Please notice after that, my lords, 18/6/2024. Now, my lords, for the purpose of whether I have executed the necessary bond or not, whatever be the reason, 7 days on 18/6/2024, I am taken under body warrant to section 267, my lords, body warrant by the CID in crime number 449, and this was registered by Ramurthy Nagar Police Station. I am produced before the first ACMM. I am remanded to police custody for 3 days till 21/6/2024. Now, my lords, on 19th, though remand was for 3 days, next day itself they produced me in 1 day's time. 19/6/2024, petitioner was produced before first ACMM in crime number 449 from police custody and remanded to judicial custody. Now, my lords, if at all the police custody period is over, I ought to have been sent back to the lead case, which was 467.
There you had enlarged on bail already.
How do? But, my lords, I'll point out, after that, when it comes to crime number 8, I'm sent back to 467. Please notice this, my lords. Now, 449 ali, they take me in JC. Now, according to me, this is second illegality because, my lords, a person can't be put under custody in 2 cases. That's exactly what, my lords, our coordinate bench in the case of Shashidhara has held, my lords. You can be only in 1 case and you can be taken in body warrant in the other, sent back to the lead case. Now, my lords, they take me in 449. All right. Then, my lords, charge sheet is filed in the lead case, 467. Fine. Then 11/7/2024, I am granted bail. In the second case is 449, I am granted bail. Now, my lords, I am granted bail. I execute the bonds. For this purpose, if my lords would notice, I have prepared the memo with the order sheets. My lords, page 48 may be noticed, my lords. Now, after bail was granted in this and I have executed the bonds, should I not have been released? Kindly notice, my lords, page 42 for a minute. Even the execution of the bond is there. On the left-hand side at page 42, my lords.
You are not released.
Not released on 11/7.
Yes.
Now, what they do after that is, please notice on the next page, 15/7/2024. So from 11th, I've been detained illegally again for 4 days till 15/7/2024. And then I'm produced from JC in crime number 449, where already I had been granted bail. How was I taken to JC? How could I have been produced on 15/7/2024? I'm produced. Then, my lords, 15/7, please notice, my lords. Again, I'm taken in body warrant in
What is crime 8 of 2020?
the third of the crime numbers. That's why I was saying 3 crime numbers, 467, 449, and crime number 8. Now you notice crime number 8, my lords. What they do in crime number 8. So 15/7, the petitioner was taken under body warrant in crime number 8 from crime number 467, registered by so-and-so by CID and produced before the first ACMM, remanded to police custody till 27/2024 for a period of 6 days.
Yes.
So crime number 8 only, they give me to PC for 6 days. Then, my lords, the next date, my lords, I'm sorry, serial number 14 only, next date should be 18/7/2024. My lords, gets it? Serial number 14 only, my lords. 14 only. It has come 18. I'm sorry, my lords. 18/7.
Yes.
18/7. Petitioner deposits the bond amount of 5,000 in crime number 467 before first ACMM. 18/7. Then, my lords, on 27/2024, in that crime number 8, my lords, where I had been taken,
Coca is invoked.
they invoke Coca. And then, my lords, what they do next is 27.
So what's the allegation against you?
My lords, cases of 420, my lords, as I pointed out, my lords, in one large plot, my lords, several survey numbers. And they say I have committed cheating and fraud insofar as the various survey numbers. And it's a case of cheating, breach of trust, and 468 and 471. Now, my lords, ideally in a case of this nature, my lords, it could have been one lead FIR and all 161 statements could have been taken. But anyway, my lords, they register 110 cases against me. 50 cases, I'm out. I've come out on bail. So my lead case becomes 467. 467, I get bail. They take me right into 449. 449, I get bail. Then, my lords, I'm detained 4 days illegally. And then, my lords, in crime number 8, I'm taken into police custody. Now, crime number 8, my lords, after I'm sent back to the lead case of 467, I'm released. I step out of the prison, my lords. They catch me there. And they say in crime number 8 now, we have invoked Coca, we're taking you back inside. Now, my lords, my respectful submission is the 3 illegalities that have taken place is, my lords. The first illegality was 41A, when I go to the police station, you ought not to have arrested me. That's the first illegality.
No, if you don't cooperate with the investigation, they are empowered to arrest.
No, my lords, kindly notice this. It's not a case of not cooperating with the investigation. I am taken in body warrant and I am subjected to...
No, the first initiation is under 41A. When you appeared before the investigating officer, you were arrested.
That's entitlement, my lords. If I have appeared before the investigating officer...
Then you can't be arrested because that cannot amount to non-cooperation. Yes.
Because that's what Supreme Court says. In fact, Supreme Court goes to the extent of saying, my lords, you don't answer a 41A. You don't appear at all. Then they get the power to arrest.
That's what
But if you have gone to the investigating officer...
That is Satyendra Kumar.
Yes, my lords. They use the word entitlement. My lords, I'll just point out that one paragraph.
All right.
Says,
no, accepted.
So, my lords, this was the first illegality. So, after that, 467, when I appeared, they could not have arrested me. So, the arrest gets vitiated at that point of time itself. Now, let's move further, my lords. When I get bail in that, 467, when I get bail, how is it that they could take me in JC in 449?
Now, where are you?
I'm in JC.
In what crime? 8 of 22? 8 of 22. Because Coca is invoked in that.
Coca is invoked.
So you want to travel back now?
No, not back, even forward or back, 3 illegalities. Second, my lord.
So,
Second.
is there illegality in crime 8 of 2022 for you having been taken into
Yes,
custody?
my lords. When I came out and they arrested me, grounds of arrest is not given. And this I'm substantiating.
No, this coca is invoked that is not made known to you.
My lords,
No grounds of arrest.
no grounds of arrest given to me, my lords. Once grounds of arrest is not given, again the Supreme Court says the arrest is illegal. It becomes- ಮೂರಿದೆ, my lords. That, my lords, it starts with.
That is, one is NIA offense 2023,
Ravi-
UAPA offense.
Undu Pankaj Bansal, my lord. That's
Bansal,
2023. That is now considered in his judgment, my lords. Prabir's case. Could I just pass it on? And Prabir's case now has been considered in Arvind Kejriwal's case.
Yes.
So in all the three, my lords, they say if grounds of arrest is not given to an accused at the time of arrest, the arrest is illegal. Everything thereafter is void. Now, my lords, Satyendra Kumar says entitlement. This says grounds of arrest to be given. If it's not given, the whole thing becomes void. And that is the reason, my lords, why we filed this petition as a writ petition or a criminal petition under 482 to point out the illegality in the arrest. So, my lords, the concept of bail comes later, my lords, when there is a legal arrest and then my entitlement or not for bail. But here, my lords.
All right. Yes, Ashok Naik.
My lord, in this case, the only point for consideration is whether he was legally arrested in crime number 8 or not. Need not be considered 467 portion. The mother case is 461. He was taken to under body warrant in this crime number 8 from 467. Then he was given to, I think, police custody for 5 days in 2 installments from 57 to 27. My submission is when he was outside the jail premises, he was arrested in crime number 8. There is nothing wrong, illegal in the arrest of the accused. In
Grounds of arrest.
Ground of arrest, I think you already they have given in writing to the accused himself before remanding the arrest. Because I not filed.
In crime number 8?
Yes, crime number 8. Crime number 8. After kindly, just I could not file a statement of objection with the documents. Yes. Here, and moreover, the ruling is not at all strictly applicable to such type of cases. First arrest, Madi, police custody, of course, that ruling is applicable. This body warrant process is somewhat different. Body warrant, they move application.
So, by body warrants, you can escape the rigor of what is laid down by the apex
that is,
court.
even then it is complied. The Supreme Court, I think Supreme Court, noted in one of the para, very important stage that is on the part of the accused to know his ground of arrest. Of course, I do admit, but here, from where the process started, 1/8/7, the body seeking body warrant application moved before the court. There are clear-cut grounds in the presence of the accused only. It is argued in the open court. It is not technical offense. It is not technical. Or ಕೊಟ್ಟಿದ್ದಾರೆ ಇಲ್ಲೋ ಅನ್ನೋದಷ್ಟೇ ಅಲ್ಲ. ಇಲ್ಲಿ there are several grounds. Then 15/7 consider argument was passed and order was passed.
No, on the merit of the matter, bail is rejected. He says arrest was illegal. So I am hearing that.
Arrest illegal ಮಾಡ್ಲಿಕ್ಕೆ ಏನು
Illegal because grounds of arrest is not given.
First arrest in crime number 8. How it can be challenged? First arrest in crime number 8.
No, you have not given the grounds of arrest.
Grounds of arrest already shown. And moreover,
it's an intimation. I will point out, my lords, what's the difference between intimation and grounds of arrest?
My further. After remanding the police custody, he was interrogated. His four pages statement is there, voluntary statement. What it shows? He was asked several questions. By way of interrogation, he was made to know what are the grounds of arrest. But he has to that kindly. This also will take.
Anyway, we'll see whether it is in tune with Prabir or not.
That's
make it that judgment.
My submission.
Prabir, though, I'll just point out the relevant paragraphs. It becomes easy. My lords, Prabir, they say there's a difference between reason to arrest, which can be intimated, and grounds of arrest. They say, my lords, D.K. Baswali, the whatever safeguards, that is all reasons to arrest and you have complied with it. Grounds of arrest stands on a different footing. Grounds of arrest should be in writing. The relevant paragraphs could I just point out quickly, my lords?
Yes.
My lord, by way of recording his voluntary statement, that is also by way of that also it was brought to notice. It is not a technical offense. The grounds anna one bardu notice ಕೊಡಬೇಕಂತಲ್ಲ. It was well within the knowledge.
Prabir ನೋಡಿದ್ದೀರಾ?
Yes, pardon?
Prabir judgment ನೋಡಿದ್ದೀರಾ Supreme Court?
ಹೌದು ಸ್ವಾಮಿ, I have gone to that. ಅಲ್ಲಿ ಯಾವುದು ಸ್ಪಿರಿಟ್ ಪೇಜ್ ನಂಬರ್ 30 ಏನ್ ಹೇಳ್ತಿದ್ದಾರೆ ಅಂದ್ರೆ ಅದು ಬಾಡಿ ವಾರೆಂಟ್ ಕೇಸ್ ಅಲ್ಲ. That is only I make difference. ಬಟ್ ಇಲ್ಲಿ ಪ್ರಬೀರ್ ಇದರಲ್ಲಿ ಇಂಪಾರ್ಟೆಂಟ್ ರೈಟ್, ಸ್ಯಾಕ್ರೋಸೆಂಟ್ ರೈಟ್, ಫಂಡಮೆಂಟ್ ರೈಟ್ ಎಲ್ಲ ಹೇಳ್ತಾರೆ. ಆದ್ರೆ ಇಟ್ ಮಸ್ಟ್ ಬಿ ನೋನ್ ಟು ಬಟ್ ಟು ಡಿಫೆಂಡ್ ಹಿಸ್ ಕೇಸ್. To defend it, that is the intention spirit.
Give the other judgment.
My lords, please just note Prabir for the paragraphs, my lords. I'll just point out from Prabir from the paragraphs which are relevant. Kindly notice paragraph 3, my lords.
In synopsis and judgment is paragraph ಬರ್ಕೊಡಿ.
Really because if I had shown, my lords, the grounds of arrest, how they have shown it as different from intimation.
Paragraph, sir.
Paragraph 3 ali UAPA, offense was UAPA, my lords.
Under UAPA, that I am aware.
4 ali, my lords. It's relevant to mention here, my lords would get paragraph 4. It's relevant to mention here, said arrest memo is in so and so does not contain any any column regarding grounds of arrest of the appellant. This very issue is primarily the bone of contention. Now, my lords, please notice paragraph 8, Roman number 6 and 7, my lords. Paragraph 8, Roman number 6 and 7.
All right. Submissions.
Yes, my lord. Judgment of Pankaj Bansal. That is what is like 2023 though.
All right.
Then, my lords, after that, kindly look at the discussion and conclusions which we get at paragraph 13 onwards, my lords. Paragraph 15 may be noticed. Now, this discussion and conclusions, my lords. Paragraph 15 only. The grounds of arrest, where it emanates from, is Article 22(1), my lords.
All right.
And then, my lords, paragraph, please notice just above, they extract paragraph 32, 36. 36, just above 36, one sentence, if my lords would notice, my lords. Now, I'm on still paragraph 15 only, my lords. Paragraph 15 only. Pankaj Bansal, they have extracted it. Adreli paragraph 36 ಮೇಲ್ಗಡೆ one sentence.
Para 15 ಅಲ್ಲ.
ಅದು para 15. Then the extraction of Pankaj Bansal.
Therefore, communication.
Therefore, communication of the grounds of arrest as mandated by Article 22(1) of the Constitution and Section 19 of the Act of 2000 is meant to serve this higher purpose and must be given due importance, and it should be in writing is in 36. That being so, there is no valid reason as to why a copy of such written grounds of arrest should not be furnished to the arrested person as a matter of course and without exception. Please notice after that 2 lines, my lords. Firstly, in the event such ground of arrest are orally read out to the arrested person, are read by such person with nothing further, then this fact is disputed in a given case. It may boil down to the word of the arrested person against the word of the authorized officer as to whether or not there is due and proper compliance in this regard. So it should be in writing. That's what they conclude. My lords, 37 is the second reason which they give there, my lord. Second reason as to why this would be proper course to adopt in a constitutional objective underlining such information being given to the arrested person. That portion they deal. And then, my lords, please notice.
Yes.
My lords, paragraph 18, the last 4 lines, my lords, in paragraph 18, should be at page 14 only there, my lords, paragraph 18. As a matter of fact, my lords should get that portion. As a matter of fact, 18. Both the provisions find their source in the constitutional safeguards provided in Article 22(1) of the Constitution. Hence, applying the golden rule of interpretation, my lords, virtually it is saying literal rule of interpretation, my lords. The provisions which lay down a very important constitutional safeguard to a person arrested on charges of committing an offense, either under PMLA or under UAPA, have to be uniformly construed and applied. Then, my lords, paragraph 20, they say, resultantly, there is no doubt in the mind of the court that any person arrested for alleged commission of offenses under UAPA, my lords, so much more stringent than IPC, my lords, under UAPA, or for that matter, any other offense, has a fundamental and statutory right to be informed about the grounds of arrest in writing, and a copy of such written grounds of arrest have to be furnished to the arrested person as a matter of course and without exception at the earliest. Next
So
sentence.
were they executing a body warrant when you came out of the prison?
No. Body warrant they executed. They took me in police custody, sent me back to the lead case. Then, my lords, in the lead case, since I had got bail, I step out of jail. As soon as I step out, my lords, they catch me in 8 and saying, now we have also invoked COCA, which was done earlier. I've now invoked COCA. I'm taking you back inside. So probably my freedom was only few steps, my lords. I think my freedom was about 5 steps before I went back to custody. So, my lords, kindly notice, my lords, paragraph 22 only. Right to be informed about the grounds of arrest, paragraph 22, flows from Article 22(1) of the Constitution of India, and any infringement of this fundamental right would vitiate the process of arrest and remand. Mere fact that a charge sheet has been filed in the matter would not validate the illegality and the unconstitutionality committed at the time of arresting the person and the grant of initial police custody remand to the accused. Then, my lords, communicate, my lords would get at paragraph 26, my lords. Lallubai, Jogibai Patel has been considered para 26, and they extract paragraph 20 of that judgment, communicate. And in bold, my lords, if the grounds are only verbally explained to the detainee and nothing in writing is left with him in a language which he understands, then that purpose is not served. The constitutional mandate in Article 22(5) is infringed. And then, my lords, finally, please notice paragraph 47 and 49. 47, my lords.
Yes.
Now, coming to the aspect as to whether the grounds of arrest were actually conveyed to the appellant in writing before he was remanded to the custody of the investigating officer. We have carefully perused the arrest memo. What was given was an arrest memo, my lords, like how an intimation has been done, and find that the same nowhere conveys the ground on which the accused was being arrested. The arrest memo is simply a pro forma indicating a formal reasons for which the accused was being arrested.
Just see this. Is it not the, have you seen this?
Yes, my lords.
Grounds ilva idralli.
I've got it. It's an intimation.
Grounds ilva idralli. Or you want the title, grounds of arrest?
My lords, grounds has to be, my lords should have seen, my lords, habeas corpus when we file the grounds of arrest on the basis of which the preventive detention takes place, my lords. It has to be very clear in saying what is the reason for your arrest. It can't merely say that there's
reasons are here.
No, my lords, this is not reason. Facts of the case, what my lords would get at paragraph 1.
ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿ ನ್ಯಾಯಾಲಯದ ಆದೇಶವನ್ನು
FIR ಅಲ್ಲಿ ಏನಿದೆ ಅದನ್ನ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ರೆ ಅದು grounds of arrest ಅಲ್ಲ. Grounds of arrest, my lords, I can give many samples, my lords, of how grounds of arrest, we get it in all preventive detention cases. Habeas corpus matters, my lords. It is very elaborate. That's why even in Supreme Court, my lords, when they considered this case, arrest memo which was given, we are arresting you. This is parameter.
According to you, this is an arrest memo.
It is more an intimation that I'm arresting you. And my lords, kindly notice also, kindly notice, my lords, even in the remand application after this, in the remand application, they don't say that the grounds of arrest has been intimated. And now, my lords, most important is paragraph 49, my lords. What's the difference between reasons to arrest and grounds of arrest? Most important. My lords, kindly notice in 49, my lords, it may be reiterated at the cost of repetition that there's a significant difference in the phrase reasons for arrest and grounds of arrest. The reason for arrest, as indicated in arrest memo, are purely formal parameters to prevent the accused from committing any further offense, for proper investigation of the offense, to prevent the accused from causing the evidence of the matter to disappear or tampering with such evidence in any manner, to prevent the arrested accused from making any inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to the investigating officer. These reasons would commonly apply to any person arrested on charge of a crime, whereas the grounds of arrest would require to contain all such details in hand of the investigating officer which necessitated the arrest of the accused. Simultaneously, the grounds of arrest informed in writing must convey to the arrested accused all basic facts on which he is being arrested so as to provide him an opportunity of defending himself against custodial remand and to seek bail. Thus, the ground of arrest would inevitably be personal to the accused and cannot be equated with the reasons of arrest, which are general in nature. From the detailed analysis made above, there is no hesitation in the mind of the court to reach to a conclusion that the copy of the remand application is a purported exercise of communication of the ground of arrest in writing was not provided to the accused appellant or his counsel before passing the order of remand dated 4th October, which vitiates the arrest. That is most important, my lords, which vitiates the arrest and subsequent remand of the appellant. As a result, the appellant is entitled to a direction for release from custody by applying the ratio. Now, this Arvind Kejriwal's case, my lords, they would again now recently reiterate. My lords, paragraph 16 and 23 of Arvind Kejriwal's case.
Where is it?
2024. Koಟ್ಟಿದ್ದೀವಿ, I think.
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀವ?
ಇದ್ರಲ್ಲಿದೆಯಾ?
Sorry, ಅದರಲ್ಲಿ just paragraph ಮೇಲ್ಗಡೆ ಒಂದು ಪೆನ್ಸಿಲ್ ಅಲ್ಲಿ ಬರ್ತಿದ್ದೀವಿ. 16 and 23, my lords. Please notice paragraph 16 there, my lords. My lords should kindly notice in 16, Prabir is quoted.
Yes.
16 ali, all of that is on Prabir, my lords, what is quoted. And 28, my lords, providing the written grounds of arrest.
Yes.
So onus is that they have given us the grounds of arrest is on them. 28.
Yes.
So 3 judgments, my lords, which deal with grounds of arrest. 1 judgment, at the very initiation, I ought not to have been arrested. And the last judgment is a coordinate bench, my lords, which says at a given point of time, you can be arrested only in one case. In all the other cases,
Where is that judgment?
267. My lords, His Lordship, Kannada.
Good evening.
My lords, I'll mention the paragraphs there, my lords. Sri Shananda versus State of Karnataka reported in... I'm sorry,
Shashidhara, sir.
Shashidhara. Sorry, my lords. Shashidhara versus State of Karnataka. ILR 2023 Karnataka 2081. My lords, paragraphs are paragraph 7, 9 to 18, my lords, and 22 to 28. Finally, my lords, I'll just point out one place where the court says, at a given point of time, my lords may notice paragraph 11, my lords. Paragraph bottom ali, page number ali, 218, my lords. Paragraph 11.
Para 11, no?
Para 11, my lords. Bottom it is.
Yes.
Let's get that portion. On careful and conjoint reading of section 439 and 267. Now 267 body warrant. And also the contents of form 36 and 37 of the CRPC, the following aspects would emerge. Kindly notice the first one, my lords.
In only one
A person can be in custody at any given point of time, only in one case. So, my lords, if their case was, the lead case was 467, then how is it that they showed my arrest in the second case, 449? Then, my lords, if at all, if the same person is required to be produced before the investigating agency or before the court, as the case may be, or to meet different contingencies enumerated in section 267 of CRPC, he can be temporarily taken out of custody, produced before the investigating agency and before the jurisdictional court in terms of the order passed by exercising powers under 267. After the said contingency is fulfilled, the accused, under trial prisoner or convict would be brought back to the judicial custody. That's to the lead case, my lords. Then the temporary transit of the accused in pursuance of the order passed under 267 would not authorize the jail authorities to detain him in the custody. Then, my lords, the paragraphs which I have mentioned. But this is the crux of it, my lords.
All right. Yes,
My lord, on the 2-3 points I would like to.
Yes.
Here, what happened in that Parity case? There are some insertion in the remand order, etc. With respect to the complaints.
We are on legality of it.
Just I wonder.
Prabir.
Under that ground, I think yes. Para number 39. In my ruling,
Same.
The remand order dated 4th, 2023 records that the copy of the remand application had been sent to the learned advocate engaged by the accused appellant through Sri app. A bare perusal of the remand order is enough to satisfy that these 2 lines were subsequently inserted in the order. Because the script in which these 2 lines, this is in the background of this, some, I think, alteration in the remand report, etc., regarding the, I think, conveying the grounds of arrest, I think Supreme Court observed this is also. That's why my submission, I have got a clear-cut document to show that the regions, I think, for arrest, it is well within the, brought to the knowledge of the accused. Just read.
That is the reason according to you.
Yes, my
grounds of arrest and reasons of arrest are contained in that notice.
Yes, yes. My one. ನಿಮ್ಮನ್ನು ಭಾರತೀನಗರ ಪೊಲೀಸ್ ಠಾಣಾ ಮೊಕದ್ದಮೆ ಸಂಖ್ಯೆ 8/20/22ರಲ್ಲಿ ಸೆಂಟ್ ಜಾನ್ ರಸ್ತೆಯ ಶಿವನಶೆಟ್ಟಿ ಗಾರ್ಡನ್ ರಸ್ತೆಯ ಸರ್ವೆ ನಂಬರ್ 10/7 10/10ಗಳ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದ ನಕಲಿ ದಾಖಲೆಯನ್ನು ಸೃಷ್ಟಿಸಿ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿ ನ್ಯಾಯಾಲಯದ ಆದೇಶವನ್ನು ಪಡೆದು ಸದರಿ ಸ್ಥಳದಲ್ಲಿದ್ದ ವಾಸವಿದ್ದ ಕೊಳಚೆ ನಿವಾಸಿಗಳನ್ನು ಅಕ್ರಮವಾಗಿ ತೆರವುಗೊಳಿಸಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. After taking the police custody, after recording the voluntary statement, he was conveyed the grounds. My submission in criminal cases, grounds ಆದಷ್ಟು ಎಲೋಬ್ರೇಟ್ ಆಗಿ ಹೇಳಿದ್ರೆ ಐ ಥಿಂಕ್ ಇಟ್ ವುಡ್ ಡಿಫೀಟ್ ದಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ has so said.
ಅಲ್ಲಿ ಎಲ್ಲಾನು ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ ಸ್ವಾಮಿ ಕ್ರಿಮಿನಲ್ ಕೇಸಸ್ ನಲ್ಲಿ. ದಟ್ ಇಸ್
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ says, sir.
Yes, yes. ಅಷ್ಟು and my submission that is there. And moreover, lastly, regarding the in the both courts, session courts and as well as this court,
ಎವಿಡೆನ್ಸ್ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ, ಅರೆಸ್ಟ್ ಯಾಕೆ ಮಾಡ್ತಾ ಇದೀರಾ ಅಂತ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡ್ಬೇಕು ಅಷ್ಟು. ಅದು ಹೇಳ್ದೆ ಹೋದ್ರೆ
ಅಷ್ಟು ಹೇಳಿದೆವು ಸ್ವಾಮಿ. ಅದು ಫೋರ್ಜರಿ ಗಿರ್ಜಿ ಇಂಥ ಕೇಸಲ್ಲಿ ಇಷ್ಟು ಸಾಕಾಗ್ಬೋದು ಸ್ವಾಮಿ.
ಸಾಕಾಗ್ಬೋದಾ?
37, 10-7, 10-10 ಇದರಲ್ಲಿ
ಕೋರ್ಟ್ ಹೇಳಿದ
ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಅನ್ನು ಆದೇಶವನ್ನು ಪಡೆದು ಸದರಿವಾಸ ಕೊಡ್ತಿರೋ ಒಂದು ನ್ಯಾಯಾಲಯದ ಡಾಕ್ಯುಮೆಂಟ್ ಸಹ ಫ್ರಾಡ್ ಮಾಡ್ತಾರೆ. That's why
I am not in the offense. It is only on whether your arrest is in tune with Supreme Court directions or not. And ಈಗ ಆಗಿರೋದ್ರಿಂದ I thought I would wriggle out of this, but there is a paragraph, para 22. Charge sheet ಹಾಕದ ಮೇಲೆ ಒಂದು illegal arrest can be looked into, putting the clock back to the date on which he was arrested despite charge sheet being filed.
ಇದು ಪೆಂಡಿಂಗ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕ್ರೈಮ್ ನಂಬರ್
ಹೇಳಿರೋದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿರೋದು para 22 ಅಲ್ಲಿ.
ಕ್ರೈಮ್ ನಂಬರ್ 8 ನಲ್ಲಿ 55 days.
If you see, the right to be informed about the grounds of arrest flows from so and so, and any infringement of the fundamental right would vitiate the process of arrest. Mere fact that charge sheet has been filed in the matter would not validate the illegality and unconstitutionality committed at the time of arresting the accused and grant of initial police custody remand to the accused. So subsequently charge sheet ಹಾಕಿದೆ, ಈಗ ಎಲ್ಲ ಸರಿ ಇದೆ
Italy ಹಾಕಿಲ್ಲ.
even then
That previous my lead case 467 ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ, 8 ಅಲ್ಲಿ ಹಾಕಿಲ್ಲ. So even we don't even have to put the clock back.
No, even then yes. Supreme Court says.
And my submission that both session court, Coca special court as well as this court, jurisdiction are invoked simultaneously. Same grounds.
I'll reject
482, 439. That is the only difference. But ಇಲ್ಲಿ ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟಾಗಿದೆ ಮೊನ್ನೆ
439 ತುಂಬಾ ಡಿಫರೆನ್ಸ್ ಇದೆ.
ಡಿಫರೆನ್ಸ್ ಇದೆ, ಬಟ್ ಗ್ರೌಂಡ್ಸ್ ಆಫ್ ಅರೆಸ್ಟ್ ಬಗ್ಗೆ ಎಲ್ಲ ಫೈಂಡಿಂಗ್ ಕೋಕಾ
that can be only here.
But
not
under
by the
section
court.
12 of the COCA, they have to prefer appeal. Under the COCA provision, 12, that is there. Under 12, they have to invoke. Even remand report also they have challenged, knowingly full well. That is they have not challenged.
I'll only consider it what the apex court has held in Praveer's case, whether it fits into that or not. Jagdish.
EMLA section 19 mandates those things. Here, my lord, it's on section 50 of CRP.
ಅದೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ
Correct.
all of you
Mandates grounds of arrest to be given. Yes, that's what is said in Praveer.
Distinction in here, my lord, is connection with the
Is UAPA.
UAPA 19
We'll see.
ಇದರಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ ಜನರಲ್.
Yes, we'll pass orders tomorrow. ಇದು ಪ್ಯಾರಾಗ್ರಾಫ್ಸ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ರೆ ಇದರಲ್ಲಿ.
Yes, my lords. My lords, now CRPC.
One point.
ಹೇಳಿ ಅಶೋಕ್.
ಇದು ಐ ಥಿಂಕ್ ವೈಲೇಷನ್ ಆಫ್ 22 ಅನ್ನೋ ಬಗ್ಗೆ my friend ಇಲ್ಲ ದಿಸ್ ಇಸ್ ಮೊದಲು ಅರ್ಲಿಯರ್ ವ್ಯೂ ಡಿಫರೆಂಟ್.
ಅರ್ಲಿಯರ್ ವ್ಯೂ ಬಿಡಿ ಸರ್, ಅರ್ಲಿಯರ್ ವ್ಯೂ ಡಿಫರೆಂಟ್. ನಾವೇನ್ ಮಾಡಕ್ಕೆ.
That is not
We are on today's view, sir.
ಸ್ವಾತಿ ಪ್ರಜ್ಞಾ ಸಿಂಗ್ ಠಾಕೂರ್ ಕೇಸ್ ಅಲ್ಲೂ ಇದೆ.
That is considered in Praveer.
ಅಲ್ಲ ಸರ್, that judgment is not overruled at that by larger bench.
We will follow the.
ಇಲ್ಲಿ once the judicial remand is there, then that
we'll see. ಕೊಡಿ ಅದು judgment ಕೊಡಿ.
Yes, yes.
ಕೊಡಿ.
Swati Prajna Singh case in this. There also the illegal arrest, there was the contention. 13 days earlier to the date shown by the police, she was arrested like that. That is the allegation. That is the once it is, he was arrested and produced before the special court.
All right.
And he was remanded by the special court.
No, we'll see.
Judicial
larger bench ಅಲ್ಲಿ ಬಂತು. ಇದು ಎರಡು ಇದು ಇಬ್ರೆ ಲೇಟೆಸ್ಟ್ ಇಬ್ರೆ.
That point is not settled in Telika.
We will follow what is to be followed. Let's see tomorrow. 1 ಗಂಟೆಗೆ ಕವ್ಯ. 1 o'clock ಹಾಕ್ತೀನಿ.
Just a clarification, section 50 of CRPC, which is 47 of BNSS now, my lords, grounds of arrest to be informed. So it's just not in PMLA, but under CRPC itself, it is.
These things will crop up. We'll refer to BNSS also.
How? 47 in BNSS and 50 in CRPC.
All right.
Deeply obliged.
Tomorrow at 1 p.m. ಹಾಕಿ. Dictating orders on that. And just remind me at 1 p.m.
Please.
We'll dictate it. Yes. ಇದೆಲ್ಲ ಜಡ್ಮೆಂಟ್ಸ್ ಸಂದೇಶ್ ಚೋಟ್ ಅವರೇ. ಜಡ್ಮೆಂಟ್ಸ್ ಪ್ಯಾರಾಗ್ರಾಫ್ಸ್ ಎಲ್ಲ ಇದೆ ಇದರಲ್ಲಿ.
Yes, but I'll again cross
ಜಸ್ಟ್ ಕ್ರಾಸ್ ವೆರಿಫೈ ಅಂಡ್ ಗಿವ್ ಇಟ್. ಅಶೋಕ್ ಸರ್ ನಿಮ್ದು ಯಾವ್ದಾರು ಇದೆ ಬೇರೆ? ಜಡ್ಮೆಂಟ್ ಒಂದೇ ಅಲ್ವಾ?
ಹೌದು ಸರ್.
ಕೊಟ್ಟಿದ್ದು ಒಂದೇ 2011 10 SCC.
Yes, yes, yes.
You have anything to say? ಅವರೇ ಸ್ಪೆಷಲ್ ಪ್ರಿಫರೆನ್ಸ್. Yes. MMDR.
19.
ಈಗೇನ ಅರ್ಜೆನ್ಸಿ ಏನ್ ಚಿದಂದೆ ಸರ್?
Urgency there is an interim order.
Just the matter on 19th at the request of the learned additional SPP and HCG. Yes, interim order subsisting will continue to the next date of hearing.
So, wherein the complainant and his family members' accounts has been seized, my lords.
Yes,
Under section 1.
family members account frozen.
70 lakhs has gone to.
At 70 lakhs, there is nothing, my lords, for the reason that.
Nothing. ಎಲ್ಲ ಖಾಲಿ ಮಾಡ್ಬಿಟ್ರ?
Illa, my lords. Accused was entice the complainant as well as other persons to invest in his company. Wherein in 2023, my lords, he has given money to the complainant as well as the other person,
Sir,
other victim.
Are you all accused in any case?
No, my lords.
You are not accused.
No, my lords.
Who is the complainant?
Complainant is the petitioner, my lords.
Petitioner is a complainant, sir.
Petitioner number 1 is the complainant. Along with him, my lords, kindly, my lords, at page number 19, my lords.
What is your complaint?
Lords, my complaint is that 6 crore 79 lakhs has been taken away by the accused, my lords. That has been invested by 14 people, including the complainant.
Yes.
Like he's received.
Your accounts act freeze ಮಾಡಿದ್ದೀರಾ?
He's received 70 lakhs from this company.
My lords,
Which company?
That VM.
Vince
VMS.
marketing company, my lords.
His marketing company. He's received 70 lakhs. His wife has received 2 to 3 lakhs and his children received 5 lakhs.
Why did you all?
Everyone has received in 2023, my lords.
Okay.
He has enticed to invest in his company. Thereafter, he has given the returns. After that, my lord, second time when he states that invest in the company, after that he has.
Where are these in records?
I have entire bank.
70 lakhs is not there.
What is the it's these people to freeze the accounts?
No, the findings, my lord.
Lords, there is no compliance, my lords. They have not.
What complaints? 102 ಬೇಕಾಗಿಲ್ಲ sir. Don't tell me 102 now.
Lords,
Shanto Varghese ನೋಡಿ. Latest judgment. 2024 284. ನೋಡಿಲ್ವಾ?
But
yes.
The magistrate has to be intimated.
No, that does not vitiate the proceedings.
But
that will only entail a departmental inquiry against the man who has not. ಅಷ್ಟ್ ಸಾಕ ನಿಮ್ಗೆ?
No, my lord, sir.
All right.
Second thing, they have not issued a notice to me.
That we'll see. But why? ಈಗ enticement ಅಂದ್ರೆ ಅವರ luring into the ಇದು, then it's a matter of evidence.
70 lakhs he is received. And not only his wife, children, every their account.
All right. That is received from whom?
From this company who cheated people. Other
Now the company is the accused in all these things. So he is also a beneficiary of that cheating is what you're saying. All right, we'll see.
Then there are 14 members, my lords.
ಆಯ್ತು ಅಷ್ಟು ಬಂದಿರೋದನ್ನ ಲೀನ್ ಮಾರ್ಕ್ ಮಾಡಿ.
ಅಕೌಂಟ್ ಅಲ್ಲಿ ದುಡ್ಡೇ ಇಲ್ಲ ಅಷ್ಟು.
ಎಲ್ಲ ಖಾಲಿ ಮಾಡಾಗಿದೆಯಾ?
ಅಲ್ಲ, kindly notes at page 19, there are 14 victims.
ಅಲ್ಲ ಎಷ್ಟಿದೆ ಅಕೌಂಟ್ ಅಲ್ಲಿ?
Sure, that I don't know.
All empty?
Empty.
Lords, not empty, my lords, because every month he has paid us, my lords, the victims.
Oh, every month.
Because for the reason, my lords, we have invested him and he has stated that we will give returns every month.
ಹೆಂಗು ಅಕೌಂಟ್ ಅಲ್ಲಿ ದುಡ್ಡಿಲ್ವಲ್ಲ ಬಿಡಿ ಅಂತ ಹೇಳಿ.
My lords, is salaried account, my lords.
Salaried account ದುಡ್ಡೇ ಇಲ್ಲ, ಎಲ್ಲಿಂದ ಕೊಡ್ತೀರಾ ಸ್ಯಾಲರಿ?
ಅಲ್ಲ, ಅವ್ರಿಗೆ salary.
10 rupees, 800 rupees.
800 rupees.
But my lords, my account, my lords,
minimum balance ಇಲ್ಲ.
It cannot be seized, my lords, without there being any.
We'll see. No, 102 is need not be complied.
An intimation to the magistrate, my lords, to file an application under 457.
Get all those records. No warrant for interim order, but for defreezement. Yes.
Lords, my children's account, my lords.
No, it's all right. You all received money. Yes. List on 24th.
Okay.
Get the records by then.
Yes.
Yes, next.
46.
That's,
46, 47, both.
let's make the submission. My lord, what I may take my lords to one order, my lords.
Respondent illa.
Responding to that.
Oh, idralli, not yet.
Yes, my lords. My lords may take to page 69, my lords.
Now, what do you want?
Let's
Get
have
the
a-
respondent.
Let's respond ಬೇಕಾಗಿದೆ. Respondent is
ಬೇಕಾಗಿಲ್ವಾ? ಏನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
Complete the investigation within the time frame of 2 months.
Oh.
Is the prayer which they are sought in.
Further investigation order is last year in the month of June 2023, my lords.
ಇನ್ನೂ ಆಗಿಲ್ವಾ?
ಇನ್ನೂ ಆಗಿಲ್ಲ, my lords.
Yes.
My lord, FSL report is waiting, my lord, almost.
ಅಲ್ಲ, my
When do you get the FSL report?
Lord, another 2 months, my lord.
2 months ಬೇಕಾ FSL report? 2 weeks ಅಲ್ಲಿ it should come, sir. No, 2 months.
may request, my lords.
This is why every accused walks away. 3 months, 6 months, 10 months, 2 years FSL report doesn't come. You don't send reminders at all. In cases where it is needed, 2 weeks al barat.
My lord,
That's one.
Get the instruction about the FSL.
please, my
My
lord.
request, my lords, let them, my lords, file an affidavit what has been transpired in this particular case as well as the next.
I'll
case.
place
I
the
will
investigation
see.
papers with you.
Learned HCGP.
Last time they make a submission saying B report file ಆಗೋಗಿದೆ ಅಂತ.
Earlier, my lord,
Learned HCGP would submit that what is awaited in the case at hand to file a final report before the concerned court is a report from the Forensic Science Laboratory. The Learned Counsel seeks 2 more months' time to secure the FSL report and make it a part of the final report. This court had directed further investigation at the time when the matter was, at the time when petition adu?
That's page number 68, my lords,
68.
page number 28, my lords, annexure E.
3559, right?
That, my lords, the acceptance of B report was set aside, my lords, and sent back to the trial court.
What is the date of that order, sir?
My lords, that date of the order is 27/6/2023, annexure E. my lords.
By an order dated 27/6/2023 had
Sent it back before the trial court. my
remitted
lords.
the matter back to the hands of the concerned court.
And on 29,
Where is that?
that's
Concerned court.
at page 69.
Therefore, 1 year, more than a year has lapsed prior to, after the order being passed by this court. There is no justification in the submission of the learned HCGP that 2 months' time was required. The report shall be sought by the next date of hearing, list on 26th.
That's may seek on Friday, my lords. My lords,
Seriously? Yes. List on 26th. Both 47, 46, 47.
that's can I,
ಇದರಲ್ಲೂ entry order ಇದೆಯಾ?
that's, can I seek for fresh?
Fresh, that you can seek, granted, yes. 48, interim order ಇದೆಯಾ ಚಿದಂದೆ sir?
But interim order ಕೊಡ್ಲಿಲ್ಲ ಅದು here.
ಇದು ನಿಮ್ದಿದು, yes.
So only it's a cognizance, my lord, sir. Sorry, committal procedure is not followed, sir. Their contention.
You will direct them to follow.
No, not. The allegation against the petitioner is, my lord, kindly come to page 46.
Yes, you will not file objections.
I will file,
You will file.
please,
I'll grant you 2 weeks' time.
please.
List on 25th in the fresh matters list, objections if any by then. Till such time further proceedings before the concerned court shall remain stayed.
Please.
Next. 49.
For petitioners in this case, my lord, offense is 376 and 354, breach of promise to marry, my lord.
Breach of respondent iga?
My lord, which was posted for settlement last week.
Oh, then on merits will pass the order.
Please,
Amal, to pass over.
please.
Yes, Sakman.
Serial number 75, my lord. Memo of withdrawal is.
Will come in the evening. ಈ ಕಡೆ ಬನ್ನಿ ಸರ್, ಏನು ಕೇಳಿಸಲ್ಲ. ಸೆಟಲ್ಮೆಂಟ್ ಈಗ ಆಯ್ತು, ಬಂದಾಗ ಕರೀರಿ.
Alert serial number.
ಮೂವಿಂಗ್ ದ ಮೆಮೊನ ಕೊಡಿ. ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್.
Alert serial number 75, my lord. I filed memo of withdrawal.
That will be withdrawn, don't worry.
Serial number 84.
Others. ಯಾವತ್ತು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ?
Hold on. 21/10/2022.
15?
21/10/2022, just before 2 months. In page number 2, it is there. 21/10/2022. First, they have transferred 21,87,500.
Intermittent transfers. And that's there.
Further,
So what?
further, not only that transaction.
My lord, after 4G exemption was granted by the government, my lord, wide annexure.
That is contention of before work order issuance.
For work order, they have granted.
That's all.
And not only about that, once the work, the amount is sanctioned.
How dispute is between whom for arbitration?
My lord, between the Nirmiti Kendra and the petitioner. The contract is between Nirmiti Kendra. Nirmiti Kendra is, my lord, society registered under Societies Registration Act. My lord, there, the engineers has to, my lord, decide, and they have to, my lord, give, my lord, pass off. Lord, my instruction is, my lord, brass, copper, and my lord, zinc is used to become, my lord, bronze.
To become bronze?
Yes, my lord. To get the bronze, they use brass, copper, and zinc.
Yes.
And that has been used, my lord, is my respectful submission. Lord, now there is a judgment, my lord, of the this honorable court, where if the work is substandard, Lord, or the service is substandard, Lord, my lord Amit Gar, your lordships.
Lord, it's not
Lord,
about that transfer.
Wait, sir.
420 cannot be attracted. Para 17.
This is my judgment.
Yes.
Yes, sir.
Mask.
It's a mask, sir. N95 mask.
Although substandard work was the allegation.
Substandard supply of mask.
Supply mask.
ಅದು ಹಾಕೊಂಡ ಮೇಲೆ ಕೋವಿಡ್ ಬಂದಿತ್ತು ಒಂದು ಸ್ವಲ್ಪ ಜನಕ್ಕೆ.
My lord, relying on, my lord, Sushil Sethi.
Yes, sir. So substandard work idre does not attract.
Assuming, my lord, if it is a substandard work, my lord. 420 is not. My lord, what happens is, my lord, this is politically motivated.
What is politically motivated?
He is a political office bearer, my lord, where he's the complainant. Yes, my lord. He filed a PIL recently, my lord, against the same issue that has got dismissed. And my lord, when the Nirmiti Kendra permitted me to continue the work, they put, my lord, mud on the road so that nobody can travel to the theme park.
So he is from the opposite party, yeah?
Yes, my lord.
Wait,
just
sir.
one second.
Wait. ಕೊಡಿ ಅದು ಕಾಪಿ ಒಂದು ಕೊಟ್ಟಿರಿ.
We will give it.
Just one submission.
Yes, sir.
In page number 5 of the same statement, my lord. What work do they have to transfer the amount to the account of project director of Udupi Nirmiti Kendra? What right do they have to transfer the amount to the account of project director?
That is personal account?
Yes.
Where is that?
In page number 5 of your statement, he is a project manager, my lord.
What's his name?
Sachin. On 10th,
Lord, we don't have copy, my lord. Let him.
ಇದೆಯಾ ಅಂತ ನೋಡೋಣ ತಾಳಿ. ಏನು? Which page, sir?
Page number 5.
The pages are according to page number?
5. Last page.
3 of 5. 4 of 5. 5 of 5.
Dated 10 February 2023, my lord.
10/2/23. Sachin.
He is project manager. What, and my lord, for
Much amount, what is amount transferred?
1 lakh, my lord.
1 lakh?
Yeah, 1,27,000. And again, on 16/2/2023, it is 1 lakh. So on what basis did they transfer the amount? Was it a bribe or was it a gift? And my lord, here, project director, my lord, he was
project director Nirmiti.
Yes, project of Nirmiti.
Sachin is not a project director.
Project manager is project manager.
All right.
Project director was handling this account, and for this very reason, my lord, he, for this
All right.
malicious
There
act,
may be problem with, he is an artist.
yes,
That is what he says.
but that artist, how can he bribe?
Whoever, don't use bribe.
Then can we consider it as this as
bribe.
gift?
Alleged.
Alleged bribe. Okay, alleged bribe. Alleged bribe or alleged gift, whatever it may be. On what basis did I transfer this amount? On for this malicious act, my lord, project director is suspended.
Sham, sir.
Please.
Bronze will complete?
Yes, my lord, we will complete.
We'll see.
We'll complete, my lord. In a stipulated time, my lord. Now, since my lord, it has been seized and my lord, they didn't allow us to go there.
That's
And there is a
tentative-
direction from the police not to work.
Tentative opinion, we'll see what
But
orders
anyway,
to pass.
these material, my lord, since it is not a bronze, question of using the same thing does not arise anymore now.
We'll see.
But
But
my lord, they can't do any
dismantling-
business now because their GST account is already suspended by Commercial Tax Commissioner because they did not pay proper GST and also they did GST fraud by showing that they have paid GST to the government, my lord. So they can't conduct any more business again. On suo motu basis, this GST account is suspended. How can they conduct any business?
That, my lord, GST authorities will take care, my lord, not, my lord, for, my lord, this is the problem, my lord.
But
Now this
they
is a, my
pay-
lord, tender, my lord, and my lord, there is a contract. My lord, if a public person claims to be a public spirited person, who is, my lord, a office bearer of a political party, my lord, who is a rival political party, my lord, and the MLA, my lord, and the
You are the
earlier-
MLA na?
earlier MLA, my lord,
Hmm.
belonging to, my lord, the other political party, and now the
Other andre iದ್ಯಾವ political party?
defeated political party person, my lord, goes to the studio of the petitioner and, my lord, asked the police to seize. In his presence, it was seized. This is how, my lord, politically motivated. Now the entire, my lord, idea is to stall this project and, my lord, so thereby, my lord, earn a bad name. So this was done during the earlier government. Now the entire theme is this, my lord, to tarnish the image and reputation of the MLA as well as the earlier minister and government.
But what they are claiming is, my lord.
The very presence, I have produced along with the photograph, the defeated MLA of the constituency. He goes to the spot and, my lord, he direct the police to seize. He belongs to the ruling party, my lord. He's office bearer. And in his presence, police seizes, my lord. Their photographs are there. This is how, my lord, it is politically. Kindly see, my lord, my IA, my lord, dated 1982, my lord, the photographs, which clearly shows
Oh, that
the-
last
if-
time
how
ತೋರಿಸಿದ್ರಲ್ಲ?
the defeated candidate ಹೋಗಿ seize ಮಾಡಿಸಿದ್ದು, and they put, my lord, mud on the road so that I can't go to the project.
Next 21.
ನಿರ್ಮಿತಿ ಕೇಂದ್ರದಲ್ಲಿ ಆಫೀಸರ್ಸ್ ಪ್ರಾಜೆಕ್ಟ್ ಡೈರೆಕ್ಟರ್ ಅಂತ ಇರ್ತಾರ? ಪ್ರಾಜೆಕ್ಟ್ ಆಫೀಸರ್?
Project director, ಕಾಂಟ್ರಾಕ್ಟ್ ಬೇಸ್ ಅಲ್ಲಿ ಇರ್ತಾರೆ. It's a ನಿರ್ಮಿತಿ ಕೇಂದ್ರ registered body under.
That I know, yes.
And government ಇಲ್ಲಿ they misunderstood. Government DPR ಮಾಡಿದ್ರು. Detailed project report. Based on that, the government received the detailed project report. And thereafter, based on that report, ಒಂದೊಂದು ಏರಿಯಾಕ್ಕೆ ಅಂತ ಒಂದು ಅಮೌಂಟ್ ಫಿಕ್ಸ್ ಮಾಡಿರ್ತಾರೆ. Thereafter, the government has not paid the amount. Here, question comes, had the government paid the amount here? They're saying that cheating the person between two persons. He is not the person who paid the money. And we utilize our administrative fund.
The public money.
It's not public fund. It's not public fund.
What fund is?
Administrative money ಅಂದ್ರೆ ಗವರ್ಮೆಂಟ್ ಈಗ ಇಲ್ಲಿ
ಎಲ್ಲಿಂದ ಬರುತ್ತೆ ಅದು?
ಸೊಸೈಟಿ
ಸೊಸೈಟಿ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ?
ಸೊಸೈಟಿ ನಾವು ಬೇರೆ ಬೇರೆ ವರ್ಕ್ ಮಾಡಿದ್ರಲ್ಲಿ 5% ಅನ್ನ ನಾವು
ಕಮಿಷನ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಚಾರ್ಜಸ್
ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಚಾರ್ಜ್ ಎತ್ಕೊಳ್ತೇವೆ. They are executing the work.
This PAL was dismissed by
yes,
on the same cause of action.
And for
And he suppressed, my lord, throughout that he is a office bearer of a political party.
ಸೇಮ್ ಕಂಪ್ಲೇಂಟ್.
ಹೌದು,
ನೀವು ಪೇ ಎಲ್ಲ ಹಾಕಿದ್ರಾ?
ಎಲ್ಲ ಹಾಕ್ತಾರೆ ಅವರು.
Which,
And he suppressed that he is
same
office
cause of
bearer of
action.
political party.
It is not regarding same cause of action.
And,
It is
it was
regarding
dismissed
another
without
fraud
notice, my lord,
which had
otherwise
taken
it would have
place in
brought
the same Parashurama theme park. That is regarding inauguration. How the inauguration was done. On what basis did they use the funds was allocated for inauguration?
Anyway, this is dismissed.
Of course.
Without notice, it was dismissed, my lord. But he
Without
suppressed
notice.
the fact that, my lord, he belongs to a political party.
All right, we'll see.
Just
My lord,
because I'm
this is
belonging
how,
to
my lord,
political
they want to
party, my
stall
lord,
the project.
I am not
That is the
being-
only thing. My lord, there are two other proceedings, my lord. One is already stated, my lord, by the coordinate bench. Your lordship observed in the order. That CID inquiry has been ordered. That has been stayed.
What is that?
CID inquiry on the same issue, my lord.
ಅದೇ ಟ್ಯಾಗ್ ಆಗಿದೆ ಇದಕ್ಕೆ?
ಇಲ್ಲ, tag ಆಗಿಲ್ಲ.
GM ಅದು?
GM ಅಲ್ಲಿ ಇದೆ. Stay has been granted, my lord. There is one more, my lord, inquiry commission appointed, the Justice Nagmohan Das commission.
That also I've observed everything in the order.
Observed, my lord. But the only thing is,
What has happened before the committee? Just Nagmohan?
nothing has happened, my lord.
Actually,
Only-
Justice Nagmohan Das committee doesn't have anything to do with this one. Because Justice Nagmohan Das.
Release of funds ಮಾತ್ರ ಅದಿರೋದು.
ಇಲ್ಲ. It is not, this complete construction of Parashurama statue is done by not PWD department or other department. It is done by tourism department. So Justice Nagmohan Das committee is considered. only
PWD
with
and
respect-
BBMP.
Yes, PWD department, Commodity, that one.
Will
Not
consider.
this one. They issued notice.
Heard reserved. You commence later if the order is.
Yes, my lord. Last portion of the order in the interim order, my lord, is missing, my lord. It is not typed actually. Lord, your lordship, after passing the order of my lord, interim order, dictated, my lord, 2 lines, my lord. That is not part of the.
I've deleted that. They're permitting you to continue the work.
No, the submission was that, my lord, permit me to continue the work. Lordships observed that if anything, my lord, then the
We'll see. Heard
contractor is
reserved.
held responsible. He cannot be blamed, my lord. The officers will.
Heard reserved.
But synopsis, my lord.
ಕೊಡಿ ಕೊಡಿ ನಿಮ್ದು ಏನಾದ್ರು ಇದ್ರೆ ಕೊಡಿ.
Lord, may I place the photographs, my lord, how it was looking and
I can't extract the photographs, sir. Synopsis ಸಾಕು.
ಇದರಲ್ಲಿ ಈ ತರ Lord, the difference is this, my lord. Angle change ಆಗಿದೆ. ಈ ಕೊಡಲಿ weight ಗೆ ತಡಿತಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಈ ಕಡೆಗೆ ಮಾಡಿಲ್ಲ.
In Parshuram of your own vision, is it?
Lord, only, my lord, on the basis of history, my lord.
All right.
So the leg have been told that it's a fiber. The
May I
leg.
place it on record, my lord?
ಏನ್ ಬೇಕಾದ್ರೆ ಕೊಡಿ ಸರ್.
Please.
Yes. Yes. Heard reserved. Next. Heard so and so. Interim order subsisting shall continue till the disposal of the petition. Great.
Objection of Nirmiti Kendra, my lord, your lordship may.
Yeah. You. Yes, sir.
11.
Objection of the Nirmiti Kendra, my lord, where they said that it is a bronze based on NIT report. Your lordship may observe something on that.
Eight. ಹದಿನೆರಡು ನಾಳೆ ತಗೊಂತೀನಿ ಅದು. 10 ನಾಳೆ ತಗೊಂತೀನಿ. I'll take it tomorrow. Please. I left the file at home. Please. Reading it, yes.
11 minutes.
Recalling of witnesses. We'll allow it. What is the age of the POCSO, na?
Please, my lord.
Age of the victim, madam?
5 years, my lord.
Seriously?
Please.
Now what is the age of the victim?
No more. She is no more, my lord.
Yeah? No more. What happened? 302 ಇದೆಯಾ? 302 ಇದೆಯಾ? ಯಾಕೆ 17 ಇಂದ ಮುಗ್ದಿಲ್ಲ ಈ ಕ್ರೈಮ್?
Then when in custody, my lord,
No, whatever it is, in a case of rape, POCSO, murder, if you take 8 years to complete the crime, where will they stop?
Correct.
These things should be done fast, sir.
But the law says that it has to be done within 1 year.
So what? 7 years ಆಗಿದೆ. Special CC 412 of 2017.
Yes.
We are in 2024. And all are heinous offense. The allegation is rape of a 5-year-old girl and murder. ಇದ್ರಲ್ಲಿ ನೀವು ಕಂಪ್ಲೀಟ್ ಮಾಡಿಲ್ಲ, ಇನ್ಯಾವ್ದ್ರಲ್ಲಿ ಮಾಡ್ತೀರಾ?
The stage is already arguments, my lordship. They have filed, they
Many
approached the
times
court
recall
now.
application. Many times recall applications also seems to be.
How many times did you file recalling applications earlier? Why did you not examine them? Law should not be misused like this to keep recalling the witnesses. ಯಾವ್ಯಾವ witness ಹೇಳಿದಿರಾ ಈಗ ಹೇಳಿ?
8, 9, 19, 23, 25, 26, 32.
ಅಲ್ಲ ಇಲ್ಲಿ ಪ್ರೇಯರ್ ಇರೋದು ನಾನು ನೋಡ್ತಾ ಇದ್ದೀನಿ ಅದು. ಈಗ ಏನ್ ಕಾರಣ ಏನು?
They are all the material witnesses.
ಈಗ CW 8 is PW 6.
Please,
Have you not examined PW 6 earlier? ಒಂದ್ ಸರ್ತಿನೂ ಆಗಿಲ್ವಾ? ನೆಕ್ಸ್ಟ್ ಯಾರ್ಯಾರ್ದು ಒಂದ್ ಸರ್ತಿನೂ ಆಗಿಲ್ಲ, ಯಾರ್ದು ಫರ್ದರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹೇಳಿ.
ಎಲ್ಲಾರ್ದು ಯಾವ್ದು ಫರ್ದರ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿಲ್ಲ. ಎಕ್ಸಾಮಿನೇಷನ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿಲ್ಲ
ಯಾರ್ದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿಲ್ಲ? ವೈ?
That time, my lord, the advocate of the petitioner, once the petitioner was not well.
Oh. Now the counsel is well?
Many times the cost was imposed. Cross examination. Your lordship may allow, my lord.
No, see, then tomorrow
Your
it will
lordship may allow, my
be allowed on the ground that they were not permitted to cross examine at all. I will give only one chance and direct the court to conclude the trial within the next 6 months or even next 3 months, because it is 7 years old in the case of rape and POCSO. And it's a 5-year-old girl. ಇದ್ರಲ್ಲಿ ಮುಗಿಸಲ್ಲ, ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಮುಗಿಸ್ತೀರಾ ಸರ್?
3 months, my lord, with direction not to seek adjournment.
You are accused number 2. Why are you, he's in custody, is it?
No, my lord.
Then, who is accused number 1?
Accused number 1. Mallikarjun.
Again, against whom is the allegation?
Same.
Illa, madam. Allegation. Yes, Jagdish. Who is the accused, sir?
Mallikarjun alias Muga.
How are you involved in this? Accused number 2.
In her house only, the opera.
A1 is Mallikarjun, A2 is Chandana, that is you. Where is your application? Objection hakidira.
Yes.
28. Page number 28.
The petitioner, accused number 2, is knocking at the doors of this court, seeking recalling of witnesses. Madam, ಇಲ್ಲಿ ಪ್ರೇಯರ್ಲಿ ಯಾವ ವಿಟ್ನೆಸ್ ಅಂತ ಇದೆ ಅದನ್ನ ನೋಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಮಾಡಬೇಡಿ. Recalling of witnesses so and so. In special case number 412 of 2017, arising out of crime in crime number 245 of 2017, registered for offences punishable under section 376(2)(I), 302 of the IPC and section 468 of the POCSO Act, read with section 75 of the Juvenile Justice Act 2015. The petitioner and accused number 1 get embroiled in a crime for the aforequoted offences on the ground that the accused number 1 had forcibly had, can't say that, forcibly had page 5. And the petitioner had threatened to kill the victim after the said horrendous act on by accused number 1. The age of the victim at the point in time of the alleged incident was 5 years. The petitioner and the accused number 1 are charged of the aforesaid offences in crime number 245 of 2017. The police, after investigation, filed a charge sheet against these accused, and the concerned court registers special case 412 of 2017. 8 years, close to 8 years have passed by after the registration of the special case, after registration of a special C 412 of 2017, and the trial is yet to come to an end on notwithstanding the heinous offence alleged against the accused number 1 or the accused number 2, as the case would be. The reason appears to be repeated applications being filed by the petitioner seeking recall of certain witnesses on the score that they have not been cross-examined or they are required for further cross-examination. 2 such applications had been allowed in the past, imposing certain costs. This is the opportunity was not availed of on the score that the advocate who was conducting the trial was not well on the said date. The third application is filed by the before the concerned court by the present petitioner accused number 2 seeking recalling of the aforesaid witnesses. The application comes to be rejected on the score that it was only a ruse, ruse to drag the proceedings. It is this order that has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that the witnesses that are now sought to be recalled is for cross-examination and not for further cross-examination, as they have not been cross-examined at all. She would submit that it cannot be, the offense may be heinous, but it cannot be a case where there is no cross-examination of the witnesses at all. He would seek grant of one opportunity to cross-examine the witnesses on the date fixed by the concerned court and would not by the concerned court. The learned additional SPP would HCGP, na? Learned HCGP would refute the submissions to contend that the trial is being dragged on one pretext or the other throughout, and in the offense, the offense being heinous and the facts being horrendous, the trial is required to be concluded expeditiously, but would admit the fact that these witnesses who are now sought to be recalled have not been cross-examined at all in the trial, owing to the folly of the counsel who had represented the accused in the trial, who did not cross-examine on the dates fixed for such cross-examination. I have given my source. The aforenarrated facts are not in dispute, as they are all a matter of record. The petitioner is accused number 2 who is said to have threatened the victim threatened to kill the victim of after the incident that has happened by the hands of accused number 1. Therefore, accused number 1 and 2 are charged of the offenses punishable and so and so. The facts are horrendous, the offenses are heinous. The petitioner, the accused, filed 2 applications before the concerned court and 2 applications for seeking recall of witnesses and did not avail of the opportunity. In the normal circumstance, repeated applications would not be entertained, as it would become an abuse of the process of the law. But in the fact circumstance that the petitioner has not cross-examined the witnesses at all, as would reveal from the records, I deem it appropriate to grant one opportunity to the petitioner, and the cross-examination of those witnesses shall be completed on the dates on which they are fixed by the concerned court. It is made with a rider that the petitioner shall not seek any adjournment for further cross-examination of any of the witnesses, and no other application of the kind that is now presented before this court shall be entertained by the concerned court. The offense, as observed here and above, the offense is of the year 2017. The offense is of rape and the ingredients of POCSO, as also POCSO and murder, as the child with whom the accused number 1 had forced sex dies. In such cases, if the trial is not completed within the time that is prescribed under the statutes,
1 year.
i.e. the POCSO Act, 1 year, it would 1 year, it would become travesty. Therefore, I deem it appropriate to direct the concerned court to conclude the trial within 3 months from the date of receipt of the within 3 months after the cross-examination of the witnesses. How many witnesses are there?
9 witnesses.
9. The cross-examination of the witnesses shall happen on a day-to-day basis, i.e. 9 days from the date of its commencement, and no adjournment shall be granted to the counsel for the accused for cross-examination. In the event the accused would not avail of the opportunity, it is open to the court to proceed further in the trial. This is the last straw, STRAW, of opportunity granted to the petitioner. Is ordered accordingly.
12.
The petitioner speech.
Immoral traffic.
3, 4, 5 of the
ITP A1 and A2.
Nothing immaterial has been seized, my lord. And
what is seized?
Cash of rupees 2,000 and swiping machine.
Idu spana or hotel?
Spa months.
What did you see?
My lordship, in the victim has have stated, my lord.
Yenanta?
They are forced to.
Forced to what? Sumne, don't dub the victims also as doing that work. ಎಲ್ಲಿ ಇದು?
ಇಂದಿರಾನಗರ್, ಬ್ಯಾಂಗ್ಳೂರ್.
161, Where are the statements? But your 1 and 2, sir, difficult.
Owner and the manager. Owner and the manager.
Of course, yes. They are the ones to be alleged.
And this is suo motu complaint.
Maybe.
My last mate, can you look into the Mahajar if 15+2 is complied with?
15.2 is not mandatory.
Of the ITP Act.
Not mandatory. R.A.H. Seguran, Supreme Court, 2017 8 Not mandatory. Went from this court, which had held it to be mandatory, Supreme Court has reversed it. Huh? The owner and manager, adu gottu. But what did you find there? Nothing. 15,000 rupees cash swiping machine ella kade irutte.
2,000 rupees.
2,000 rupees. Aitu, adu ella kade irutte. How did you impute? ಅದು ಬಿಟ್ಟು ಬೇರೆ ಏನು ಸೀಸ್ ಮಾಡಿದೀರಾ ನೋಡಿ. If there is any other seizure, tell me. List tomorrow in the fresh matters list.
Please.
Because you have been searching every spa. Only if you find something, definitely you tell. Otherwise, you can't dub every spa as hubs of prostitution. And thereby declaring those people who do that massage as prostitutes. Not correct. Unless you find something, yes. No problem. This technical argument bidi 15.2, 13.2 ivella illa. Yes.
Please.
13?
My lord. 326.
Senior is little busy. Pass over.
No grounds. Difficult. Passed over to next Tuesday. Passed over by 1 week. Next Tuesday, in the fresh matters list. Next. List after 4 weeks, entry order subsisting shall continue. We're getting stack here.
No, my lord. Settlement talks are still going on. For the respondent number 2 in this case.
All right, council, both the councils in unison would submit that the talks of settlement are afoot, AFOT. Therefore, lest this matter after 4 weeks, interim order subsisting shall continue to the next date of hearing. Next. Marilva. No representation, list after 2 weeks.
My lord, serial number 15, I appear for the.
Yen matte?
My lord, he is for the hard to in the serial number 15, my lord.
15 alla talks ಆಗ್ತಿರೋದು.
Please, my lord.
ನೀವು 14 ಗೆ ಹೇಳ್ಬಿಟ್ರದ್ದು.
I appear for 14, my lord.
Madam, 14 ಗೆ interim order interim order subsisting shall continue till the next list after 4 weeks. Interim order subsisting will continue to the next date of hearing. 15 ಅಲ್ಲಿ ಅದೇನು ಹೇಳಿದೆ afoot ಅದಕ್ಕೆ ಹಾಕಿ. Yes.
Much obliged.
ಅದ್ರಲ್ಲಿ interim order ಇದೆಯಾ ನೋಡಿ. ಇಲ್ಲಲ್ಲ? ಇದ್ರೆ continue. Yes. All right. Next. Post immediately after service of notice upon the second respondent, interim order subsisting shall continue to the next date of hearing.
Lordship, interim order is only for 5 and 6, 4 and 5, my lord. There is no allegation of.
No.
Your lordship,
no, sir. Let the complainant come.
This property belongs to the petitioners, my lord. Therefore, I request before this court.
Already agide order. We'll consider after appearance. Let them appear. Yes.
Date maybe.
Post in admission. Post in admission. Post immediately in admission after the receipt of the notice. So on. Yes. This MMDR.
Forest Act.
Forest Act.
Forest Act.
They use the forest to make road.
ಅಲ್ಲ.
ಮೈನಿಂಗ್ ಮಾಡಕ್ಕೋಸ್ಕರನೇ ಫಾರೆಸ್ಟ್ ಅಲ್ಲಿ ರೋಡ್ ಮಾಡ್ಕೊಂಡು ಹೋಗಿ ಮೈನಿಂಗ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಫಾರೆಸ್ಟ್ ನೋದಲ್ಲಿ.
Yes, sir.
But kindly go through the page number.
ಬಿಟ್ಬಿಡಿ ಆ road ನ.
Kindly go through page number 40 minutes.
I will go through anything. Now, if you have made roads in forest, leave it.
No, Minister, the land belongs to revenue only.
Revenue, na? It does not belong to you anyway.
No.
Does it belong to you?
No, not like that.
Then, yes.
Because Kind of, my lordship, kind of go to page number 41, my lordship.
File your objections.
Gramasthara ಉಪಯೋಗಕ್ಕಾಗಿ
Learned additional SPP seeks 2 weeks time to file statement of objections. List after 2 weeks. Next.
18? 18.
List after 2 weeks. Entry order subsisting shall continue.
Matter, my lord.
ಯಾವ್ದಿದು?
Settlement
ಆಗಿದೆಯಾ?
complaint, my lords, he had received the site and got registered, my lords.
ಆಯ್ತು.
Like,
ಎಲ್ಲಿದೆ
like,
ಸರ್?
like,
Party
this matter, my lord, I may oppose their settlement. my lord.
ಹೌದಾ?
Yes, my lord, because the BDA land,
VDA land.
BDA land.
He is the complainant, my lords, he made the allegation. Now, my lords, he registered the sale.
ನೀವಿಬ್ರು VDA land ನ ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರ?
ಅಲ್ಲ. My lords, the complainant, the accused number 1.
Accused and complainant settle a land does not belong to them.
No, my lords. The land belongs to the accused number 1. My lords, the complainant, my lords.
Merits ಮೇಲೆ ತೀರ್ಮಾನ ಮಾಡ್ಬಿಡಿ. List after 2 weeks. Interim order subsisting will continue.
The interim order was granted because investigation was not done for 2 years.
2 ಅಲ್ಲ, even
5
more.
years.
5 years.
Therefore, my lord, I made a submission last time. DCP has passed an order now. Now, departmental inquiry has been initiated against the persons who are responsible for it.
Correct.
So therefore, my lord, the investigation may continue.
ಆಯ್ತು, let the investigation continue.
Now, the complaint itself, my lords, himself is.
No. Wait, yes.
The reason, my lord, file also been.
ಯಾರ್ದೋ land ನ ನೀವ್ ಹೆಂಗ್ ಸೆಟಲ್
No, my lords, it's not the Abdul land. My lords, the land belongs to the accused number 1, my lords.
Give the investigation papers. ಎಲ್ಲಿದೆ?
No investigation was done. That is the, my lord, last time, my lord,
This
My lords,
is
he is
department inquiry initiate
I
ಮಾಡಿದ್ದೇನೆ.
gave that, last time I had given that.
that is, my lords, inquiry with respect to they have not conducted the investigation.
We'll see.
After the FIR.
List the matter on
have another copy.
next Wednesday in the fresh matters list.
Other copy. my lord.
ಕೊಡಿ ಅದು ಕೊಡಿ. ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎಂಕ್ವೈರಿ ಕೊಡಿ. ಅದನ್ನ ಸುಮ್ನೆ ಪೇಪರ್ ಟೈಗರ್ ಅಲ್ಲ.
ಇಲ್ಲ, my lord. Yes, my lord.
It should result in completion of proceedings and appropriate penalty being imposed.
Yes, my lord.
Yes.
Lordship may observe that also in this order.
That is why next Wednesday in the fresh matters list. Next. MMDR ಯಾವತ್ತಿಗೆ ಹಾಕಿದೀವಿ?
19th.
Yes, Rajan.
Interim order, my lords.
Interim order will extend.
complaint-
ನಾನು ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ extend ಮಾಡಿ.
My lord, complainant has filed a PCR before the trial court, my lord. Trial court dismissed this complainant on the ground that, my lord, he has not followed the guidelines issued in Priyanka Srivastava case, my lord. I have produced all the documents. I filed affidavit. Before filing complaint, I approached the police also.
Where is the order, sir? Impugned order ಅಲ್ಲಿ. Page.
Sorry. Page 24, my lord. 25, my lord.
25. ಎಲ್ಲಿದೆ ಅಫಿಡವಿಟ್ ಇಲ್ಲ ಅಂತ ಡಿಸ್ಮಿಸ್ ಮಾಡಿರೋದು?
Kindly 27, my lord. Page 27 page. Next page. 8 para.
Where is the averment in the complaint?
I have stated.
ನಿಮ್ಮ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ?
Complaint is at page, my lord, 10 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಸರ್.
10.
ಹೌದು.
ಎಲ್ಲಿದೆ ಅವರ್ಮೆಂಟ್?
ಪ್ಯಾರಾ 5 ಅಲ್ಲಿ ಇದೆ ಸರ್. ಪ್ಯಾರಾ 5 4 ಅಲ್ಲೂ ಇದೆ.
ಖಾಸಗಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಹೆಚ್ಚಿನ ಚಿಕಿತ್ಸೆ
4 ಅಲ್ಲೂ ಇದೆ. ಆಮೇಲೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ವಿ. ಐ ಮಾರ್ಕ್ಡ್ ಆಲ್ ದಟ್.
ಫಸ್ಟ್ 154(1) ಕಂಪ್ಲೈನ್ಸ್ ಎಲ್ಲಿದೆ?
ಪ್ಯಾರಾದಲ್ಲಿ ಹೇಳಿದೀವಿ ಸರ್.
ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲಿದೆ?
ಪ್ರೊಡ್ಯೂಸ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
ಹಿಂಗಂದ್ರೆ ಪೇಜ್ ಹೇಳಿ ಸರ್.
ಅಲ್ಲ ಸಪರೇಟ್ ಫೈಲ್ ಮಾಡಿ. ಪೇಜ್ ನಂಬರ್
ಪೇಜ್
10 ಮೇಲೆ 10.
ಪೇಜ್ 10.
ಹೌದು ಸರ್. ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಮಾರ್ಕ್ ಆಗಿದೆ. ಎವಿಡೆನ್ಸ್.
ಇದೇನು CC ಅಂತಿದೆ, ಯಾಕಿದು? 287 of 21, which is that?
ಅದು ಬೇರೆ ಕೇಸಲ್ಲಿ ಇದಾಗಿತ್ತು ಅಂತ ಆಗಿದೆ.
ಬೇರೆ ಯಾವ ಕೇಸಲ್ಲಿ? This is dated 20th September 2000, July 2014.
ಪ್ಲೀಸ್ ಮಾಡಿ.
ಅವತ್ತು ಕೊಟ್ರ ಕಂಪ್ಲೇಂಟ್?
ಇಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದು ನಾವು 30/12/2021.
ಎಲ್ಲಿದೆ ಅದು? Where is that?
ಮತ್ತೆ
This is 29/7/2014, sir.
ಅಲ್ಲ ಪೇಜ್ ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ ಸರ್. ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್.
ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲ. 154(1) your complaint is
kindly see page 11. 23/9/2019. 23/8/2019 ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟು.
23/8/2019
ಪೇಜ್ 11 ಬಾಟಮ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ ಸರ್.
23/8/2019. ಇದು 154(1)
ಹೌದು ಸರ್.
154(3) ಅಲ್ಲಿ
3 ಅನ್ನೋದು ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ
ಎಲ್ಲಿದೆ?
ಪೊಲೀಸ್ ಮಹಾನಿರೀಕ್ಷಕ ಪೇಜ್
ಅದು ಯಾವತ್ತು?
12 ಅದನ್ನು ಕೂಡ
10/2/2021.
21
ಇದೆರಡು CC 287/21 ಅಂತಿದೆ ಯಾಕೆ?
ಯಾವ್ದೋ ಬೇರೆ ಕೇಸಿಂದಾನೆ ಇದ್ ಮಾಡಿದ್ದಾರೆ.
ಬೇರೆ ಈ ಕೇಸ್ ಕೊಟ್ಟಿದ್ದಲ್ಲ
ಈ
ಕಂಪ್ಲೇಂಟ್.
ಕೇಸ್ ಅಲ್ಲ, ಇದ್ರಲ್ಲೇ ಮಾರ್ಕ್ ಆಗಿರೋದು. ಇದ್ರಲ್ಲೇ ಮಾರ್ಕ್ ಆಗಿರೋದು ಸ್ವಾಮಿ. ಅಲ್ಲ, ಇದ್ರಲ್ಲೇ ಮಾರ್ಕ್ ಆಗಿರೋದು.
ಮಾರ್ಕ್ ಆದ್ಮೇಲೆ ಯಾಕೆ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು?
ಅವ್ರು ಆರ್ಡರ್ ಅದು ಫಾಲೋ ಮಾಡಿಲ್ಲ.
CC ಆದ್ಮೇಲೆ ಯಾಕೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು ಕಂಪ್ಲೇಂಟ್ ನ?
ಅದನ್ನೇ ನಾನು ದಟ್ಸ್ ವೈ ಐ ಬ್ರಾಟ್ ದಿಸ್ ಕೋರ್ಟ್. ಇನ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೂ ಹೇಳಿದೀನಿ, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
Why you did not produce all this at the time of filing the petition?
ಫೈಲಿಂಗ್ ಮಾಡಲ್ಲ, ಫೈಲಿಂಗ್ ಆದ ಅವಾಗ್ಲೇ ಕೊಟ್ಟಿರೋದು ಸ್ವಾಮಿ.
ಆಮೇಲೆ ಯಾಕೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಿ?
ಇದು 37/21 PCR ರಿಜಿಸ್ಟರ್ ಆಯ್ತು. ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದು 30/12/23 ರೆಫರ್ ಆಗಿಲ್ಲ. 156 is the matter was not referred for investigation. ಓವರ್ ಆಗೂ ಸೋರ್ಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಐ ಪ್ರೊಡ್ಯೂಸ್ all the documents along with affidavit also. They have recorded source statement, oral source statement also, evidence.
ಅಲ್ಲಿ ಏನು ಹೇಳಿದೆ ಎಲ್ಲ ಇಲ್ಲಿ ಹೇಳಿರ್ತೀರ ಅದಕ್ಕೆ?
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ,
ಏನಿಲ್ಲ,
ಮಾರ್ಕ್ ಆಗಿದೆ ಅಲ್ಲ.
The petitioner is before this court calling in question an order dated 30th December 2023 by which the concerned court rejects the private complaint in PCR 287/2021 on this score that it is not in compliance with the judgment of the apex court in the case of Priyanka Srivatsava versus so and so 2015 6 ACC page 287, as also the judgment subsequently so and so. The petitioner is the complainant. Initially seeks to register a complaint before the jurisdictional police on ಯಾವತ್ತದು ರಾಜು? On
30 ಫೈಲ್ ಮಾಡಿದ್ದು 37/20.
ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲಿ ಕೊಟ್ರಿ?
ಕಂಪ್ಲೇಂಟ್ಸ್
on 23/8/2019. No action was taken and therefore the petitioner invoked subsection 3 of section 154 in registering a crime to the registering a complaint to the higher authority. This was also not taken note of. Therefore the petitioner then invoked the court of the learned magistrate under section 200 of the CRPC by registering a private complaint. The sworn statement is recorded and the proceedings are taken forward for 2 years. And then comes the impugned order rejecting the complaint on the ground that it is not in compliance with Priyanka Srivatsava. Apart from the fact that there is no sanction to prosecute the accused as obtaining under section 197 of the CRPC. The petitioner, this order has driven the petitioner to this court in the subject petition. The learned counsel for the petitioner submits that all the documents necessary for it to be in compliance with Priyanka Srivatsava was placed before the concerned court. The concerned court has ignored all that and has rejected the complaint after taking the complaint to an advanced stage where the matter was pending for close to 2 years. The learned counsel would seek to refer to the documents so produced before the concerned court, all of which would lead to an unmistakable inference that the order of the concerned court is erroneous and is required to be, and the complaint is required to be restored on the file of the concerned magistrate for it to be taken to its logical conclusion. For the aforesaid logical conclusion, in the light of the fact that the complaint was in complete compliance with Priyanka Srivatsava then and the judgment of the apex court in the case of Babu Venkatesh versus State of Karnataka reported in 2022 SSC Online SC page 200. In that, for the aforesaid reasons, the following order allowed, the order quashed, the complaint is restored to file of so and so court and Tharpade, restored to file of so and so court. The concerned court shall regulate its procedure. Yes. Next.
20.
ಇದೆಲ್ಲ MMDR ನಾಳೆ 19th ಅಲ್ಲ? 19th.
20 and 21.
2021 ಎರಡು 19th. Yes. Yes. Next.
22.
489 Suyog. Huh? ಅಕ್ವಿಟ್ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಎಲ್ಲರೂ.
Acquit ಆಗಿದ್ದಾರೆ.
ಕೊಡಿ. ಯಾರ್ಯಾರು ಅಕ್ವಿಟ್ ಆಗಿದ್ದಾರೆ? ಪೇಜ್ ನಂಬರ್, ಪ್ಯಾರಾಗ್ರಾಫ್.
Accused number 1, my lords, 1, 2, 3, 5
One?
and 6. 1, 2, 3, 5 and 6, my lords. have
1
been
minute.
acquitted. A4, my lord, during the.
1, 2, 3, 5 and 6. Your A4 is it?
A7.
A4
Lords, he expired, my lord. Pendency trial. Pending.
ಉಳಿದಿರೋದು ನೀವು ಒಬ್ರೇನಾ?
Page number 69 and 70, my lords, paragraph 76 and 77.
ಒಂದು ನಿಮಿಷ. 69, 70.
Paragraph 76 and 77.
Sir, that is operative portion. Reasoning ಹೇಳಿ.
ಅಲ್ಲ, reasoning ಅಲ್ಲೇ ಕೊಡಿ. 76 and 77.
Yes, the petitioner, accused number 7, is knocking at the doors of this court, claiming parity with the order of acquittal passed in favor of accused number 1, 2, 3, 5 and 6. The heard words. The petitioner, along with others, gets embroiled in a crime of circulation of fake notes of 200 and 500 rupees, and therefore becomes an offence punishable under 489C, D, E and 420 read with 120B of the IPC. The police conduct investigation and file a charge sheet, and the matter was tried before the concerned court. At the relevant point in time, the petitioner, accused number 7, was not available for trial. The concerned court split the case against the petitioner in CC 654 of 2011 and sought to try the petitioner separately. The concerned court, i.e. the Court of Session, in terms of its order dated 26/5/2015, acquits accused number 1 to 3, accused number 5 and 6. Accused number 4 died during the trial. The lone accused who is left in the proceeding is accused number 7, the present petitioner. The case against the petitioner is now sought to be tried as SC 40 of 2024. It is therefore he is before this court in the subject petition. The learned counsel appearing for the petitioner would vehemently contend that the reason so rendered to acquit all the other accused would inure to the benefit of the petitioner, and continuance of further trial would become contrary to law. The learned HCGP would, however, refute the submission to contend that the petitioner has escaped trial. If to a person who has escaped trial, this court should not show an indulgence, and the petitioner should come out clean like other accused who have come out clean in a full-blown trial. I have given my anxious considerations also. The afore narrated facts are not in dispute. The accused getting embroiled in a crime for circulation of fake notes or counterfeit notes is a matter of record. The other accused 1 to 3, 5 and 6 get acquitted by the order of the Court of Session dated 26th May 2015. The reasons so rendered to acquit the said accused can be gathered from paragraphs 69 to 69 other 76 and 77. ಅದು ಕೋಟ್ ಮಾಡ್ಬಿಡಿ. They read as follows. If the reasons so rendered is to acquit the others are perused, it would undoubtedly become applicable to the case of the petitioner as well. The petitioner, though, has escaped trial and was not available at the relevant point in time, permitting further trial against this petitioner in SC 40 of 2024 who would eventually get acquitted of the offense on the same reason would be a waste of precious judicial time. In that light, notwithstanding the vehement opposition of the learned HCGP, I deem it appropriate to quash the proceedings in SC 40 of 2024 on the score that all other accused have been acquitted in the trial for the aforesaid reasons also.
Combination of 500. Only denomination of 500 rupees. The lordship said, my lords,
200 and 500 ಅಂತಿದೆ?
To 200 note, my lords.
Oh, sorry, 200 ಮಾತ್ರ. Yes.
23.
Istanbul. Is there a secure number one, my lord? Yes, my lord, section 417, 424,
It is sought for IO papers in this. Lordship sought for IO papers in this case.
last date of hearing.
The petitioner, my lord, being the brother and mother of the respondent number 2, they have forged his signatures and then
Yes.
the property belongs to him has been given to.
All right, let the complainant come.
My lord, kindly press page number 35, please, ma'am.
Yeah, no.
It's affidavit and compliance affidavit. The trial court. of-
Priyanka Srivatsavana.
No, no, not.
ಮತ್ತೆ?
Third to obtain signature of the respondent. The notary.
Signature of respondent. ಯಾವುದಕ್ಕೆ?
Number 2, my lord.
ಯಾವ ಸಿಗ್ನೇಚರ್?
Page number 35, respondent number 2 signature. It was not a without signature. Further complaints affidavit also.
We'll see, get the records.
Please.
The learned HCGP is directed, the registry is directed to secure the records in PCR 4394 of 2023 by the next date of hearing. List on Wednesday in the fresh matters list.
Till then,
No, sir.
please,
ಸ್ವಲ್ಪ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು,
Please,
ರೆಕಾರ್ಡ್ಸ್
please.
ಬಂದ್ರೆ ಏನ್ ಮಾಡ್ತಾರಲ್ಲ?
please,
ಇಂಡೈರೆಕ್ಟ್ ಎಂಟ್ರಿ ಮಾಡೋದಲ್ಲ.
please.
24.
I'll try to get some authority, my lord. I'll try to get,
Any amount of trial will not, let the trial begin.
I'll try to get some authority.
I told you,
Before
madam,
it-
you can't show the prime minister so light. I will not
To me, it is
entertain such
66
things.
A, my lord. According to me, it is 66 A of IT Act.
According to you,
I'll try.
I will write the judgment, you take it.
Yes, my lord. Before that, anyway, I'll try to get some authority.
List the matter on 27th for further hearing. It is made clear pendency of this petition will not come in the way of the trial before the concerned court.
So there is no stay.
ಅದು ಅದಕ್ಕೆ
There's no-
ಪೆಂಡೆನ್ಸಿನೂ ಅಲ್ಲಿ ತೋರಿಸ್ಬಾರ್ದು ಅಂತ ಅಷ್ಟೇ. Yes, next.
25.
List on 20th.
7A of the PC Act.
20th, yes.
Accused number 1.
ಏನು?
FIR against accused number 1 has been watched by your lordship.
Washed against accused number 1.
1.
ಯಾವುದು?
Petitioner is driver of the accused number 1.
I told you Supreme Court ಏನಾಗಿದೆ ನೋಡ್ಕೊಂಬನ್ನಿ ಅಂತ ಕೊಡಿ.
Order passed by your lordship has been upheld by this.
Upheld? Yes. Note, ಎಲ್ಲಿ ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು?
Notice.
ನೋಟಿಸ್ ಆಗಿಲ್ವಾ? Learned counsel B.B. Patil is directed to accept notice for the first respondent, emergent notice to the second respondent. Que accused number 1, this court had quashed the proceedings in criminal petition 4807 of 2022. You are the driver, 2020. You have received the money.
ಹೇಳಿದ್ರು
ಅಲ್ಲ, ಅದು ಬೈಂಡಿಂಗ್ ಇರೋದೇ ಅದು. It will not be applicable to you.
ನಾನು ರಿಸೀವ್ ಮಾಡಿಲ್ಲ, ನನ್ನ ಜೊತೆಗೆ ಬಂದು ಕೊಟ್ರು ಅಂತ.
Whatever, yes. So and so. We accused number 1 question. The said order was tossed by the complainant before the apex court in SLP 15276 of 2023, which comes to be rejected on 30th April 2024. In that light, till the next date of hearing, there shall be an interim order of stay of further proceedings qua the petitioner. List the matter on 27th. Yes.
26.
Both matter concerning 3 and 7 of Essential Commodities Act, my lord. Essential Commodities
Both
Act.
ways.
My lord, in first matter, accused number 4, my lord, allegation is that at page para 20, my lord. 1, 2, 3 were seized at the spot, my lord. Accused number 4.
The FSL ಕಳ್ಸಿದ್ರಾ?
The FSL has been.
ಏನ್ report ಏನು?
My lord, that could be at page number 45, my lord. Hence, it can't be determined that the seized bag belongs to Anna Bhagya Yojana or meant for public distribution.
1 minute. Hence, it cannot be determined that the seized bag belong to Anna Bhagya Yojana or meant for PDS. Yes. दाने दाने पे लिखा है PDS का नाम. ಆಗಲ್ಲ ಇವೆಲ್ಲ. Yes. the offense in the case at hand are the ones punishable under section 3 and 7 of the Essential Commodities Act. The rice that was seized from the hands of the petitioners was subjected to forensics by the FSL. The FSL report reads as follows, page 45. The report is clear that the rice that is seized cannot be determined to be belonging to Annabhagya Yojana or meant for PDS. In that light, the justification of the petitioner that it was procured in the open market stands to reason. Therefore, there shall be an interim order of stay of all proceedings in CC 5592 of 2023 till the next date of hearing. List the matter on 26th.
My lord, in second matter, my lord, it has been subjected to FSL, but the report has not been annexed to charge sheet, my lord.
The report.
Report has
Same order ಮಾಡಿ.
second matter.
ಅದು ಎರಡು connected ಮಾಡ್ರಿ. Report ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ. Yes. ಜಗದೀಶ್ ಅವರೇ, FSL ಕಳಿಸ್ತಿರಲ್ಲ, ಅಕ್ಕಿ ಮೇಲೆ ಬರ್ದಿರುತ್ತಾ PDS ಅಂತ.
Only reason, my lord, that FSL is being sent because I believe one of the
Whether it is rice or not ಅಂತ.
coordinate bench judgment, my lord, says that it has to be determined by FSL.
ಇಲ್ಲ, how do you determine rice that it belongs to PDS or otherwise? ಅದ್ರ ಮೇಲೆ ಏನಿರುತ್ತೆ?
Only if they have a sample, take that sample and compare the sample with that is the only way it has to.
ಅದಕ್ಕೆ ದಾನೆ ಪೇ ಏನಾರು ಇದೆಯಾ ಅಂತ ಹೇಳಿ. PDS ಕನ. Okay, anyway, yes.
87.
The acid case, my lords. Petitioner 1 and 2 are withdrawn. As against petitioner 3, my lords have directed the respondent 2 to verify what are the allegations.
Yes, sir.
My lord,
3 ಮೇಲೆ ಏನಿಲ್ವಲ್ಲ. 1 and 2 horrendous, he has withdrawn.
3 ಮೇಲೆ ಅವರು ಇನ್ಸ್ಟಿಗೇಟ್ ಮಾಡಿದ್ದಾರೆ, ಸ್ಪಾಟ್ ಅಲ್ಲಿ ಇದ್ರು ಇನ್ಸ್ಟಿಗೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಇದೆ.
ಇಲ್ಲ, ಮೇಲ್ಗಡೆ ಫ್ಲೋರ್ ಅಲ್ಲಿ ಇದ್ರು.
ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್, ಅದ್ರಲ್ಲಿ ನಾವು ಎಲ್ಲೂ ಕೊಟ್ಟಿಲ್ಲ, ಅದೆಲ್ಲೂ ಹೇಳಿಲ್ಲ.
ಆಯ್ತು, ಎನಿವೆ ಇನ್ಸ್ಟಿಗೇಷನ್ ಅಷ್ಟೇ ಅಲ್ವಾ?
ಮೈ ಲಾರ್ಡ್, ಅವ್ರಿಗೆ ಯಾವಾಗ್ಲೂ
ಇನ್ಸ್ಟಿಗೇಷನ್ ಅಷ್ಟೇ ತಾನೆ?
ಇನ್ಸ್ಟಿಗೇಷನ್ ಇದೆ.
ಇಲ್ಲಿ ಹಿಯರ್ ಇಟ್, ಬಟ್ ಇಂಟರ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ.
ಇಲ್ಲ,
ಕೊಟ್ಟಿಲ್ವಾ?
82 my lord.
That purpose only it was adjourned, my lords, for today.
All right.
My lord, page number 82.
82, yes.
ರಿಕ್ವಿಷನ್ ಮಾಡಿದ್ರು ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆ.
ಏನ್ ರಿಕ್ವಿಸಿಷನ್?
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಟೈಮ್ ಅಲ್ಲೇ 307 ಇದಾಗಿತ್ತು ಮೈ ಲಾರ್ಡ್.
ಅವ್ರ ಮೇಲೆ 1 and 2 ಮೇಲೆ ಬಿಟ್ಬಿಡಿ. He has withdrawn those petitions, trial will go on.
All the accused ಮೇಲೆ.
Instigation we will not permit 307 to go on. Yes.
ಆಲ್ಸೋ ಪಂಚನಾಮದಲ್ಲಿ 2 CCTV ಇದೆ ಮೈ ಲಾರ್ಡ್. ಅವ್ರ ಮನೇಲಿ ಇದ್ದ CCTV ರಿಮೂವ್ ಮಾಡಿ ಹೊಸದ್ ಹಾಕಿದ್ದಾರೆ.
ಅದೆಲ್ಲ 1 and 2 ಮೇಲೆ ಆಯ್ತು. I have not stayed against them. I will clarify. This court on 2/9/2024 had passed the following order. The learned counsel for the second respondent would, on going through the papers, submit that the allegation against the third accused, the third petitioner herein, is only instigation. In that light, the offense or ingredients of the offense under section 307 inter alia cannot be laid against the accused number 3, the petitioner number 3. Therefore, the further proceedings qua accused number 3 shall remain stayed. It is made clear that the petitioners 1 and 2, accused 1 and 2, have withdrawn the petitions. The trial against those 2 accused shall not be stalled on the score that the present petition is pending before consideration qua accused number 3 before this court. Yes. Ilda idin ತೋರಿಸ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಟ್ರಯಲ್ ನಡೆಯಲ್ಲ. Yes, next.
Please, my lords. 28 and 28.1 are the accused number 1 and 2 in this matter.
My lord, I need some time to file my objection.
ಏನಿದು?
My lords, the allegation is that under section 207, I have disobeyed the summons issued to me. The complaint itself said that summons was not served on me. When it was not even served on me, how can I disobey it?
All right. Not served on you ಅಂತ ಹೇಳಿದೆ.
Complaint says, my lords. Complaint. Para 6 of the complaint, page 29.
Page
29. Para 6, page 29, the second half, my lords. A copy of the summons is enclosed as annexure E.
1 minute, sir. Where does it say that it was not served?
A copy
the summons were returned undelivered with postal endorsement left. The accused did not attend the proceedings, so and so. How do you interpret the postal endorsement left?
I have changed my address. So subsequently, show cause notice is issued to me. That show cause notice
that changed address was, they were aware of it?
They were not aware of it. They were made subsequently aware of it. By way of, when the show cause notice was issued to me, I replied, that show cause notice came to be forwarded to my new address. When I forwarded and I filed a reply to that.
If you are aware of it, then if you have not heard him,
No, my lord. I was aware.
if they were aware of it.
May I make one submission? This copy is served to me yesterday. I've got instructions now. The officer has come to give instructions.
All right.
Your Lordship, the matter is posted on 19/9 before the trial court.
All right.
I'll file my objections on 18th.
I'll take
by
it on,
18th.
I'll take it on 18th in the fresh matters.
I'll file it.
At the request of learned DSGI Shanti Bhushan, who seeks time to file statement of objections, list the matter on 18th in the fresh matters list.
Straightforward.
Next.
29.
My lords, my application for number 311 has been rejected.
311. Yeshne application.
My lords, only one. Second application, please. My lords, earlier.
Offense.
Offense 307, please.
We'll allow it. The petitioner is before this court calling in question an order dated 29/7/2024 passed in SC 64 of 2019 by which the application of the petitioner filed under section 311 of the CRPC comes to be rejected. The petitioner The petitioner, along with other accused, gets embroiled in a crime number 105 of 2018 for the offense punishable under section 307 of the IPC 307. Column number 2 only there, madam. All the offenses. 307, so and so. 307 ilva?
307.
307 of the IPC. The police conduct investigation and file a charge sheet, and the matter is pending as SC 64 of 2019. The issue in the list does not relate $84. ಏನಾಗ್ಬೇಕು?
Next.
Enter ಮಾಡಿದ್ಯಾ? Admission, I don't know. I may not be able to take. We'll see. Will adjourn. ಬೇರೆ ಡೇಟ್ ಕೊಡ್ತೀನಿ ನಾನು. ಯಾವಾಗ? ಆಫ್ಟರ್ ಫೈಲಿಂಗ್ ದಿ ಪೆಟಿಷನ್, ಬಿಫೋರ್ ಫೈಲಿಂಗ್? ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆ ಅಂತಲ್ಲ, ಗೊತ್ತಿಲ್ವಾ? ನೀವು 84 ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆ ಅಂತ. ಆಯ್ತು, ಸೊ ವಿಲ್ ಸಿ when the matter is called, will adjourn. Yes,
133 my lord. Compromise.
Number 9, my lord. Matter was reserved for orders, my lord. That matter, my lord, the misleading statement was made that no amount has been transferred to one Sachin's account.
Don't worry about
project
that.
director is Sachin, but this amount has been transferred to somebody in Bombay for the purpose of some work.
No, I did not get swayed by that.
My lord,
Don't
there
worry
are two
about
things,
that.
my lord. One, that statement, my personal, my lord, account statement has been, my lord, in the hands of the complainant. That is through, my lord, police they got appears to be, my lord.
All that I'm not.
Therefore, we wanted to clarify that, my lord, no amount has been transferred.
I would not have written about that also. Don't have to worry.
That is one thing.
Brasa. brass, bronze, same. Now I will consider that. Don't worry. If you don't assist technically, I will read and then do it. Not a problem. Huh? Don't worry. I will not get confused.
130, compromise, madam. Small baby, 1 month.
Small baby.
1 month baby.
Karbidi. Offense ಏನು?
420, 66, information technology.
Get first. Serial number?
133.
133.
133, my lord.
ಶ್ರೀನಾಥ.
Srinath.
ನಿಮ್ಮ ಹೆಸರಾ?
ಹೌದು.
ನಂಜುಂಡೇಗೌಡ ಅಲ್ವಾ?
ನಮ್ಮ senior, madam.
Sorry. Learned counsel so and so undertakes to enter appearance for the respondent registry to print the name of so and so as appearing for the respondent. ಆಮೇಲೆ the petitioners, madam, 406, 420.
Malay.
ಇದರಲ್ಲಿ ಅಕೌಂಟ್ ಫ್ರೀಸ್ ಮಾಡಿದ್ದಾರಾ?
Account freeze, madam. Kindly direct.
ಒಂದು ನಿಮಿಷ. ಬರೀ ಇಲ್ಲಿಂದ ಇಲ್ಲಿಗೆ ಮಾತ್ರ ಮಾಡಿ. ಪ್ಯಾರಾ 3 ಇಂದ ಇಲ್ಲಿವರೆಗೆ ಸೆಟಲ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿ. Pursuant to the registration of the crime, the investigating officer has directed freezement of several accounts of the petitioners. They are 13 in number. In the light of the settlement arrived at between the parties, all consequential action that is taken by the investigating officer would all be rendered a nullity. This court is coming across cases where the matter is again being moved on the score that the investigating officers, after the matter being settled and the crime quashed, are not directing defreezement of the accounts. Therefore, I deem it appropriate to direct the investigating officer to direct defreezement of the accounts that have all been frozen pursuant to the registration of the crime, which is now settled and the crime itself obliterated for therefore disposed, quashed. In the light of the first. ಮತ್ತೆ ನೀವು being spoken to ಮಾಡ್ತೀರಾ? ಎಲ್ಲರೂ ಮಾಡಲ್ಲ. For extraneous reasons, you should not do it, sir. Crime ಇಂದ ರಿಜಿಸ್ಟರ್ ಆಗಿದ್ರೆ ಹೋಗ್ಬೇಕಲ್ಲ. ನಿಮ್ದು ಸ್ಮಾಲ್ ಮಗು ಇದೆಯಾ? ನಿಮ್ದು ಮಗು ಇದೆಯಾ? ಇರಿ. ಎಸ್. ಹೌದೇನು 1 month ಚೈಲ್ಡ್ ಇದೆ ಅಂತ ತಗೊಂಡ್ರೆ ನೀವು ಅಲ್ಲೇ ಆಂಬ್ಯುಲೆನ್ಸ್ ಇಂದ ಹೋದಂಗೆ ಹೋಗ್ಬೇಡಿ.
ಸೆಟಲ್ಮೆಂಟ್ petitioners has breast cancer ದಲ್ಲಿ patient settlement ಇದೆ ಅದೊಂದು ಮ್ಯಾಟ್ರಿಕ್ the patient is the patient petitioner one
where is online is it?
ಇಲ್ಲ ಸ್ವಾಮಿ ಈಚೆನೆ ಇದ್ದಾರೆ
ಕರೆದ್ಬಿಡಿ.
serial number 34
34 ಏನು 498 then get serial numbers, madam. 34 ಆಮೇಲೆ 233. Sorry, sir.
the 2 FR madam.
Who is suffering from cancer?
Mother of the petitioner, right? In petition 1004 and
ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ
ಎರಡಲ್ಲೂ ಆಗ್ತದೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
ಕೊಟ್ಟೆ just
ಕೊಡಿ ಮೇಡಮ್. Madam, 320 application, 498 offense. Affidavit, ಈ 2 page ಮಾತ್ರ ಅಷ್ಟೇ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಎಲ್ಲಿದ್ದಾರೆ?
ಸ್ವಾಮಿ ಅವ್ರು ಬಂದಿಲ್ಲ. ಅಪೇರ್ ಆಗ್ಲೇಟ್ ವಕಾಲತ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು.
ವಕಾಲತ್ ನಿಮ್ ಕೈಗೆ ಕೊಟ್ಬಿಟ್ರಾ?
ಬೇರೆ ಕೊಟ್ಟಿಲ್ಲ.
ಆಮೇಲೆ ನಾನು ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ?
ಇಲ್ಲ ಶೀಸ್ ಹಿಯರ್ ಓನ್ಲಿ.
ಹೂ ಅವರು ಕೊಟ್ಟಿದ್ದೀರ? ಯಾರು ವಕಾಲತ್ ಯಾರು ಹಾಕಿರೋದು?
ಇಮ್ರಾನ್ ಜಿ ಅಂತ.
ಅಲ್ಲ ಮೇಡಮ್, ಅಮರ್ ಕೊಡಿ ಅವರು. ಇಲ್ಲ ಇದ್ರಲ್ಲ ಅವರು. ಯು ಫೈಲ್ಡ್ ವಕಾಲತ್ 129 ಮೇಡಮ್ ಅದು? ಇಲ್ಲ
34 ಮೇಡಮ್.
ಎನಿವೇ ಎಸ್ ಇದು ಕೊಟ್ಟು ಮಾಡಿ. so and so enters appearance for the respondent ಅಂತ ಮಾಡಿ. ರಿಜಿಸ್ಟ್ರಿ ಟು ಪ್ರಿಂಟ್ ದಿ ನೇಮ್ ಆಫ್ so and so. ಎಲ್ಲಿ ವಕಾಲತ್ತಲ್ಲಿ? ಕಾಮನ್ ಮಾಡಿ, 2 ಕಾಮನ್. ಒಂದರಲ್ಲಿ ಹಸ್ಬೆಂಡು, ಒಂದರಲ್ಲಿ ಪೇರೆಂಟ್ಸ್. ಎಸ್. Yes, Amar, you have entered appearance. In matter is moved for 2:30 on account of a settlement. Your wakalat is there.
129, we have moved for settlement.
Hello, 120, 1004 of 2023.
Criminal petition.
Praveen Begum and others.
No, not much.
ಇಲ್ಲೇ ನಿಮ್ದು ತೋರಿಸ್ತಾ ಇದೆ ಇಲ್ಲಿ.
For respondent, it is for me to check.
Then Imran J ಅಂತ ಯಾರ ಕೊಟ್ಟಿದ್ದಾರೆ? How is that?
For a fresh petition, older petition, the 1004, the other council has filed a wakalat. He sent one more colleague today. Imran Ji is filing on behalf of.
ಅದೇಂಗಾಗತ್ತೆ? What is all this? Settlement ಅಲ್ಲಿ ಗಡ್ಬಡಿಲ್ ಮತ್ತೆ don't get into problems.
Everything is.
I will recall the order then.
Everything is clear, my lord.
Yes. ಅದು so and so enters.
Marriage is also dissolved.
In place of Amar Korea ಅಂತ ಹಾಕ್ಬಿಡಿ, ಅವ್ರು ಯಾಕಿರ್ಬೇಕು? In place of Amar Korea, register to print the name of so and so and delete the name of Amar Korea. ಹಾಕಿದ್ದಾರೆ ಇವರು.
Gangadhar is.
ನೀವು ಶ್ರೀದೇವಿ ಎಲ್ಲರದು ಇದೆ.
Check.
What is this? Settlement ಆಗ್ತಾ ಇರೋದು. Should I print your name or not? Tell me.
We are of 129 for settlement.
129 Allah. This is moved at moved 2:30, serial number 1004, where Amar Korea, Sridevi Bhosle, and Ramachandra Shanai.
Ramachandra is calling. Your colleague. Your colleague.
ಅವರೇ ವಕಾಲತ್. ಅವ್ರು ಹಾಕಿರ್ಬೇಕು.
He only sent Imran. Ramachandra only sent Imran.
ಅವ್ರದ್ದೇ ಹಾಕಿ ಮೇಡಮ್, ಅದ್ ಮಾಡಬೇಡಿ. Don't print Amar Korea only. ಹಂಗೆ ಇರಲಿ. Yes.
Colleague is there. He says that another colleague of mine.
ಆಯ್ತು ಶ್ರೀದೇವಿ ಮೇಡಮ್, look into it. What is it? Settlement. ನೀವು ಒಬ್ಬೊಬ್ರು ವಕಾಲತ್ ಹಾಕೋದು ಗೊತ್ತಿರೋದೇ ಇಲ್ವಾ? Yes. All right, settle. ಮೇಡಮ್ ಅದು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡೋದು ಅಷ್ಟು ಮಾತ್ರ ಮಾಡಿ. ಇದು serial number 1 in 230 mood matter plus 34 common order.
106.
ನಿಮ್ಗೂ ಏನಾದ್ರು ಹಾಸ್ಪಿಟಲೈಸೇಷನ್ ಪ್ರಾಬ್ಲಮ್ ಇದೆಯಾ? ಆಂಬ್ಯುಲೆನ್ಸ್ ಇಂದ ಹೋಗ್ಬೇಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅವಾಗಲೇ, ಸುಮ್ಮನೆ ಇರಿ. ಬರ್ಲಿ. ಎಸ್. ಆರ್ಡರ್ಸ್ ಇಂಟರ್ಲೋಕೇಟರಿ ಮುಗಿಸ್ಬಿಟ್ಟು ವಿಲ್ ಗೋ 230 ಮ್ಯಾಟರ್ ವಿಲ್ ಟೇಕ್. ಐ ವಿಲ್ ಫಿನಿಶ್ ಆರ್ಡರ್ಸ್ ಅಂಡ್ ಇಂಟರ್ಲೋ. ವೇರ್ ಇಸ್ ದ ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್? ಟೇಕ್ ದಟ್ ಮ್ಯಾಟರ್. ಬಂದಿದೆ ಮೇಡಮ್. ಎಸ್ ಮಿಸ್ಟರ್ ಐಒ, FSL ಅಲ್ಲಿ ಏನ್ ಬಂದಿದೆ ರಿಪೋರ್ಟ್ ನೋಡಿದ್ದೀರಾ? FSL
ನೋಡಿದ್ದೀನಿ.
ಇಲ್ಲ ಬ್ಲೈಂಡ್ ಆಗಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರ?
ನೋಡಿದ್ದೀನಿ.
ನೋಡಿ ಏನಿದೆ FSL ಅಲ್ಲಿ?
ನಾಟ್ ಡಿಟೆಕ್ಟೆಡ್ ಅಂತ ಇದೆ.
ಮತ್ತೆ ಯಾಕೆ ದೃಢಪಟ್ಟಿರ್ತದೆ ಏನ್ ಬರೀತೀರಾ? ವೈ ಯು ನೋ ಸೆನ್ಸ್? ಅದು ಇಟ್ಸ್ ನಾಟ್ 406, 420 or non-cognizable offense, NDPS. How do you pin down this accused contrary to the FSL? ಹೆಂಗ್ ಬರದ್ರಿ ಅದನ್ನ? FSL ಅಲ್ಲಿ ನೆಗೆಟಿವ್ ಅಂತ ಬಂದ್ಮೇಲೆ FSL ದೃಢಪಟ್ಟಿರ್ತದೆ ಅಂತ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ತಿರಲ್ಲ. ಹೌ ಇಸ್ ಇಟ್? We will direct departmental inquiry to be initiated against you if you are playing with these people.
ಸೊ ತಪ್ಪಾಗಿದೆ ಸ್ವಾಮಿ.
ಏನ್ ತಪ್ಪಾಗಿದೆ? Contrary to FSL report ಹಾಕಿ, they will be inside. They may be involved in any crime. That is not the issue. In this crime, when the FSL straight away says that it is negative, there is no contraband substance found, how did you say ದೃಢಪಟ್ಟಿರುತ್ತದೆ ಅಂತ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ತೀರಿ? Should not an inquiry be conducted against you?
ಒಂದು ಬಾರಿ ಕ್ಷಮಿಸಿ ಸ್ವಾಮಿ, ಮುಂದೆ ಈ ತರ ತಪ್ಪು ಮಾಡ್ಕೊಳ್ಳೋದು.
ವಾಟ್ ಇಸ್ ದಿಸ್? ನೀವು ಹೆಂಗಂತ ಇದ್ದೀರಾ? ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ ಸರ್ವಿಸ್?
7 ವರ್ಷ ಆಯ್ತು.
ಐಒ ಎಷ್ಟು ಕೇಸಲ್ಲಿ ಇದ್ದೀರಾ
ಸ್ವಾಮಿ? ಈಗ ಪ್ರೆಸೆಂಟ್ ಒಂದು 15 ಕೇಸ್ ಇದೆ ಸ್ವಾಮಿ.
15 ಕೇಸ್? ಅವ್ರ ಗತಿ ಅಷ್ಟೇ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಆ ತರ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ ಸ್ವಾಮಿ, ಆ ತರ ತಪ್ಪು ಮಾಡ್ಕೊಳ್ಳಲ್ಲ ಇನ್ನು.
Yes, we'll have to quash this.
But small quantity of drugs was seized. This is part of the record.
Drugs were seized, is sent to FSL, it does not find,
What is sent to FSL is a blood sample.
correct.
The blood sample says consumption.
Where is your Panchnama saying that 15 grams of ganja was seized from them?
Page number. It is. Page number 19 ಅಲ್ಲಿ.
is not followed. That is different. Seize ಮಾಡಿದ್ದು ಏನ್ ಮಾಡಿದ್ರಿ?
ಅದನ್ನ ಹಂಗೆ ಕಳಿಸಿ.
ಯಾಕೆ ಸೆಕ್ಷನ್ 50 ಫಾಲೋ ಮಾಡಕ್ಕೆ ಏನಾಗಿತ್ತು?
ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ಲ. Another illegality.
ಅದನ್ನ ಇವ್ರು ಮಾಡಿಲ್ಲ, ಬೇರೆಯವ್ರು ಮಾಡಿಲ್ಲ.
At your whim and fancy, you conduct investigation, no procedure is followed, just because it is NDPS. ಸ್ಯಾಂಪಲ್ ಏನ್ ಮಾಡಿದ್ರಿ? ರೀಸೈಕಲ್ ಮಾಡಕ್ ಹಾಕಿದ್ರ ಇನ್ನೊಂದ್ ಕೇಸ್ಗೆ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದನ್ನ ಬೇರೆ ಐಒ ಮಾಡಿರೋದು.
ನಿಮ್ ಮೇಲೆ ಹೇಳಿಲ್ಲ, ಸುಮ್ಮನೆ ಇರಿ ನೀವು. 15 ಗ್ರಾಮ್ ಸ್ಟಾಕ್ ಇರ್ಲಿ ಯಾವಾಗ್ಲೂ ಅಂದ್ಬಿಟ್ಟು ರೀಸೈಕ್ಲಿಂಗ್ ಬೇಕಾಗತ್ತೆ ಅಂತ ಅಲೇಟ್. Why did you not take that seizure and place it before the magistrate in section 50? This is precisely why Supreme Court says you'll recycle everything.
Anyway, it is a small quantity. They should have sent everything to the FSL.
Yes.
They could have done that, sent it to everything to the FSL.
Wholesale procedural aberration.
Both the investigation officer in this case have misled.
Yes. Will pass orders. Allowed cost. ಇವ್ರ ಮೇಲೆ ಡಿ-ಇನಿಷಿಯೇಟ್ ಮಾಡಕ್ ಹಾಕೋಣ.
ಇವ್ರ ಮೇಲೆ TW1 ಮೇಲೆ ಮಾಡ್ಬೇಕು.
ಯಾರ ಮೇಲೆ?
TW1.
The other investigating officer.
Because he only filed the charge sheet.
ಯಾರು?
This person.
Investigating officer.
Done by CW.
SHO na.
He's an.
All right.
TW1 is the.
Yes. Allowed cost on both the grounds, 50 and the investigating officer. Yes. ನೋಡಿ.
ಇಲ್ಲಿ ಅವನು ಪ್ರೊಬೇಷನರಿ ಅವನು. ಅವನು ಪ್ರೊಬೇಷನರಿ.
ಯಾರು?
ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟವನು.
ಪ್ರೊಫೆಷನಲ್.
ಪ್ರೊಬೇಷನರಿ.
ಯಾರು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದ? The officer in charge of police.
The person who registered this, person who filed the complaint, conducted a Mazar and filed a complaint, is a probationary.
ಯಾಕೆ ನೀವು ಟ್ರೈನಿಂಗ್ ಕೊಡಲ್ವಾ? His probation is declared to be satisfactory. Yes, we'll see. For what? Traveling abroad, yaar. Parvalla. You can go the whole hog, wait. Yes. Our permission, yaar. Yes, ask him to leave.
Discontinued orders in number 50.
Appear for the petitioners in this matter.
Sufficiency of service. The report indicates that the wife of the complainant has received the notice on the complainant's behalf, registry to print the name of the complainant and show her as served. Entry ಮಾಡಿದ್ಯಾ?
Entry ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ, that's why I'm.
List on Tuesday in the fresh matters list.
Much of that.
Yes, next. Impleading ಏನು?
Impleading ಇದ್ರಲ್ಲಿ ಏನಾಗಿತ್ತು ಅಂದ್ರೆ ಸ್ವಾಮಿ, ಕಂಪ್ಲೇಂಟ್ seized the wife na
implead notice ಆಗಿದೆ ಅದರ ಮೇಲೆ.
ಅದಾಗಿದೆ ಸ್ವಾಮಿ, emergency notice.
Then let it come. Post immediately after service of notice upon the impleading applicant.
25ನೇ ತಾರೀಕಿದೆ. A day or two, couple of days early.
We'll see. Or on the 24th, whichever is earlier.
Much of it.
Extension receipt. ಏನ್ ಗಂಗಾಧರ ಸರ್? ನಿಮ್ದಲ್ಲ ಬಿಡಿ extension.
Lord's petition was dismissed with a direction to dispose of the matter within 6 months. Unfortunately, courts were changed. It was addressed before the trial court in two different.
Disposed the subject petition in terms of the order dated 28/7/2023, directing its disposal within a period of 6 months from the date of receipt of the copy of the order. A communication is sent from the hands of the concerned court seeking extension, seeking 3 more months' time to dispose the matter. though the request so made is not justified, in the interest of justice, I deem it appropriate to direct the concerned court to dispose the subject petition, dispose CC 4142 of 2016 within an outer limit of 30th November, as on or before 30th November 2024. An application of the kind, if again made, would be viewed seriously. A communication of the kind.
Much obliged.
Next. Amendment ಮಾಡೋದು ಕಷ್ಟನಾ?
Carry out amendment.
A week's time to do the needful. Next. In terms of same, in terms of 55 or same.
With regard to service of copies, it's already served the copies to the other side. It's 498A.
Next week, my lord, they are.
Learned counsel for the petitioner submits office objections have been complied with. List the matter on 24th.
17th.
Okay.
Some urgency in this man.
ಏನು urgency?
498A.
ಅದು ಬಿಟ್ಟು ಏನು urgency?
But the petitioner has to, it's gone to Pune. It's already transferred.
Pune?
Yeah, Pune.
ಪರವಾಗಿಲ್ಲ ಬಿಡಿ.
ಅಲ್ಲ, ಇಲ್ಲಿ ಏನಾಗುತ್ತೆ regular interim order granted earlier may be extended.
Interim order ಇದೆ ಅಲ್ವಾ?
ಇದೆ.
Interim order subsisting shall continue till the next date of hearing. Traveling abroad ಅನ್ಲಿಲ್ವಲ್ಲ ಪುಣ್ಯ?
ಅಲ್ಲ, ಅದಕ್ಕೂ chances.
Okay.
I am appearing for the petitioner in this matter, my lord.
Office objections. Don't open the file. Office objections ಏನು?
My lord, so the office objections of.
I filed objection to the main petition, my lord. Last occasion it had come. Subsequent to that, this office objection is read.
Interim order ಇದೆಯಾ?
There's no interim order, my lord.
That's why you're dodging with the objections. I will grant an interim order
Lord,
now,
the only allegation.
because you have not complied with the objections.
My lord, last occasion, I filed objection. Subsequent to that, office objection has been
I
raised.
list them.
My lord, the only allegation
Copy.
against.
Additional SPP copy serve ಮಾಡಿಲ್ಲ.
Hello, sir.
ಯಾವಾಗ?
Copy is already served.
Not to him.
For the state. I will serve.
Office objections become office objections by the respondent be complied with by the next date of hearing, 18th.
My lord, sir.
Yes.
Interim order, my lord. Sir.
ಹೀಗಿದೆಯಾ?
Because no, there's no interim order.
There is no interim. 18th. In terms of
58.
withdrawal.
Withdrawn. With the liberty to file the.
ಈ ಮೆಮೊಲ್ ಏನ್ ಹೇಳಿದಿರಾ ಅದು? If you have not told anything, nothing.
For petitioner.
SOB. Copy not served, serve ಮಾಡಿ. ಅಲ್ಲ ಅವ್ರು ಮಾಡ್ಬೇಕು.
My lord, in fact, I served.
Vignesh.
I beg to appear on behalf of respondent. I served a copy, my lord, on other day, my lord, across the bar only.
HCGP serve ಮಾಡಿ ಒಂದು.
Martin, I'll do it, my lord.
That's now the norm.
I'll do it. I should.
Yes.
Great.
A week's time to comply with interim order ಇದೆಯಾ?
ಇಲ್ಲ, interim order.
A week's time to comply with the office objections. Next.
Great.
The petition has been moved seeking withdrawal.
Filing the memo for withdrawal.
ಕೊಡಿ. In terms of the memo.
Much of-
Yes.
61 ನೊಳಗೆ, in fact, the charge sheet has not been filed. So far, the office objection is that, my lord, the entire order sheet has to be filed.
Except
They
the
avoid
submission of the council appearing for the
One
petitioner.
submission.
Office objection stand overruled. Tuesday, fresh matters list. ಅದಕ್ಕಿಂತ ಮುಂಚೆ urgent
ಇಲ್ಲ.
ಇದೆಯಾ? Post immediately after service of notice upon the second respondent. Interim order ಇದ್ರೆ continue ಮಾಡಿ. Yes. Same order.
I appear for the respondent number 2 in this matter, my lord.
ಯಾವುದು?
63.
Yes, sir.
I filed a wakalat today.
Learned counsel, I forget your name, sorry.
Vinayak Kulkarni, my lord.
Vinayak Kulkarni.
Please.
Learned counsel Vinayak Kulkarni submits that he has entered appearance for the second respondent registry to print the name of so and so is appearing for the second respondent. Interim order ಉಂಟಾ?
Maybe extended.
Petitioner may be directed to serve a copy.
Petitioner to serve set of papers upon. ಕೊಡಿ ಇನ್ನೊಂದು.
Please.
Set of papers upon the council for the second respondent. Interim order subsisting shall continue to the next date of hearing.
My lords, one submission. In this matter, petitioner has painted the case as if nothing has happened. It matter pertains to 2008 and now it has been agitated. So he relied upon judgment and got the interim order. My lords, there has been some transactions which have been transpired between the parties. I may be permitted to submit a memo. In this, my lords,
ಅಲ್ಲ ಈಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಡಿ.
My lords,
I'll post it.
ಏನಂತಂದ್ರೆ
I'll post it on Wednesday in the fresh matters.
grateful, my lords. What has happened is,
Whatever you want to file, please file.
grateful.
File it in advance so that it gets into the file.
Please, my lords.
2 ದಿನ ಮುಂಚೆ ಹಾಕಿರಿ.
Tomorrow itself I'll do.
List on Wednesday in the fresh matters list.
Great.
Yes, sir. Interim order subsisting will continue to the next date of hearing.
54.
I represent the 399-402 minutes, split up charge sheet.
ಅದಕ್ಕೆ ಆಫೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಬಾರ್ದು ಅಂತಿದೆ.
Second respondent is the police sub-inspector.
All right. Learned HCGP is directed to accept notice for the second respondent as well. List this matter on 19th in the fresh matters list. We'll close it. Yes.
65.
Rajendra.
Yes, Your Lordship.
Maintainability.
Yes, sir.
Why?
The page number 49, annexure B.
ಇನ್ನೊಂದು petition ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ ಬೇರೆ.
ಮತ್ತೆ?
I am challenging the order passed by the.
ಅಲ್ಲ, why maintainability?
Yes, Your Lordship. ಅಲ್ಲಿ ಚೆಕ್ ಇದೆಯಲ್ಲ Your Lordship. Annexure B.
Conviction ಆಗಿದೆಯಾ?
ಅಲ್ಲಿ ಕನ್ವಿಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. We have to prepare up, but actually check is invalid check ಇದು.
Conviction ಆಗಿದೆಯಾ?
Yes, Your Lordship.
That's a matter in appeal.
Appeal, but ಇದು valid check is not valid, my lord.
That is also in appeal. You are already convicted.
Yes, my lord.
Appeal ಅಲ್ಲ, you address everything in the appeal. 482 ಹೆಂಗ್ ಬರುತ್ತೆ conviction ಆದ್ಮೇಲೆ? Unless you are going to settle the matter after conviction.
Because check itself is not valid.
Well, that is a ground for you in the appeal, Rajendra.
Yes, then liberty may be given to approach. Then the time spent here, because within 30 days I have.
ಎಷ್ಟು time spend ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲ, within 30 days I approached the court.
Yes.
Within 30 days ಬಂದ್ಬಿಟ್ಟಿದ್ದೇನೆ. ಅಲ್ಲಿ
Petitioner is before this court calling in question the order of conviction and sentence for an offence punishable under section 138 of the Negotiable Instruments Act. The counsel for the petitioner projects that the check that was the subject matter of the proceeding before the concerned court was itself invalid. This would be a ground for the petitioner to urge that in the appeal proceedings, the petition under 482 in the subject circumstance would not be entertainable. Reserving liberty to the petitioner to avail of such remedy as available in law, the petition stands disposed. The period spent from 23rd July till today be excluded for the purpose of calculation of limitation in the event the petitioner prefers an appeal. Ordered accordingly.
ಅಲ್ಲಿ ಸಸ್ಪೆಂಡ್ ಆಗಿತ್ತು ಆರ್ಡರ್ನ.
Ordered. ಅಲ್ಲಿ
Oblige.
in terms of
My lords, liberty may be granted.
ಏನ್ ಕೇಳಿದಿರಾ ಮೆಮೋಲ್ ಅದು.
Oblige, my lords.
Yes.
67.
And for the petitioner, the
Office objection.
name of the second petitioner has been misdescribed in the FIR.
Misdescribed.
I said so in my petition, it's misdescribed. I've also filed.
All right. Office accepting the submission of the counsel with the petitioner, office objections overruled. List this matter on Tuesday in the fresh matters list. Yes.
68. To the petitioners, my lord. The objection, I produced the entire copy of the entire order sheet certified.
Accepting submission Tuesday fresh matters list. ಅದಕ್ಕೆ ಮುಂಚೆ urgency ಇದೆಯಾ? Yes.
69. My lord, it's a typographical error in the charge sheet, my lord. Office objection.
ಅದೊಂದೇನಾ?
Must.
You're right? Yes. Monday, Tuesday accepting. Next.
70. 70.
But I request for a passover, my lord.
Passover. Why? Office objection, passover.
Office objections, my lord, we are pressing for an interim order.
What interim order? What is the urgency?
Urgency cognizance has been taken by the.
Let it be taken. That's the urgency. When is the next date after cognizance taken?
Cognizance was taken on 4th of July 2020.
When is the next date? ಅಲ್ಲೇ ಇರುತ್ತೆ ನೋಡಿ. Read the order of cognizance. Footnote irutte. Where is the order of cognizance?
So cognizance is at page number 11, my lord.
Next date ಅಲ್ಲೇ ಇರುತ್ತೆ ನೋಡಿ. Issue summons returnable by.
My lord, ಅದಾದ್ಮೇಲೂ proceedings ಆಗಿದೆ.
ಆಗಿದೆಯಾ? ಏನು urgency? Monday and Tuesday in the fresh matters list. Yes, office objections overruled. Tuesday in the fresh matters list. Next.
71.
Why maintainability?
Because I have sought for quashing of police notice issued by,
41A.
not 41A, under section
35(3).
Under section 191. Annexure A at page number 7.
8824.
Page number 24 is annexure.
Yes, sir. 13.
14, your lordship. D
Go and appear before the police.
I have appeared the police.
Then why do you
given
seek
all the
quashment of this?
Defense has been given. Now
No
police
problem.
is compelling me to part with the pond articles, which is not subject matter of the crime, your lordship. Which is not subject.
You are a
matter of
pawnbroker.
Annexure D also, your lordship.
You are a pawnbroker.
Yes, your lordship. In respect of the pledge argument, there is no complaint at all, your lordship.
Let's see. Why? Yes, madam. He's saying something.
Will secure,
Keliskonಡ್ರಾ?
please, my lords.
Ah.
We'll secure the documents, my lords, regarding the.
Secure documents alla.
He-
He's saying you are compelling him to part with the seized articles. Learned HCGP is directed to accept notice. Office objection, square maintainability stands overruled. The learned HCGP is directed to accept notice for the respondent. Check your instructions and make submissions. List on 18th in the fresh matters list.
Order, sir. They are compelling me to part.
The respondent police shall not precipitate the matter till the next date of hearing. Yes.
72.
Office objections.
Objection regarding the description in the names, my lords. Correct.
Tuesday work urgency ಇದೆಯಾ?
Urgency ಇದೆ.
ಅಂತ ಹೇಳಿ.
For this reason, my lords, injunction order was obtained against the complainant on 29/8/2024. And thereafterwards, after the injunction order, my lords, page
Civil
19.
court injunction order ಇದ್ದಂಗಿದೆ?
In the civil court injunction order is there, and not to publish or make any allegations, etc. My lord, there is some political issue, my lord. This petition hearing was was a candidate in the election who lost by few votes, my lords. Then rival, few votes, 5,000 votes, he lost, my lords. Now rival political parties were making allegations, including this first informant in the present case, making allegation that he had received money from the opponent. That was the allegation initially made, and that was being published in the social media. Injunction was granted. Then, well, after the injunction, after about 10 days of the injunction, my lords, on 1/9/2024, she comes out with a complaint of 354A IPC, page 19, my lords, and page 23 is a complaint. She is aged 47 years, says that incident took place 2023 June. Of sexual assault, etc. June 2023.
Sexual assault ಹೆಂಗೆ?
She says this much, my lord.
You have threatened that you'll commit suicide.
No, my lord, this allegation is
What
made.
will she do?
Your lords may kindly see, my lords, aged 47 years, she has a daughter. She says,
No, the allegation is claim is registered on 1/9/2024. The allegation is June 2023. You have threatened her that you will die.
23, my lords.
Aదే,
June 23.
You will die by
that your lords
committing
may kindly see.
suicide
No, my lord.
if she would not
Please, my lord.
oblige.
This allegation comes for the first time after the injunction order is issued, and injunction order, your lords, make page 33. And the injunction order is, she has already made some publications. She has made series of allegations against me. This is not the first time she's makes the allegations. The first allegations pertain to, my lords, that I have received money from the political opponents of 3 point so and so among crores.
Section ಸೋತಿದ್ಯಾರು?
I lost the election, my lords.
You sold.
I lost the election, my lords. And at the end, in the political rivals, my lord, she is making allegation that I stood election because I received money from the political opponents. And it paved the way for victory of somebody else, the other political party. And my lord, the injunction was sought against her, injunction was granted. She is
Again
dependent.
urgency.
No, because of this, my lords, they are-
ತಗೊಂಡಿಲ್ವಾ?
I obtained bail, my lords. Now they are harassing me because now, pursuant to this, my lords.
Who she is harassing you?
No, my lord, the police, my lords, because of the
Yes.
political opponents. And she, my lords, she makes this allegation initially. Now goes on telling the public that it is not 354, it's 376.
Public ಅಲ್ಲ.
Please, my lords, after this, because she is not satisfied, because I obtained bail immediately.
Sorry?
I obtained bail. I have surrendered myself before the honorable court. Bail was obtained, my lords. Now she is pressurizing the police, my lord, that the allegations would attract something more. That's her statement, my lords. And kindly appreciate, my lords, till this date, the initial publication she has made, my lords, your lords may kindly see the publications initially made, which has been widely reported, my lords. Allegation is, my lords, she releases an audio about a month ago, my lord. Page number, the audio contents, my lords, is produced at page 59. And that has been extracted by the news, my lords. Page 71 makes allegations against me.
Why did you threaten her that you will kill yourself?
No such allegations was made in the initial audio released by her. There's no such, that's widely published in all the media, my lords. Allegations made is, my lords, page 72, so and so mattu maile madhye, audio, etc. And that allegation is made, my lords, that he has received money, page 74. Extensive, she herself publishes it on Facebook, etc., my lords. No such allegations were made at any point earlier. Since there was an injunction order, now she comes out with this allegation stating 1.5 years ago, there was an incident of 354, my lords. This is after the injunction order was passed by the Honorable Court, my lords. And she is, my lord, I will not repeat it, my lord, 47 years old, 47 years old, my lord, with a child. And now she, and if it is the first time she makes this allegation, my lord, is one aspect, my lords. She had occasion to make such allegations earlier. Earlier allegations were only about the, that I have received money, etc. Where the Honorable Court, the Civil Court injuncts her not to repeat it. But now she comes out with this. Apparently, my lord, a false allegation made, my lords.
Yes, madam.
My lords, there is a serious allegation against.
Serious allegation.
Please, my lords, kindly peruse the page number 23, my lords. In this, my lords, she has clearly stated that Arun Kumar Puttali ಎಂಬುವರಿಂದ ಲೈಂಗಿಕ ದೌರ್ಜನ್ಯ ನಂಬಿಕೆ ದ್ರೋಹ ಮಾನಹಾನಿ ಬ್ಯಾಕ್ಮೈಲಿಂಗ್ ಹಾಗೂ ಶಾರೀರಿಕ ಮಾನಸಿಕ ಪೀಡನೆ ಕೊಲೆ ಬೆದರಿಕೆಗಳಿಂದಾಗಿ
ಯಾವಾಗ
that's after the incident, my lords, and
ಅಲ್ಲ ಯಾವಾಗ
that's this is dated on 1/9/2024, my lord.
ಕಂಪ್ಲೇಂಟ್ ಇನ್ಸಿಡೆಂಟ್ ಯಾವಾಗ
Prior to that, my lords, and it has
14 months before the registration of the complaint.
There was an
Injunction order.
59, page number 59, my lords. It clearly stated about the conversation between the
Conversation has stood for 14 months. Again, conversation crime ಆಗ್ಲಿಲ್ವಾ?
there is a media.
Yes. Accepting the submission of the counsel for the petition, learned senior counsel, the office objection stands overruled. The learned senior counsel would plead grave urgency in the matter. The urgency in the matter. The petitioner is now an accused in crime number 45 of 2024 for offences punishable under section 417, 354A and 506 of the IPC. The petitioner is said to have contested the assembly elections and has lost. The second respondent complainant has initiated certain broadcasting or made statements in the social media or in the television. The petitioner approaches the civil court in OS.
My lord, OS 6128 of 2024.
6128 of 2024, and the concerned civil court grants an order of injunction injuncting publication of any material against the petitioner in the electronic or print media. After the registration, after the grant of injunction, comes the impugned complaint. The impugned complaint narrates an incident that happened in the month of July 2023. The incident is that the petitioner threatens the complainant that he would kill himself or commit suicide if the complainant would not have physical relationship with the petitioner. The incident has stood 14 months' time, and the complaint comes about on 1/9/2024. Prima facie, it cannot but be said the complaint is a counterblast to what action the petitioner had taken in seeking an injunction against the complainant and the court granting an injunction. Therefore, there shall be an interim order of stay of further investigation in crime number 45 of 2024 till the next date of hearing, 1 HCGP 2 emergent notice.
And also further proceedings, because I am informed, my lord, they want to transfer it. Further proceedings because they want to transfer it from Puttur to Bangalore, my lords.
All investigation and all further proceedings.
I'm most.
Next. ಇದು ಬೇರೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನಿದೆ?
ಅದು identity particulars, my lords, names do not tally with what's mentioned in the complaint.
ಒಂದೇ ಅಲ್ಲ, ತುಂಬಾ ಇದೆ.
The same thing.
ನೀವು
We will get it.
ತಗೊಂಡೆ.
We will get it. Leave in the course.
The order shall take effect only after the compliance with the office objections.
Leave it. I'm great.
Yes.
23.
Served Mr. Manish Kumar on
Review
N7 itself.
ಮತ್ತೇನು?
Alla, idralli what has happened, my lords, is that insofar as the levy of advanced probable pro rata charges, your lordships had taken a view in Sundaram Setti's case that when the regulations provide that it has to be levied at a certain
ಏನ್
time.
ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ರಿವ್ಯೂಗೆ?
Now, my lords, what has happened is, in this particular matter, there was a circular which your lordships have not considered, which I had challenged.
Appeal, sir.
Alla, what
Appeal,
has
appeal.
happened? Because my lords may kindly see for,
non-application of point, appeal.
Alla, beda, if your lordships
Beda.
kindly sees for a moment, because your lordships have already taken a view in Sundaram Setti's case that by way of a notification, if they advance this incidence of a particular charge, that cannot be sustained. Similar, my lords.
Appeal, sir.
Similarly, here also, if your lordships may kindly take one
If Jalkal was not there, I would have continued my view.
My lords.
If Jalkal Nigam was not there of the Supreme Court.
Because this is not insofar as Jalkal is applicable. If your lordships kindly sees your lordships findings
No,
at
sir.
page
All the
93,
I will not rehear the matters.
your lordships may not.
Non-consideration of some material is not a ground for review.
It is not at all a non-consideration of some material, my lords, but this is one of the main circulars that I have challenged in my petition. If your lordships may kindly see for a moment.
Appeal.
Because regulation 5.3 clearly says it is at the time of water connection. They cannot advance this entire incidence, my lords.
Advance what?
The entire incidence of the
What
levy.
incidents? Probable pro rata?
Pro rata charges itself, because pro rata
Advance
charges.
pro rata charges.
Advance pro rata charges. If your lordships kindly sees, 5.3 says that regulation 5.3 says that it has to be collected at the time of water connection only. Now, my lords, by way of a circular, which your lordships have not considered during the
You are
consideration
talking of
the
advance pro rata.
advance pro rata charges, my lords.
Anything else?
Because ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ, your lordships have said that pro rata has been upheld by the division bench. Insofar as the upholding of the charges, I am not on that ground, my lords. Only insofar as the incidence is concerned. Similar to how your lordships quashed the upfront incidents. Indeed, my lords.
In Sundaram Shetty.
In Sundaram Setti's case. Very similarly, my lords, here also, because the statutory regulations provide that it has to be collected at the time of water connection.
Why did you urge all this in the division bench?
That's what has happened is because this is a matter for review. This was not considered by your lordships, and therefore I am bringing it to your lordship's consideration.
Will answer?
My lords?
Will answer it.
Very well.
The petitioner has preferred the subject review petition seeking review of an order passed by this court holding advanced probable pro rata charges and the other charge to be valid, and had invalidated two of the charges that were levied against all the consumers. The petitioner has preferred the subject, but the learned counsel for the petitioner submits that the probable pro rata charges is leviable, but the incident should have been after the connection being taken.
At the time of connection.
At the time of connection being taken, and not as an advanced probable pro rata charge.
At the time of NOC, my lords.
Or at the time of NOC. He would seek to place reliance upon clause 5.3 of the
Regulation 5.3
regulation
of the-
5.3 of the so and so BWSB regulations. So and so. The court has, on reasoned consideration, following the division judgment of the division bench, passed the order. The review, the petition being presented for a review would amount to rehearing the matter, which is not the scope of a review petition, as held by the apex court in Kamalesh Verma versus Mayawati, 2013, 8 SEC, page 320, extract para 21.1 and 21.2. The postulates laid down by the apex court would clearly become applicable to the case at hand, as the petitioner, if the submissions of the petitioner is now taken note of, it would amount to sitting in appeal over an order passed by this court and rehearing the matter all over again. Petition dismissed.
It's good. Only on that ground.
Yes. Next.
74.
There appears to be a wrong office note, my lord. This petition I had actually withdrawn.
Withdrawal gyake?
I had withdrawn, but, and also it pertains to Bangalore. The cause title, cause list shows, my lord, a letter from district and sessions is Mysore, my lord. There appears to be a wrong. thing. I'd withdrawn it. In fact, the case also pertains.
Application of concerned court. The OS 771, Samadhana 11. The communication appears to be wrongly tagged before this court, the office to verify and responsibly listed before the concerned court. Next.
75.
In terms of
76.
But the only office objection is that there are double pagination.
Huh?
The only office objection is that there are double pagination. In the charge sheet, my lord, one of the pagination is the internal page numbers of the charge sheet, my lord. Might kindly be over. My lord?
Enandri?
My lord, the office objection is that there are double paginations.
Double pagination.
Yes,
Correct, Madi.
No, my lord. One of the pagination is internal page numbers of the charge sheet, my lord.
Overruled. Yes. Tuesday in the fresh matters list. Yes.
My lord, serial number 49, my lord.
Why, sir?
It was not called, my lord.
49.
Yes, my lord. The list started from serial number 50.
Oh, 49, we said we'll pass orders. Wait.
Yes, ma'am.
Yes. Promise to marry. Well, promise to dispose. Yes. Madam? Further hearing courage. Vacating stay avudilla idರಲ್ಲಿ. Call further hearing case. Mistake ಇಲ್ಲ. Responsible you know, they are. All the further hearing matters.
Further hearing matters. 1, 5.
Batch matter, my lords.
Iದೇನು?
It's not part of the batch matter, my lords. This was a case.
What is this?
My lords, this was a case, my lords, where an ICICI bank manager, when he was coming at night, he stopped for the purpose of drunken driving. So he stopped, my lords. He does not actually stop, but he speaks out to the officer concerned. And then, my lords.
353.
Out. And then, my lords, the allegation is, my lords, he moves his vehicle, which has gone over the leg of that police officer, my lords.
I think it's my interim.
Yes, my lords. And then, my lords, after that, the police officer would go to a certain hospital, and those hospital medical records are not part of the charge sheet. Then he goes to another hospital, my lords, and he would get the certificate from that hospital. Finally, they would file a charge sheet, my lords, where only police persons are all shown as the witnesses to this incident. And the allegation is, my lords, a case of 353, my lords, 307, my lords. They bring in 307.
Jagdish, you have solid unity amongst yourselves. Police will never give up police.
And my lords, most interesting part is, my lords, not a case of drunken driving. They would say that he was not drunk. He's a manager who was returning back from his work, my lords, at night.
Damages, litigation expenses pocket in the correspondent. ಆಮೇಲೆ ಸರಿ ಹೋಗುತ್ತೆ ಇವೆಲ್ಲ.
And in fact, my lords, a coordinate bench in a case of discharge where it came up for revision would rely on a circular, my lords, which says at the time when you're doing drunken driving, they need to have video cameras because what transpires there has to be recorded.
These days they're doing that time.
Yes, my lords, that was not done in any of these cases, my lords. So a case where he was not drunk but driving, and the allegation is while he was moving away, he has gone on the leg of that officer concerned, my lords. That leads to the whole thing.
Two-wheeler mela.
Four-wheeler ali, my lords. Nilseki, he's coming from work intentionally without drinking.
No. Even if it is by a two-wheeler, they will say 307.
And 307, my lords, whole thing, it should be running short of 302. Your intention, knowledge, everything should be there, but you're short of committing 302. That is how all the judgments read. But charge sheet ali 307 for a case of simple hurt.
Stay there. We'll take it another day. Yes. I'll list it in October.
Please.
Yes. Next.
The interim order.
Interim order subsists heard the learned senior counsel Madi. List the matter on in the second week of October for the hearing. Third week, yes.
Please.
Next.
136.
Yes, Halima madam. Where are the objections?
Objections, Milord, I have.
I'm not granting time in this.
Milord.
Either eighth husband will come.
No, it is not, those facts are not correct, Milord.
What
It is
not
all.
correct?
No, she has filed for defamation also. And he has suffered an order for maintenance. To escape from that, he has done all this, Milord.
How many husbands you had earlier?
She has married for 4 times. One has passed away. After talaq only, she has done all this.
Next 3?
One by one after talaq.
One by one?
Yes.
Talaq.
One has passed away. After that, she married. So those
You
facts
have-
are not true, Milord.
You have only 4, is it?
She has married for 4 times. That is what I am told. And I will be filing objection in detail with the order he suffered for maintenance. And he is no he is no saint. And thing is, he has married her in spite of having children of marriageable age. This is his 2nd or 3rd marriage. That he has hidden. He has suppressed so many facts.
So you have 4 and he has 3. Total 7.
Maybe, according to if he adds 2.
Your Honor, appearance on the behalf of the petitioner, Your Honor, in this case.
Where are you, sir?
And
In
with all
hospital,
this,
Your Honor.
it all gone viral and she is really in trouble there.
What to do? You were not there that day.
I was there.
No, your colleague was. Mine was not for
Yes,
objection.
somewhere else I was there.
Anyway, I can't. These are facts that are
That is
recorded.
good. But I had sought for time to file objection.
Correct.
I am collecting all the documents, even
Correct.
this order of
Yes,
maintenance.
sir. You said 7. Where are 7?
Your Honor, total 8 marriages, Your Honor. I have filed all the documents. Yes.
Only the documents.
1 minute.
I will give the details, Your Honor. The first marriage was solemnized on 2004, Your Honor, with Muhammad Hussain.
Page ಹೇಳಿ, sir.
Page number 3, Your Honor.
Page number 3, yeah.
Yes, I have filed the details and along with the documents, Your Honor.
Page number 3, yeah.
I'll get the document.
Yes, sir.
What investigation?
Compilation.
Page number 3. Idu first marriage,
Yes, Your Honor, with Muhammad Hussain, Your Honor. And it is the first marriage with Muhammad Hussain. The Jamia Masjid of Hodehonnuru, Shumoga district has given the certificate, marriage certificate.
First marriage, Jamia Masjid has given the certificate. That is on
Yes, Your Honor.
5/11/23.
No, Your Honor, marriage certificate ಕೊಟ್ಟಿದ್ದು ಅವಾಗ ಆದ್ರೆ ಮದುವೆ ಆಗಿ 2004 ಅಲ್ಲಿ ಅದರಲ್ಲಿ ಕನ್ನಡದಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
2004 ಅಂತ ಎಲ್ಲಿದೆ?
ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶ್ರೀಮತಿ ತಬಸ್ಸುಮ್ ತಾಸ್ ತಂದೆ ಇಸ್ಮಾಯಿಲ್ ವಾಸ ಹೊಳೆಹೊನ್ನೂರು ಇವರನ್ನು 2004ನೇ ಇಸವಿಯಲ್ಲಿ
ಆಯ್ತು. ಆಮೇಲೆ
and the second marriage was solemnized on 2016, Your Honor, with Anwar.
1 minute. With page 6,
with Anwar, Your Honor, 2016.
2016.
Yes, Your Honor. In 2019, Your Honor, she filed a criminal misdemeanor for maintenance case against domestic violence case against Anwar.
All right.
The order sheet has been annexed as document number 11, page number 7, Your Honor.
Next.
Your Honor, during the proceedings, Your Honor, she again married with one person named Afsar Pasha. The death certificate also produced, Your Honor. In the death certificate, Your Honor.
All right. Next.
The name of the person
Death
is
certificate. She's right. She said after he died, she married again.
Yes, Your Honor. During the proceedings of Anwar against proceedings, Your Honor, pending in Heinous court in Udupi, Your Honor.
So what are the crimes registered against the complainant?
Your Honor, in many, in Udupi, in Shivamogga, Hospete, see in the pretext of providing.
Lord,
File your objections.
yes, my lord.
You
should
also file all the
Your
documents.
Honor,
And he has to furnish.
Your Honor, I also submitted affidavits with the 3 more husbands that they are praying before this honorable court to kindly issue this case to CCB.
Oh,
I have,
all right.
I am not
Yes.
given
Yes.
copy.
3 more husbands, from where did they spring, sir?
Anwar second husband also filed the affidavit before this honorable court, Your Honor, in the
Where?
page number 4.
Which petition?
Your Honor, I have filed the compilation of documents in counter, Your Honor.
You first appear before the court, sir.
Oblige.
Here you on VC.
I am in hospital, Your Honor.
ನೀವು ಇದ್ಯಾವುದು ಎಲ್ಲ ಹೊಸಪೇಟೆ ಬಡಾವಣೆ ಅಂತಿದೆ ಇಲ್ಲಿ?
Your respondent number 2 again.
You are with the present husband, huh?
Yes, Your Honor. Raja Hussain.
All right, yes. He is giving you instructions there. Huh? Yes, appear here. List on 18
Oblige.
at 2:30.
Oblige.
If you don't appear, I will dismiss it.
No, your previous date, all the husbands, 5 husbands are came to this court, Your Honor, but the
All
matter
the
is
husbands are
not
coming
reached.
here.
Yes, sir. Yes. Before this honorable court, 5 husbands are physically came before this court, Your Honor.
5 husbands came physically. What are you talking, sir?
Yes, Your Honor, previous date, but the matter is not reached, unfortunately.
So they went back home, is it? Yes. Anyway,
Yes, Your Honor.
list on 18th ಅಲ್ಲಿ ಹಾಕಿ ಮೇಡಮ್. ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ ನಿಮ್ಗೆ?
ಇಲ್ಲ, ನನಗೆ ಎಲ್ಲ
I will serve you.
ಕೊಟ್ಟಿಲ್ಲ ಹೇಳಿದ್ರು. He has filed it seems. I have not.
Serve a copy on Halima madam.
Oblige, Your Honor.
Counsel for the petitioner to serve on.
Some more time, Lord. 18th will not be because I have some other.
Then he will come up with 3 more affidavits.
No, that is okay. Lord. Let him come and he has to simply just filing affidavit is not enough. There should be some supporting
So he said
documents.
they were present in person here. Then he will bring the next 3.
He is that type of person. She has gone for defamation case.
All right, file.
Maybe 30th, my lord.
30th, beda. 27th.
All right.
List on 27th at 2:30 PM. You appear in person.
Oblige, sir.
And don't be with the petitioner.
Oblige, Your Honor.
Yes.
Oblige.
137.
This case where
Entry mortar ಕೊಟ್ಟಿದೀವಲ್ಲ?
entry mode is operating.
Yes, entry mortar ಅದಿರ್ಲಿ. List after 2 weeks, entry mortar subsisting shall continue till the next date. Next ಅಲ್ಲೂ ಇದೆ entry mortar.
ಇದ್ರೊಳಗೆ entry ಮಾಡ್ರಿ ಇಲ್ಲ.
ಯಾವ್ದ್ರಲ್ಲೂ ಒಂದು ಕೊಟ್ಟಿದ್ದೀನಿ.
137 ಅಲ್ಲಿ ಇದೆ, my lords.
137 ಇದೆ, 138 ಅಲ್ಲಿ ಇಲ್ಲ.
Yes.
ಅದನ್ನ together I will hear now. ಒಂದು ನಿಮಿಷ, I'll just call out the cases.
Please.
ಆಮೇಲೆ 139
139.
objections ಹಾಕಿದ್ದೀರಾ? Respondent. ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದಾ?
Second time.
ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಕೊಡಿ ಮೇಡಮ್.
Notice ಆಗಿದೆ. I've served the copy of
ಯಾರು BB ಪಾಟೀಲ್ ಬಿ ಲತೀಫಾ?
BB Party.
Register to print the name of BB Patil. Notice ಕೊಟ್ಟಿದ್ದಾರೆ ಇದು? ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರಾ?
Copy, we'll check it.
Learned Counsel BB Patil, register to print the name of BB Patil as appearing for the respondent Lokayukta. If the copy of the petition is not served, the same shall be served upon the said counsel. List on 20th.
Right.
Yes. Next, 140.
140.
There's no interim order that was granted. That matter relates to 13(1)D, my lords.
I know, yes. Objections ಹಾಕಿದ್ದೀರಾ? ಹಾಕಾಗಿದೆಯಾ?
ಹಾಕಾಗಿದೆ.
All right, then. List on 26th. Yes, next.
Trial is going on. Matter.
Stay ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ?
ಇಲ್ಲ, stay ಇಲ್ಲ.
Trial is going on.
Yes.
Then wait.
Very well.
Next.
141.
Respondent.
141 in.
ED matter.
Respondent ಈಗ?
Respondent.
How come?
ED.
Petitioner ಯಾರು? ಇದು ED ಬೇರೆ you have,
Please.
this is same the other petition where 7A ಅದೇ ಅಲ್ವಾ?
ಅದಲ್ಲ.
Disproportionate assets.
The C is not where he has sought for washing off, not the ECIR. The summons issue.
ಅದು predicate ಹೋದ್ಮೇಲೆ ನೋಡೋಣ. Just after 2 weeks. Next.
142.
142 not is 13(1).
ಇದು?
13(1)D.
Pass over. I'll take it immediately after this.
Please.
Yes.
43.
Sandesh Shota sir is there.
Please.
All right. Yes.
Serial number 143, Lordship. Kindly pass over, Lordship.
I've heard this Matten. Reserved. Yes. Next.
144.
ಇದು ಅಷ್ಟೇ I've heard. Reserved.
45.
Pass over.
46 and 40.
145. ಇದು 7A ನಾ?
46, 13(1)D.
13. 146.
That's also not same.
Pass over.
147.
Pass over.
My lords, I appear for the petition in 147. Kindly pass over, my lords.
It's already passed. Yes.
148.
That's also not DA.
ಇದರಲ್ಲಿ ಏನಿಲ್ಲ. We'll dismiss this case. 148.
ಇದರಲ್ಲಿ wife is a public servant which not accounted. I made a synopsis that ಎಲ್ಲದಕ್ಕೂ ಮಾಡಿದ್ವಿ.
This is huge. The chief engineer ತಾನೆ? ನಾನು ನೋಟಿಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಹೇಳಿದೆ. This man does not deserve. Chief engineer, super engineer ಇರಬೇಕು.
I just will not pass on.
Chief engineer, yes sir. We'll hear you. Anyway, this is not a case for interference. Next, ಬೇರೆವೆಲ್ಲ ಕೇಳೋಣ.
149.
PC Act 13.
13. 115 to 13. All right, now take up Sandesh Shota sir. Which is the one you would be submitting in?
42. 42.
42?
Yes, well, it's passed over.
Prasanna Kumar, nimdu 41. ಅದು ಅದೇ.
41, then my lords minus at 42.
All right. 42 ತಗೊಳ್ಳಿ.
It can be said.
But synopsis is spelled in everything?
We'll pass the synopsis across.
No, if you're same submissions like the others.
My lords, I will point out a few things which are not there in the other orders, my lords. It may aid, my lords, in the whole thing. My lords, the
Please
manner.
give the complete compilation of all judgments, either of you.
I'm giving the, my lords, I'm giving a
which are
compilation.
passed by me or by coordinate benches, whatever it is. Yes.
Totally, my lords. My lords, the manner in which I would like to go about this matter is, my lords, there are 5 aspects that I'll touch upon, my lords. The first aspect, my lords, in my respectful submission is the interpretation of the act. Emphasis is, my lords, why is disproportionate asset different than other cases of criminal misconduct under the PC Act? What is it so different about disproportionate asset? Along with that, my lords, I will also point out that so far as disproportionate asset is concerned, my lords, it's an individual offense by a public servant. My lords, there are certain provisions under the PC Act where offenses are only by public servants, and there's certain where offenses are only by individuals. And we have only one offense, my lords, as I'll point out, section 14, where it includes both of them. So, my lords, when we say the offense is that of the public servant, family members cannot be brought in. The only exception, I will even point out, my lords, the only exception is when it is going to be a Benami transaction. Then how do we say it's a Benami transaction? I will come to it, my lords. Merely bringing them into the aspect of asset, my lords, and not considering the corresponding income, how it would be bad when you come to the calculation part of it. So this is the first aspect, my lords, that I'll point out from the act itself. Now, the second aspect, my lords, that I would like to point out is, how do we interpret the word order, which we get under the second proviso of section 17? My lords had an occasion, my lords, while dealing with 17A, while dealing with approval, there were certain judgments given, my lords, which pointed out the distinction between what a direction is and what a sanction is, and similar other words. So the emphasis when it comes to the word order, where it stands, my lords, in my respectful submission, my lords, it would stand on a much higher pedestal than the word of either consent, approval, or sanction. I will point that aspect out, my lords, and legislature thought it fit to use the word order. And that is where, my lords, I'll point out strict interpretation, my lords, as how the Supreme Court in Bhajanlal also has done when it comes to the same provision. Now, that would be the second aspect that I will emphasize on the word order, my lords. The third aspect, my lords, which I will point out is, how does other premium agencies, such as CBI, my lords, how is it they go about investigating disproportionate asset cases? That is where, my lords, the emphasis will be to say why they have a PE, post a PE, how they convert it into an RC, post an RC, how it is placed before the SP, and how the SP, my lords, passes an order with an independent application of mind to permit investigation. It is in this sequence, my lords, I will be able to demonstrate, my lords. So the present step taken by the Lokayukt, my lords, seems to be giving an go by to that, and would be a case of saying, if we have a source information that is enough, we can translate it to an FIR. My lords has seen the word desirability, my lords, which my lords has used in a couple of matters while deciding it. So that would be the next aspect, my lords. And the fourth is, my lords, the Lokayukta now themselves having realized, my lords, the procedure which they are following, not just as irregular, but is illegal. They would come up with a circular, my lords. In the circular, my lords, how they have dealt with it and how the action which they're doing is contrary to their own circular. But now at present, my lords, they seem to have realized that. And one of the cases I will demonstrate, my lords, they go by what the circular says. So you're going to have a source report, you're going to have a preliminary inquiry, and after the preliminary inquiry, you convert it into an FIR. You place these three before the SP, and the SP would have to pass an independent order directing investigation. Now they're adopting it. I will show it. Now, if they're adopting it, my lords, then it virtually whatever they've done prior to this shows that it was not in order, my lords. Then lastly, my lords, and most importantly, my lords, the 5 important aspects, my lords, when it comes to registration and investigation of a DA. As I said, my lords, proviso to section 17 would be mandatory as held by the apex court and by my lords. Secondly, my lords, the desirability to conduct a PE. The third is post-PE, the mandate to register the FIR. Fourth aspect, after it is done, it is placed before the SP who applies his mind independently before permitting investigation. And the reason for that is, my lords, the civil consequences. Because now what is happening, as my lords pointed out, 2006 and 2012, if it's a DA case, there should not be a suspension. But 2015 onwards, I think Mr. Prasanna pointed out.
He told him.
My lords told me also.
Even I have produced those circulars before courts and have taken stay of suspension.
But I think
and
the
none of them are getting that.
The position changed post 2015.
Post 2015 only, I'm telling. No, earlier it was no suspension. 2015
2006 and 12, my lords pointed out. Avaga suspension irta irlilla. Now, my lords, as soon as they register the FIR, they themselves write to the authorities.
So 7A is a different thing. Yes, you may entail suspension. That's a different thing. In a disproportionate asset case, suspend made in
my lords, more importantly, as my lords, in a disproportionate asset, now what do? You go, you search, and you seize the documents.
Documents are all there.
Then what is it tearing hurry, my lords? What is it tearing hurry to say, I will not even do a preliminary inquiry, I will straight away register an FIR and I will get an order from the SP. That seems to be, my lords, is unnecessarily a tearing hurry giving go by to what is mandated.
Hottest haste and the bardid. That is, they have taken it to Supreme Court.
What should be in my the judgment, my lords, which I pointed out.
Yes,
my lord, that is still pending in the Supreme Court, but that was not an absolute stay, as I had pointed out, my lords.
The investigation shall continue.
But my lords, the other case, my lords, L. Satish, where my lords also the coordinate bench held, PE should be done. That when it was taken to the Supreme Court, SLP is dismissed. This is how the position stands. Now, my lords, when I was pointing out the first aspect about the act itself, could I just request my lords to kindly have the act, my lords? Totally, we have about 30 sections in this, my lords.
PC Act.
PC Act.
All right. You want me to read all the 30 now?
Adril, I'll point out, my lords. So far as these offences are concerned.
One sec. Yes, Ian. You want to say something?
Lordship, in my statement of objection, in each statement of objection, I have made a para in which we say that check bid is not taken in hottest haste. That it is not, check bid is not taken with a vague intention.
All right.
That I have mentioned.
Anyway,
We'll hear you.
Individually, I'll point out, my lords, what they've done. Now, my lords, as I was pointing out, my lords, out of these 30 sections that are there, chapter 5, my lords, is the most important chapter which deals with offences and penalties. My lords, chapter 5, section 7 starts there, my lords. And it goes all the way till section 15. 16 again will not be a punishment section.
Yes.
Now, if these sections are noticed, my lords should have chapter 5. My lords, my apology, chapter 3, my lords. Sorry, chapter 3, not 5. Totally, we have 5 chapters. Section 7 in the start agutte. My lords may notice, my lords, how certain offences are against public servants and certain offences against individuals. Now, take for instance, section 7, my lords, it is public servant. My lords, offences relating to public servants being bribed. Now, section 8, 7A may be noticed, my lord. 7 capital A, it pertains to an individual. It starts with whoever accepts or obtains or attempts to obtain from another person for himself to give to a public servant. So it's against individuals, 7A, my lords. Similarly, my lords, if my lords notices 8 offences relating to bribing of a public servant, it is an individual. 8. 9, my lords, offences relating to bribing a public servant, again an individual. So 8, 9 is individuals, my lords. And then, my lords, the next section, 10, again an individual, nothing to do with the public servant. 11 deals with public servant. 11 says public servant obtaining undue advantage without consideration. 12, my lords, is an individual abatement.
Yes.
13, my lords, is which is the most relevant section for us, my lords, because earlier 13.1e, now 13.1b. Kindly notice the usage of the words under 13, my lords. Public servant.
Yes.
My lords, can I just point out in 13, my lords?
I am 1 minute.
My lords, a public servant. My lords, it starts with criminal misconduct by a public servant. A public servant is said to commit the offence of public misconduct, B, as it stands now, my lords, if he intentionally enriches himself illicitly during the period of his office. So kindly notice this, my lords. This is an offence which is exclusively to that of a public servant. Now, my lords, where we get the word benami, my lords, where we have to read that into it. Explanation 1, a person shall be presumed to have intentionally enriched himself illicitly if he or any person on his behalf. This is the words, my lords. If he or any person on his behalf, this may be noticed, my lords, to be one of benami transaction. And when you come with benami, my lords, what should be the averment in terms of benami? He is in possession of or has at any time during the period of his office been in possession of pecuniary resources of property disproportionate to his known source of income, which the public servant cannot satisfactorily account for. Again, my lords, this has a lot of importance, my lords. So when does it become an offense, my lords? It becomes an offense not merely by making an averment that you have disproportionate asset. It would become an offense, my lords, when I am not able to satisfactorily account for it. That is how the whole wordings. That's why, my lords, under 13.1e, my lords.
So if you are not able to satisfactorily explain, it would become an offense.
Yes, my lords. So now, my lords, when we say not able to satisfactorily account for, when is it that you're asking for that explanation?
After the registration of the crime.
I'll come to that, my lords. If my lords
They ask you the schedule to all the offense, what court schedule is that?
Schedule 1 to 7. Earlier it used to be 1 to 23, but now they've reduced it to 1 to 7, my lords. That's how the schedules read, where they ask us for an explanation during the investigation. So starting, my lords, FIR, in fact, my lords, that's the precise reason, my lords, why P and why the order of the SP comes into an aspect of disproportionate asset. So that's why, my lords, this particular offense of disproportionate asset stands on a different footing than any other offense here. Now, my lords, explanation 2, the expression known source of income means income received from any lawful source. Now, what the distinction that has come up here earlier, my lords.
One clarification. Now, in many of the cases, they have passed an order through. We'll say that order is in consonance with law. Some amount of preliminary inquiry is done. It is not that in all cases they have vaguely registered crimes or given permission to register crimes. In few of the cases I have seen where, yes, preliminary inquiry is done, not by drawing up a circular or in terms of the circular. They have collected all the information and those information are all correct now. In those cases, I will not interfere.
I understand, my lords. My lords felt such of the source information. I will address that, my lords.
This legal submission cannot sweep into every fact.
That's need not.
That's why I said, where the facts, I will apply the law.
Yes, my lords. My lords, kindly notice, my lords, one of the submissions that they constantly keep making is our source information is post certain inquiry.
Yes.
So our source information contains everything. This is, my lords, we will compare this in terms of what we see in the manuals itself, my lords, because my lords wanted to know how is it that the CBI manual deals with disproportionate asset. My lords, it is part of what we are producing, my lords, how exactly it is done. I will show it. And then my lords feels sufficient. Source reportedly, there is some.
Definitely.
Please, my lords, I totally.
I have seen, because few matters I have reserved. In those cases, when I went through the files, in some matters, definitely it is sufficient. They have conducted preliminary inquiry and then registered the crime. In some matters, they have skipped off everything.
My lord was pleased to see that they've done some kind of an inquiry and then come with the source information. That's how it, I will deal with it, my lord. I understand that because my lords also felt the source information in a preliminary inquiry, it can be an affair. My lords felt so.
No. Source information ಮಾಡಬೇಕಾದ್ರೆ preliminary inquiry ಏನ್ ಮಾಡಿದ್ದಾರೆ, everything is drawn in that source information report.
Yes, please, I understand that.
Beyond that, we can't expect the investigating agency to go on fishing for evidence in its entirety.
That's correct, my lord. That happens during investigation. During inquiry, it is not required. My lords,
glaring illegalities.
My lords,
where income of the wife is taken, not taken away, not by
assets taken, income not taken.
Assets
most
taken,
glaring,
not
my lord.
That's what he's saying.
Yes, my lord. Most glaring will be that you take the assets of the wife. You don't even consider that asset of the wife could be a gift from the mother. You have not even taken that into consideration. I will point it out.
Problems of gifts we know. Gift will, I will never end.
Ancestral property.
Yeah, ancestral property.
My lords, if the wife,
ancestral property gift madidre, it's okay.
So I will point out instances, my lords.
How Benami works is this. You buy a property in your mother-in-law or father-in-law's name. Father-in-law or mother-in-law gifts it to the wife.
My lords, when it comes to Benami, my lords, I will point out from Krishnanand Agnihotri's case itself. They've dealt with that very specific aspect.
Exactly.
My lords,
that is why I said you cannot paint every case with the same brush.
I totally understand that, my lords. I totally understand. My lords, in Krishnanand Agnihotri's case, quite an old case, 70s, my lords. That was a case where they said below 10%. It was below 10%.
See, here and that is why that adjustment comes about. But ಅವಾಗ ಎಷ್ಟು ಡಿಸ್ಪ್ರಪೋರ್ಷನೇಟ್ ಅಸಿಸ್ಟ್ ಇದಿರಲಿ,
ಅದರಲ್ಲಿ ಒಂದು 11,000
ಏನು 11,000
ಡಿಸ್ಪ್ರಪೋರ್ಷನೇಟ್ ಇನ್ ದಟ್ ಕೇಸ್
11,000 rupees. All right. ಈಗ ಡಿಸ್ಪ್ರಪೋರ್ಷನೇಟ್ ಅಸೆಟ್ runs into crores, 400%, 500%. ಇವರು ಬಿಟ್ರೆ ಅದನ್ನ 900%
ತೋರಿಸ್ತಾರೆ. ಆಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಬೇರೆ ಇರ್ಬೋದು,
ಅದು ಗೊತ್ತು. ಪ್ರೊಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ.
So my lords would kindly notice this aspect in saying, why is it that disproportionate asset stands on a slightly different footing than of other criminal misconduct? That is where I'm heading towards, my lords. And why is it the legislature thought it fit that you need to have some check and balance when it comes to a disproportionate asset? That's why we get that second proviso of 17. And the first proviso is a general provision, my lords, which allows only a higher ranked officers to investigate. Exception to that is by notification. You have an inspector. So that ring of protection that is given is in the context of this, my lords, and especially disproportionate asset. So, my lords, after this 13, 14 would be a common offense involving both public servant and individuals. My lords, because it says punishment for habitual offender. So whoever, that could be a public servant, it could be an individual.
Like 12, anybody can.
12 is abatement, individual.
Abatement, that's what.
But 14, both of them included.
Yes.
My lords, they say whoever convicted of the offense under this act, it could be a public servant, it could be an individual. Then, my lords, 15 punishment for attempt, that is in reference to a public servant, 15, because it comes under subsection 1 of section 13. So it's an attempt to do that, only a public servant comes into it. And 16 is not relevant. So now, my lords, of these sections, my lords, the ones which only public servants are exclusively involved are 4 sections, my lords. Section 7, Section 11, Section 13, and Section 15. These are the 4 sections. So this is in the context of saying how we have to view the word benami there. That's the only exception there. Now, my lords, with this, please notice the object and interpretation of the act was considered in Ram Singh's case itself. My lords, Ram Singh's case, my lords, this is citation 1 that I'm giving, my lords. These are the stray citations on certain points, my lords. The second book I'm giving is based on CBI, how CBI manual is, how CBI goes about it, and Lokaayukta 1. The third book, my lords, contains all my lords' judgments, coordinate bench judgments, Bhajan Lal, which is the lead case when it comes to the second proviso. This is how I've segregated it, my lords. Kindly notice this judgment.
CBI manual ಅವರು ಕೇಳ್ತಾ ಇದ್ದೀರಾ ಪಕ್ಕದಲ್ಲಿ
Prasanna, I even wanted some few things.
He is appearing for the Lokaayukta and you want to tell him CBI manual now. Appearing against the Lokaayukta.
No, my lords, we will have to show it how it is done in accordance with the object of the act. Now, CBI, my lords, whenever they do their manuals, they consider all the judgments.
How CBI does it, yes, definitely.
How judgments that are passed, and then they have formulated
CBI follows a meticulous procedure in all these things.
Please.
Not that
citation.
They don't do it by circulars.
No.
They have a manual.
They have the manual.
Compendium of all circulars, rules and everything.
And my lords, now the present interpretation is, it's not of statutory force, it's a set of instructions. But the set of instruction, my lords, is based on judgments passed by the apex courts.
So it has
that the weightage that it has. I will show it, my lords. Those there are 3 chapters there I may have to point out. Now, object and interpretation of the act. My lords, in the memo of citation, I have pointed out the paragraph number also, my lords.
Yes.
My lord, State of Madhya Pradesh versus Ram Singh, paragraph 10 deals with the object and interpretation of the PC Act. My lords may directly go to page 6, my lords, at the bottom, paragraph 10. Why it was required, my lords.
Yes.
My lords would recollect, my lords, this Prevention of Corruption Act, first act was 47, my lords. Amendment took place in 64. Then this act, which 88 amendment in 2018. So we are still with the 88 act with the amendment. So original acts, if you see 47 and 88.
No, that shows it's quite strong.
Very strong, my lord. And in 47 act itself, my lord, that second proviso is there under 5A.
That is true. Yes.
Investigation.
No, that's why it is as strong as corruption. Yes.
Protection, balance between the two. There may be corruption and there are certain safeguards. That is how we view it, my lords, when we say balance is scales, my lords. This is how it is balanced. So, my lords, only paragraph 10, my lords, I will not read it out. The object behind the act is spelled out there, my lords, why they had to come up with it. Now, my lords.
Why of it is in para 9?
Para 9, yes, my lords. The menace. 9. The menace. And then for that, the act which came into force.
The beginning of the menace is in the First World War.
Yes, ಅಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ ಹೌದು.
Yes.
Now, my lords, as I was pointing out, section 13(1)(b), what we'll have to take notice, 13(1)(e), as it stood earlier, disproportionate is it. Now, my lords, in the Prevention of Corruption Act, my lords, the word family is not defined. Now, we have word family defined under various other statutes, my lords. Now, take for example, even the CPC, my lords. CPC, under Order 32A, Rule 6 defines family. Similarly, Central GST, they define family under Section 2, subsection 49. IT Act, Section 2, subsection 41 defines family. But in PC Act, my lords, we don't have a definition of what the family is. Now, when you're saying, my lords, I want to take even the family into the account of public servant, that provision itself is not there. to take family members, unless, my lords, as I pointed out, they must say this family member has this asset which in fact belongs to the public servant. That is very specific, my lords, for Benami, because Benami always commences with that averment.
Not be a matter of trial.
No, my lords. Averment is not a matter of trial. Matter of trial is proof of it. Now, if you're not even making an averment, subject to correction, my lords, I will show from the Benami Act itself. My lords, an averment should be there that this wife's property in fact belongs to the public servant. Then they can say, we have laid a basis. Now we are on the basis of an FIR, my lords, and investigation on that basis. At least there must be some basic facts to lay a foundation on. This is my submission, my lords.
The officer has declared all his assets in the annual property returns, the APR, of the wife independently or this, fine. Sometimes nothing is done. Suddenly the income or the properties in the name of the wife springs. What else can you call it?
My lords, they must point that out, my lords. If they're not even averring, my lords, I may be able to demonstrate how they don't take the income tax returns of the wife while doing this. So is it a case of saying in all cases, as soon as in the source report, they say wife has this asset, should we jump to the stage of investigation or there should be a balance before
Why
that?
don't you declare that in the APR?
APR, I don't think wives get separate.
No, family, sir. Family includes wife and all assets. It does include. Annual property returns of the government servant includes the assets and assets of the wife even if she is an independent income tax assessee.
I'll just check it up.
You declaring it to the income tax department is different.
Is different.
That is different for the purpose of income tax.
My lords,
now the APR should be declared here.
my lords, could I just point out one subtle difference that has taken place now? My lords, under 13(1)(e), they used to say from known source of income which you have declared before the appropriate authority. That was the usage under 13(1)(e).
That is now.
Now what they have done is, I'm sorry, my lords, though the amendments are in favor of the public servants, the amendments stand. As of now, no one has challenged it.
Now it need not, that is not even there.
Not even there. So now, my lords,
That's why in one of the cases I said I will read that back into this.
unless it's challenged, my lords. Someone has to challenge it. But unless if it is not challenged at all,
I will read that back into it.
challenge ಆಗ್ಬೇಕಲ್ಲ, my lords. Saying that this is bad, I will read.
Let's see.
Intention may be right, my lords, but unless someone is going to be saying it has to be read back to that.
Yes,
because
yes.
so many things. Then 17A, my lords. Approval, which was not there earlier.
No, that's altogether a new thing.
Approval.
17 is a new provision itself. ಇಲ್ಲಿ amendment.
ಅಮೆಂಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ತಂದಿದ್ದಾರೆ, ಇದರಲ್ಲಿ ಕೂಡ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ತೆಗ್ದಿದ್ದಾರೆ.
ತೆಗ್ದಿರೋದು ಸ್ವಲ್ಪ.
So, my lords, I'm sorry. There earlier it was the expression known source of income means income received from any lawful source intimated in accordance with provisions of any law, rule, etc. That is how it had read. Now, what is taken out now is, my lords, intimated in accordance with that is taken out in 2018.
I know, that's the amendment.
So, my lords, I'm sorry.
Intimation ಮಾಡಬೇಕಾಗಿಲ್ಲ.
ಈಗ ಮಾಡ್ಬೇಕ? No, as long as I'm able to explain the source, ಅಷ್ಟೇ. Satisfactorily, if I'm able to explain to them the source, that is it. It need not have been declared in that IT returns or in my annual.
No, that's why I said the declaration of a government servant of his assets in the APR is imperative, be it of his and his family members.
Someone will.
My
lord, someone may have to point it out.
Government servant is safe. He will not be facing these problems. Unnecessary prosecution or whatever.
Now, what has happened is we have got an expansion so far as the public servant is concerned. He can say, though I have not declared it there, but please look at this. This is how I'm satisfactorily able to account for. That is where.
What stage we will have to answer? That's very important.
Please,
Now, you register the FIR, bring him, show him as an accused, and then ask, yes, what do you say about it? Or you have to you have to ask him prior to the registration, and registration of the crime itself is obviated or not, we'll see. I know, it is the court.
No,
Then the registration of crime can't be stopped.
No, probably there, my lords. I'll point it out. I think it was our Chief Justice of the Supreme Court, Maheshwari. His Lordship, Justice Maheshwari's judgment. My lords, I will point out exactly what they have said there. Because we are under the impression now initial satisfaction is not required. Your satisfaction to the court is required. Anta. That is not the ambit or what exactly that they have spelled out in the judgment. If required, I will point that out.
Because there is many issues that have been decided now in this.
So, my lords, as I was pointing out, my lords, family is not defined here. So, if you're going to be including family as a unit into the three categories, that is asset, expenditure, and income, that the Act does not provide for. You can't say, my wife has this much of assets, my son has this much of assets, and then take them as a unit and then show that disproportionate asset insofar as a public servant is this. That can't be done. That is exactly how it is. My lords, if family is taken as a unit, then my lords, my respectful submission is, if family is taken as a unit, you take the assets of the family, you take expenditure of the family, add these two together.
Yes.
Please, my lords, you also take the income of the family. Now, I will be able to show from cases,
All right.
the wife's income is not taken, the children who are working, their income is not taken,
All right.
and then the calculation takes place only on the basis of the asset, and you come up with disproportionate asset. Now, my lords,
We will.
yes, my lords, asset plus expenditure
What is to
minus
be done in
income.
those cases?
Yes, my lords. How they're trying to work on it is increase the asset, increase the expenditure, keep the income minimal. So when you go to the calculation,
That is how 200%, 300%. Ilder baralla figure.
ಅದು income ಅಲ್ಲಿ if they correctly is taken, it will come down.
ಮಾಡ್ಬಿಟ್ರ ಮೇಲೆ ಕ್ರೈಮ್ ಹೆಂಗ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಕ್ಕೆ?
ಅದು correct. ಅದು correct. So if you're, see, formula ultimately is assets plus expenditure minus.
If it is 10%, 20%, ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ನೀವು when you give a representation, it will come down to 40%.
ಆಮೇಲೆ
30%.
But in the process, my lords, suspension, public
all that will
ridicule,
happen.
and virtually, my lords, as soon as there is a suspension order and a criminal case, stigma, my lords, stigma to the family, stigma to yourself. And in, my lords, there may be cases, 80%, 90% deserving cases for investigation, if it is there. Remaining 20, my lords, they should not get stigmatized. So that's why the safeguards that are given, my lords, to see, you no hurry for you to, tearing hurry to have an FIR and investigation. It's not there in a disproportionate asset. My lords, in fact, CBI, my lords, I can point out, though their manual says about 3 months preliminary inquiry, there are cases, my lords, where they've taken 9 months to finish the preliminary inquiry and come with the RC.
Yes.
Because there's no hurry. So, my lords, my respectful submission is, individuals cannot be included with public servant in DA cases. The only exception being Benami. Now, in this regard, my lords, in the set of citations that I've given, the second citation, my lords, would notice State of SP versus Uttam Chand Bora, 2021 SEC online, paragraphs 24 and 25. My lords, how they tried to bring an individual into that was 120B and 109. So then Supreme Court says, no, you can't do that. Kindly notice paragraph 24 and 25, my lords. It's at, starts at page 14, my lords, judgment starts.
Page 29 and 29.
Yes. Flags are not put. My lords, that portion, if my lords just notices
There is no evidence against respondent linking him to transaction related execution of sale deed. 120B against could not be made out.
120B and 109. So you can't
That
link
is on the
them.
basis of evidence, it could not be made out. That doesn't mean that you can't allege that.
My lords, please notice when
Evidence
when the allegation itself can lead to so much of consequences,
So
my
that
lords,
we will
please
answer.
notice that,
Yes.
my lords.
That will answer.
Then, my lords, now, in my lords, the next aspect is, if there's an allegation of the properties having been acquired through Benami, my lords, I made a submission, the allegation to be specific and the burden to prove on it is on the person who alleges it. In Benami, my lords, the person who alleges Benami, total burden is on them, my lords. Now, in that context, please notice Krishnanand Agnihotri, the third judgment in this, paragraph 26, my lords. This is in 1977 1 SEC 816, paragraph 26, my lords.
The 11,800 lying in the deposit.
Adralli, they dealt with Benami, my lords. Very important is how they dealt with, when you say Benami, what is Benami? My lords would have page 47, my lords. My lords, I
Yes.
hope that's marked. I hope it's marked.
What is marked?
in my lords, my lords, I'll just point out.
Page 47.
Page 47.
It is
about-
difficult to see how in the face of the overwhelming evidence of
Yes,
11,800.
My lord-
Allinda end orge is your Benami.
It must be remembered, my lords gets that. It must be remembered that the fixed deposit stood in the name of so and the burden thereof lays on the prosecution to show Shanti Devi was the Benamdar of the appellant. Now, my lords, after that, it is well settled that the burden of showing that a particular transaction is Benami and the appellant owner is not the real owner always rests on the person asserting it to be so. So there must be an assertion. That's where I'm coming to, my lords. Now, if you don't even assert that it is Benami, how is it that you're putting wives all into the assets into it? You must assert at least. My lords, this may be a correction later, my lords, but
Yes.
please notice this, asserting it to be so, and the burden has to be strictly discharged by adducing legal evidence of a definite character, which should either directly prove the fact of Benami or establish circumstances unerringly and reasonably
Raising
raising
an
an
inference.
inference of that inference.
There it is.
Please, my
Essence
lord.
of Benami is the intention of the
Parties
not
and not
thick
unoften.
wheel which cannot be easily pierced through such difficulties do not relieve a person of asserting a
The
transaction.
next sentence. But such difficulties do not relieve the person asserting the transactions to be Benami of the serious onus that rests on him, not justifying the acceptance of mere conjectures or surmises as a substitute for proof. It is not enough merely to show circumstances which might create suspicion. My lords, please notice. Now, just by putting wife's name, you can't say suspicion. Suspicion because the court cannot decide on the basis of suspicion. It has to act on legal grounds established by evidence. Then after two lines, however strong may be the suspicion, the court in this connection, it cannot take place of proof. This is settled position. So without an assertion being done, I'm on the word assertion, my lords. Now, without telling anything in the source report, you merely put the properties belong to the wife, the children, the relatives into assets. That, my lords, that practice totally has to discontinue. And CBI very consciously, my lords, when they do their FIR and when they show the statements, they clearly assert this is a Benami property. Now, once an assertion comes, then later, my lords, after that investigation. So, my lords, these are the judgments where public servant. Now, my lords,
first issue.
The first issue, then, my lords, no concept of vicarious liability in PC cases, like my lord Sunil Bharti Mittal's case. So we have kept it, my lords, to say they can't even fall back on the concept of vicarious liability there. Then, my lords, so present cases are not one where allegation is that family members have to so and so. My lords, so this is so far as point number one is concerned, which involved both the aspects, my lords. One is on family members, and the other aspect is with regard to the intention of the act itself, my lords, how it is intended and how disproportionate asset stands on a different footing. Now I come to the second aspect of how the word order has to be construed. Because, my lords, in this act, we may have words such as, my lord, 17A, approval, 19, sanction, second proviso to section 17, order. Now, kindly notice the different usage of words there, my lords. And in my respectful submission, each word has certain meaning associated with the extent of application of mind in it. So, my lords, if I look at how it is done, like how we see even in the CRPC, my lords, we have different stages of application of mind, my lords. Initially, my lords, when just cognizance is taken. Second, more application when you issue summons, because that's the first time you're summoning an accused. Then after he comes, my lords, HBC, discharge your application of mind becomes that much more. Then after prosecution evidence, there's a stage, my lords, for considering it. The court applies more application of mind. Finally, my lords, after argument, proof beyond reasonable doubt. This is how the whole scheme of CRPC would be. Similarly, my lords, in the PC Act also, the usage...
You are suggesting that at the stage of registration of crime, there need not be application of mind.
No, I'm not suggesting that.
Levels increase as the in the trial.
My lords, I'm suggesting, my lords, when it comes to an order under 17A, which only deals with mere according approval.
So there need not be application of.
It's not that there need not be. The application of mind is little less when compared to the next stage. My lords, when compared to the next stage, when you go under 19 and get a sanction. Now you have the investigating papers with you. You apply your mind on that. And then my lords,
Those are rudimentary.
and then order. Please notice this in terms of order then. Now, why is it that the legislature used the word order for the second proviso of 17? My lords, may I have the second proviso of 17 for a minute? Could I just read that proviso itself, my lords? There are two protections my lords would see there. The first proviso and
General or special order.
how? First proviso is, my lords, you want a high-ranked officer to be investigating any case under the PC Act.
The second proviso,
Yes,
without the order of the police officer.
no, my lords. First, I'm sorry, my lords. First proviso only, provided that if a police officer
Yes, correct.
not below the rank of inspector of police is authorized by the state government in this. So, my lords, the object is, if my lord sees earlier to that, they would say, my lords, under A, B, and C, who can investigate? So, CLE, minimum was DYSP. Now, exception to that is, by special or general order, you can give to an inspector. Individual cases, my lords, but now they're doing a general consent in saying inspectors can do it. Object of the act is you want a higher ranked officer to be investigating
In a given
cases
case.
under the PC Act. It applies to everything. Second proviso is exclusive to disproportionate asset. Second proviso, my lords, provided further that an offense referred to in clause
13(1)(b),
B
yes.
shall not be investigated without the order, my lords, order is what I'm stressing on, of a police officer not below the rank of a superintendent of police. My lords, two things my lords may notice here. One is the word order, and the second is the word investigation. Investigation assumes importance in the context here, my lords. Now, my lords, if the legislative intention was you can't permit a registration of an FIR, then, my lord, second proviso would have read before registration of a crime. Now, that was not the intent of the legislation. They said there can be a registration of a crime, but if you're going to be permitting investigation, as my lords has seen, my lords, 154, mere on an information disclosing a cognizable offense, mandate to register FIR. Now, you want to investigate into it. Under normal course, automatically investigation begins. But here, an extra protection given. The protection is saying, after the registration of that FIR, the matter has to be placed with an officer not below the rank of an SP. SP applies his mind to say, look, I have seen source report, PE, and the FIR. I'm applying my mind to say, should I permit investigation or not? That is the object behind the second proviso to section 17. This would be my respectful submission. Now, here, my lords, why I would say so is, my lords has seen Bhajanlal's case, which we had relied on, my lords. In Bhajanlal's case, ultimately Supreme Court found fault with the order that is being passed under the second proviso. A complaint against the ex-chief minister is given to the office of the chief minister. Chief minister sends it to the DGP. He sends it to the SP. SP says, register FIR and investigate. That ultimately Supreme Court says this cannot be an order under the second proviso. So, my lords, this word order and investigation assumes great importance. Now, in that context, my lords, that is where I pointed out, my lords, when we say an order should definitely be with reasons. We can't have an order sans reasons. That, my lords, has held even in, I think, Sri Rupa's case.
Yes.
I'm sorry, my lord. And also the coordinate bench, my lords, which very deeply has dealt with what is application of mind for an order. I'll point that out. So, my lords, my respectful submission is what an order should contain. This precisely has been answered in Satish S. my lords, versus State of Karnataka in that batch of matters.
Coordinate bench.
My lords, paragraphs 31 to 39.
This is Hemant.
My lords, that is in the second, volume 3. I'll just pass that out.
Commodities.
I'll just point that out, my lords, because the word order.
No, that we have seen. Now we'll do one thing. We'll continue again tomorrow.
Tomorrow.
Yes. Every day.
Please, my lords.
Tomorrow at 4:30 we'll start.
Whatever. Because I'm sorry, my lords, I'm going a little deeper into the
Other
subject
councils
because
will be waiting. Other will take it off. 4:30 I'll take this tomorrow.
my lords,
Tomorrow,
I'm
not
going
day
a
after.
little in depth, but I'm sorry, my lords,
No
because
problem.
it's a
Yes.
batch of matters.
We'll answer in depth.
Please.
Yes. ಬೇರೆದು ಯಾವ್ಯಾವ್ದು ಇವತ್ತು ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಅದನ್ನೆಲ್ಲ ಇದಕ್ಕೆ ಕೊಡಿ. suspension alwa. We will direct no coercive or precipitative action will be taken. 41 ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. ನಿಮಗ್ ಸಂಬಂಧ ಇಲ್ಲ. Suspension ಮಾಡ್ತಾರೆ ಅಂತ. The pursuant to the register, they heard so and so. Notice ಮಾಡಿದೀನಾ ಪ್ರಸನ್ನ ಕುಮಾರ್? Learned Counsel B.B. Patil is directed to accept notice for the respondent. The Learned Counsel for the petitioner submits that action is taken to place the petitioner under suspension on account of the registration of the FIR. The investigation shall go on, but no precipitative action shall be taken against the petitioner. Precipitative or coercive action will be taken against the petitioner. Mail ಹೇಳ್ಬಿಟ್ಟು ಬರ್ದಿದ್ದೀನಿ ಅನ್ಸುತ್ತೆ ತೊಂದ್ರೆ ಇಲ್ಲ.
My lords, 42 and 109 are also same. 149, 42 and 149, same my lords, same order.
ಅದರಲ್ಲೂ ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಬಿ ಲತೀಫ್ ವಾಟ್ ಎವರ್. ಎಸ್ ನಂಬರ್ಸ್ ಕೊಡಿ ಯಾವ್ದಿದೆ ಅಂತ.
Serial number 96, your lordship. It is not a DA case, 13A case.
96 ಲಿಂಕ್ ಮಾಡಿ ಅಲ್ಲ ಲಿಂಕ್ ಆಗಿಲ್ಲ
And 100, your lordship.
Already not D. Not D. They'll come next week.
And 105,
They'll come on 20th.
please lordship. 105, our name may be deleted, your lordship. It is served on Venkatesh Arbatti.
1 minute ಅದು ಕರಿತೇನಲ್ಲ ಅಡ್ಮಿಷನ್ ಕೇಸಸ್ ಕಾಲ್ ವೇಟ್. ಕರ್ದಾಗ ಹೇಳಿ ದೆನ್ 4:45 ಹೇಳಿ. ಎಸ್ I'll take it madam. Bail matter ನೋಡ್ಕೊಂಡ್ ಬಂದಿದ್ದೀರಾ? Yes, I'll take it. Halima madam, before I rise, I'll pass orders and.
Yes, enough.
Continue ಮಾಡ್ಬಿಡಿ. ಇನ್ನೊಂದು 4 PM ಒಂದಿತ್ತಲ್ಲ. I'll take it one moment. Is not there?
4 PM matter.
I know. Where is he?
He's logged in.
Locked in where? Logged in.
Logged in. Lord, I wanted to tell your lordships, I was about
Word is locked in.
Fortunately, I will take the services of my learned
No,
friend.
not now. Just wait. I'll just run through the list and get back to you, Nandakumar.
I'm sorry.
Chandesh Chowta ಅವರು ಇದ್ದಾರೆ. ಅವ್ರು ತಾನೇ ರೆಸ್ಪಾಂಡ್.
ಅವರು ಇದ್ದಾರೆ ಅದಕ್ಕೆ.
Why are you waiting? 147 ಕರೆದ್ವಾ? ಇಲ್ಲ ಅದೇ ಎಲ್ಲ ಟು ಬಿ ಟೇಕನ್ ಲೇಟರ್ along with other cases. 20th. All other ಅಲ್ಲ these other matters are tomorrow.
Question to the court. The lordship desires that I be there tomorrow again because I am.
No, let the
Mine is on the 13th.
true. ಸಂದೇಶ್ ಚೌಟ ಅವ್ರು ಆದ್ಮೇಲೆ ಮಾಡೋದು ಮಾಡಿ ಇಲ್ಲ ನೀವು ನಾಳೆ ಮಾಡೋದು ನನಗೇನು ಎನಿಥಿಂಗ್.
20th of if it is called.
No, I'll take it tomorrow and again on Friday.
Friday.
Yes. And I'll begin at 4:30.
Friday I am at the port.
Then whenever you come, we'll have it.
So it will be on board.
It will be on board. Yes.
143 was passed over.
140?
143.
ಅದು ಅಷ್ಟೇ ಎಲ್ಲ 143 is different. No, that is reserved. You are for the petitioner.
I am for the petitioner.
Oh, I have heard it. That's that association of
Association versus agency.
age home, right?
I am the service provider, old age home.
Provider. Yes, I've heard it. That I have reserved.
Very well.
That's not passed over. He was there.
Yes, sir.
Yes.
And then can I request your lordship to have it on 20th? There is
ಅಲ್ಲ ನಿಮ್ದಕ್ಕೆ 20th ತಗೊಂತೀನಿ. No worries. ಅಲ್ಲೇನ್ ಮುಗಿಯಲ್ಲ ಅಷ್ಟರಲ್ಲಿ.
I have raised an issue with regard.
I'll hear you separately. No problem.
I have just beforehand I will.
Yes.
I have questioned the very prosecution on the ground that I don't satisfy the definition of public servant.
Why? ನಿರ್ಮಿತಿ ಕೇಂದ್ರ ನಿಮ್ದು.
ಅಲ್ಲ ನಿರ್ಮಿತಿ ತಮ್ಮ ಜಡ್ಜ್ಮೆಂಟ್ ಓದಿದೆ ನಿರ್ಮಿತಿ ಕೇಂದ್ರ ತಾವು ಹೋಲ್ಡ್ ಮಾಡಿದ್ದೀರ.
ಆಯ್ತು.
I am an officer of the Karnataka Legislative Assembly Secretariat.
Oh, this all right.
I fall under section 183, article 183, read with article 200.
Retired person.
Not retired, he is still
in service.
He has been demoted to the post, rather reduced in rank.
All right. Yes.
So on that issue.
ನಿಮಗೆ ಕಾಯ್ತಾ ಇದ್ದೆ.
Sincere apologies, my lords. I was on my legs in another court.
I were always on legs in other courts. Never come here.
No, my lords.
So I'm hearing that tomorrow ಮತ್ತೆ at 4 o'clock, 4:30 I'll take it every day.
tomorrow, please.
Half an hour every day or 45 minutes every day.
Please.
Will come on 20th.
No problem.
Obliged.
Whenever you want, it will be on board.
That's the only point I want to make. Otherwise, your lordships have heard on other issues, like application of mine, section 17.
Yes, yes. No problem. I'll call every matter. Wait. Yes.
My lord, one matter was mentioned in the morning to be taken at 2:30.
ಏನದು urgency na?
My lords, the SIT has issued the notice.
The matter which we have moved, is yet to be called. We had moved in the
ಬಂದಿದೆ madam. We'll call that matter. Sunil Kumar. In 2 and 2.1.
Sorry.
Same word. Connected with 2 point, ಇನ್ನೊಂದು ಯಾವ್ದು ಇದೆ?
Yes, my lords, but now I am on criminal petition 7596, my lords, where we have filed this IA.
What has happened now?
My lords may kindly notice in that the IA page 11 ಅಲ್ಲಿ, the interim order.
B.S. Prasad, ನಿಮ್ದು.
For the purpose of closure for that, function, my lord. Because of that reason, we should notice for the information given by the.
So you are withdrawing that notice?
Only stay is concerned, not to give a charge. It's a charge sheet, it's already filed. It's only for the purpose of additional charge sheet, my lord. They issued a notice.
So then now I'll stay everything then.
No, but they are not.
Is it a close?
Why do you flex your muscles when the matter is pending and there is an order?
And the charge sheet, we sought for the liberty, my lord, we have to file additional.
ಅದು ಕೆಳಗಡೆ ಫುಟ್ ನೋಟ್ ಇದ್ದೇ ಇರುತ್ತೆ ಎಲ್ಲದ್ರಲ್ಲಿ.
That we have to close that one.
ಏನ್ ಕ್ಲೋಸ್ ಮಾಡ್ಬೇಕು?
Additional charge sheet ಏನು ಇಲ್ಲ ಅಂತ close ಮಾಡಿ.
ಏನು ಇಲ್ಲ ಅಂತ ಕ್ಲೋಸ್ ಮಾಡಕ್ಕೆ ಇವ್ರೇ ಹಾಕ್ಬೇಕು ನಿಮ್ಗೆ. ಅಲ್ಲಿ ಇವ್ರೇ ಹಾಕ್ಬೇಕು ಅದಕ್ಕೆ. ಸುಮ್ನೆ ಬರ್ಲಿ ನೋಡೋಣ.
Not like that.
ಕ್ಲೋಸ್ ಮಾಡ್ತಾ ಇದೀವಿ ಅಂತ ಹೇಳಕ್ಕ.
For the instruction, my lord, you have to close that.
You close it. You will be happy.
That too, my lord, kindly see, notice also issued on, issued 12/6/2024, it's already over.
The note, I'll record that notice has spent itself, but you will not venture into issuing another notice for the purpose. All right. The matter is moved to be taken up at the end of the list of the date. The reason for moving is that a notice issued by the respondent special investigation team seeking appearance of the petitioner. The learned counsel B.S. Prasad would clarify that the liberty sought to file an additional charge sheet under 173(8) should be closed as there is nothing to file as an additional charge sheet. For that purpose, a notice was issued. The notice is dated 12/6/2024. It has obviously spent itself today. The learned counsel would submit that no other notice would be issued to the petitioner during the pendency of the subject petition. Okay? Yes. Yes.
Is a cancer patient, senior citizen, my lords. That's what we had pointed out.
ಅವ್ರನ್ನ ಕರ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತೀರಾ ನೀವು?
ಬರೋದು 80 ವರ್ಷ ಆದ್ಮೇಲೆ ಸಿಕ್ಕಾಕೊಂಡ್ಬಿಡುತ್ತೆ.
ಅಲ್ಲಿವರೆಗೂ ಆಗದೆ. What a statement, no sir.
Statement of experience, my lord. Statement of experience, yes. Statement of experience.
ಎಲ್ಲ ಇನ್ಫೆಕ್ಟಿವ್ಸ್ ಆಗೋದು.
DA cases also, my lords, after 8 years, they are saying that, my lords, 8 years cancer patient, that patient, like that.
That patient is patient. 8 years itself, sir, what is this? You can't, take it so, take cancer so lightly and say, then.
Every case we are facing.
Every case you are facing cancer problem?
DA cases, lords, 2010 acquittal cases and conviction cases. Everybody, my lord, they will come with the death certificate. It's infectious.
No, that's not, that reflects on the system.
Please.
Not the individual. Corrective measures there should be needed. 10 years, 12 years.
Expediting the process.
Obviously, yes.
Expediting.
Yes, baby Patil ಅವರೇ.
Please.
ಇದಕ್ಕೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಬರ್ತೀರಾ ಹೆಂಗೆ?
I'll come. Tomorrow I'll be there at 4:30 every day.
ಬನ್ನಿ.
Every day. Please, my apologies.
No problem. In the lighter ways.
Please, deeply.
I know you'll be very busy.
No, it's not the least.
What is Halima madam has moved?
Orders.
What urgency, madam?
going to lose his job if it is not allowed, my lord. Because of that, his passport is being impounded.
I told you, passport ಬೇಕು ಅಂದ್ರೆ ಶಾಂತಿ
That's-
ಭೂಷಣ್ ಇಂಪ್ಲಿಟ್ ಮಾಡಿ. Sorry.
If this is disposed of, it is a split up case, all other accused are acquitted. He is accused number 7, on 1 to 6 are all acquitted, my lord.
ಈಗ ನಾಳೆಗೆ ಲಿಸ್ಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಲಿಸ್ಟ್ ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ.
Yes, my lord.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಇನ್ ದ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್.
Yes,
ಎಸ್ ಸ್ಪ್ಲಿಟ್ ಚಾರ್ಜ್ ಅಲ್ವಾ?
split up.
ಆಯ್ತು. ಎಸ್ ಸತ್ಯನಾರಾಯಣ್
My colleague,
ನೀವು ಮಾಡಿರೋದ?
settlement ಆಗಿದೆ parties.
ಆಯ್ತು. ಏನ್ ಅಫೆನ್ಸ್ ಏನು?
Husband. Matrimonial dispute, your lordship.
ವೈಫ್ ಅಂಡ್ ಹಸ್ಬೆಂಡ್ ಅಂದ್ರೆ ಅದೇನೆ.
498 A ಅದು.
ಹ್ಮ್.
I am filing
ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ
ಇಲ್ಲಿದೆ ಅಲ್ಲಿಗೆ ಸೆಟಲ್ಮೆಂಟ್ ಬೆಳಿಗ್ಗೆ ಇದ್ರ ಮೇಲೆ ಆಗ್ತಾ ಇದ್ವಿ.
ಯಾವ್ದ್ರ
ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ಅಲ್ಲಿ I have produced the copy, my lord. Yeah.
ಅದಕ್ ಮುಂಚೆ ಇದೇ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡೋದ?
ಅಲ್ಲ ಅದಕ್ಕೋಸ್ಕರನೇ
ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ ಇಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಚೆಕ್ ಈಗ ಅಯ್ಯೋ ಎಷ್ಟು 50 lakhs rupees ನಾವು ಕೊಡ್ತಾ ಇದೀವಿ, ನಾವು ನಾಳೆ ಬೆಳಿಗ್ಗೆಗೆ ಅಲ್ಲಿ ಕೊಡ್ತಾ ಇದೀವಿ, ಕೊಡ್ತೀವಿ. ಬಟ್ ಬಿಫೋರ್ ದಟ್ ದೇ ವಾಂಟ್ ಟು ಸಿ ದಟ್ ಇಟ್ ಮಸ್ಟ್ ಬಿ ಕ್ವಾಶ್ಡ್.
ನಾಳೆ ಅಲ್ಲಿ ಕೊಟ್ಬಿಟ್ಟು ಸಾಯಂಕಾಲ ಇಲ್ಲಿ ಬನ್ನಿ.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ಮೈ ಲಾರ್ಡ್.
They will not close it before the settlement is arrived at there.
No, it is settled, your lordship. It is settled, my lord. Agreement is also.
ಅಲ್ಲೆಲ್ಲ ಮುಗಿಸ್ಕೊಂಡ್ ಬನ್ನಿ.
The thing is, my lord, agreement formally it has to be signed, your lordship, and check to be delivered.
ಎಲ್ಲ ಶಾಸ್ತ್ರೋಕ್ತವಾಗಲಿ.
ಒಂದ್ಸರಿ ತಾವು ನೋಡಿದ್ರೆ ಒಂದು
ಅಲ್ಲಿ ಮುಗಿಸ್ಕೊಂಡ್ ಬನ್ನಿ. I will take it here.
Yes.
You settle it, close it there. On that conditions there, I will close it here.
Our difficulty.
ಯಾವತ್ತು ಬೇಕು ನಿಮ್ಗೆ?
ಅಲ್ಲ ನಾಳೆನೆ ಇದೆ ಅಲ್ಲಿ ಆಕ್ಚುಲಿ.
ನಿಮಗೆ ಇದು ಯಾವತ್ತು ಬೇಕು?
ಇದು ನಾಳೆಗೆ ಹಾಕಿದ್ರೆ ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಮುಗಿಯುತ್ತೆ ಅಂತ ಹೇಳ್ಬೋದು ನಾವು ಅಂತ ಅಷ್ಟೇ.
ನೋ ಪ್ರಾಬ್ಲಮ್.
They will come and say that.
ಟುಮಾರೋ ಆಗಲ್ಲ. ಟುಮಾರೋ ಬೆಳಗ್ಗೆ 2:30ಗೆ ಇದು ನಂಬರ್ ಬರ್ಕೊಂಡು 2:30ಗೆ ಪೋಸ್ಟ್ ಮಾಡಿಸ್ತೀನಿ.
ನಾಳೆ
ಲಿಸ್ಟ್ ಇಸ್ ಕ್ಲೋಸ್ ನೌ.
Yes, ನಾಳೆಗೆ 2:30.
Day after tomorrow morning I will take it, no problem.
Our party is ready to come anytime, my lord. The other side, my lord, is very difficult to get them in spite of all this.
ಇಲ್ಲ, tomorrow you will find
For
them.
apprehension, only this.
Tomorrow you settle and come, sir. If the other side is not there also, I will close it.
Yes,
But you should settle and produce everything here.
There is no problem at all.
All
We will
right.
settle.
Day after tomorrow morning. Sorry. Call the case. Let's continue. 4 PM, Kumar Ramel Town. I'll take it. Wait.
230 matters.
Huh?
230
Settlement cases.
Voting settlement,
Yes.
127.
Muralidhar.
For the petitioner, your
Hearing for the respondent, my lord.
lordship, you have filed joint memo, 498A, 3 and 4 of DPI. Parties are present, your lordship.
Parties are present.
File ಮಾಡಿದ್ದೀರಾ?
Yes, your lordship.
Yes. Joint memo ಎಲ್ಲಿದೆ? Page ಹೇಳಿ.
So we have filed separate.
ಕೊಡಿ.
The counter we have filed.
Respondent is entered ಇದಾರಾ? You such lengthy settlement. This is shortest settlement I've seen.
So our mutual consent, they have settled.
Reunion na?
ಇಲ್ಲ ಸರ್, mutual divorce ಆಗಿದೆ. 13 back.
ತುಂಬಾ ದೊಡ್ಡದಿದೆ ಸೆಟ್ಲ್. 498. Yes, close ಮಾಡಿ. Yes, sir. Next. 128, Manjula.
28.
This case,
Offense.
Offense is
filing
report
occurrence for respond number 2. Occurrence for filing, occurrence for respond number 2.
Offense ಏನು?
19,420, my lord. Forgery of documents and sale.
Yes.
As per annexure.
ಎಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡಿ. ಕೊಡಿ.
Before trial court, they have compromised the OS case, my lord.
1 minute.
Compromise.
ಇಲ್ಲಿ ಹೇಳಿದಿರಲ್ಲ ಮೇಡಮ್ ಅದನ್ನ.
Please, madam.
Please, my lord. On the basis
Madam,
of-
ತೊಗೊಳ್ಳಿ.
ಜಾಯಿಂಟ್ ಮೆಮೊ ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಕಾಂಪೌಂಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಜಾಯಿಂಟ್ ಮೆಮೊ ಇಲ್ಲಿ ಪೇಜ್ 4 and 5. Yes.
ನಂದಲ್ಲ, ಬೇರೆಯವ್ರು.
So and so enters appearance for
Colleague ಇದ್ದಾರೆ. ಅಲ್ಲ, colleague ಇದ್ದಾರೆ.
ಗೊತ್ತಲ್ಲ ಸರ್. Yes.
One submission, parties are before the court, my lord, my presence may be noted.
ಇವತ್ತು ಯಾಕೆ?
ಅಲ್ಲ ಇವತ್ತಲ್ಲ, just they are before the court, my lord. Tomorrow for any reason.
All right,
Yes.
ನಾಳೆ ಅಲ್ಲಿ ಮುಗಿಸ್ಕೊಂಡ್ ಬನ್ನಿ. We'll settle it here. No.
Please.
You finish everything there and produce that here,
Yes.
we will close it.
Obliged.
Partly said.
129.
Yes, next. Amar,
Milords, in this case, Milords, I'm seeking for an adjournment
all right,
on
but what's the offense?
Milords 447 and 427.
When do you want?
Milords, on Friday, Milords.
13th,
13th.
2:30 PM.
Obliged.
13, 2:30 PM to report settlement. Next.
130.
My lords, I appear for respondent number 2 in this matter. My lords,
Arun Govindraj.
50 ಲಕ್ಷಕ್ಕೆ ಸೆಟ್ಲ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ.
ಇವತ್ತವರೆಗೂ ಸೆಟ್ಲ್ ಆಗಿತ್ತಾ?
ಅಲ್ಲೇ ಫ್ಯಾಮಿಲಿ ಕೊಟ್ಟು ಸೆಟ್ಲ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ. ಅದ್ರ ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಸೆಟ್ಲ್ಮೆಂಟ್ ಡೀಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀವಿ. ಇಲ್ಲಿ ಕೋಆಪರೇಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಳಕ್ಕೆ.
ಈಗ ಕೋಆಪರೇಟ್ ಮಾಡ್ತಾ ಇಲ್ವಾ?
ಅವರು ಸ್ವಾಮಿ
page 111 for a moment, my lords.
ಸೆಟ್ಲ್ಮೆಂಟ್
Para number 5F. He has to settle the disputes with the landlord. That he has not settled it as on today. Page 111. Petition number 1 undertakes to settle all the disputes arising out of OS and RFA without any liability on petition number.
Yes,
ಯಾವುದು ಪೆಂಡಿಂಗ್ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಎಲ್ಲ ಡಿಸ್ಪೋಸ್ ಆಗೋಗಿದೆ.
ಎಲ್ಲ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ.
RFA is still pending. I filed the RFA. There is no
ಕೊಡಿ,
instructions as such.
ಡಿಸ್ಪೋಸ್ ಆಗಿರೋದು ಆರ್ಡರ್ ಕೊಡಿ.
ಅದ್ರ ಕೊಡ್ತೀನಿ ಸರ್.
And one other thing, my lords, para 7, they say that they withdraw all the allegations. In the petition at para number 4, again, my lords, they state that she was in an adulterous relationship.
In 2 days. ಇಲ್ಲ ನಾಳೆ.
ಅದನ್ನ remove that in the settlement. The learned counsel for the petitioner seeks 2 days time to do the needful. The needful is as per clause 7 and clause
5F.
5F
And
of the memorandum of settlement. Friday? List on Friday.
Is grateful.
ಹಿಂಗಿದ್ರೆ ಕೋಆಪರೇಟ್ ಮಾಡಲ್ಲ ಅವರು. ಎಸ್.
And then they withdraw and then they make same allegations again.
Next.
131.
ಲತೀಫ್,
Please, Lord, I'm filing.
ನೀವೇನು
Petition.
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್?
Lord, 366 is the offense. Lord, the accused number 1 and the victim girl had an engagement. Thereafter, there was a misunderstanding and victim girl eloped with the accused number 1. Then father filed a complaint saying the abduction of the victim.
ಈಗ ಎಲ್ಲಿದ್ದೀರಾ ಇಬ್ರು?
Both of them present.
ಅಲ್ಲ, ಒಟ್ಟಿಗೆ ಇದ್ದೀರಾ?
Illa, they are dissolved.
All right. Yes, sir. 366. ಕೊಡಿ, ತಗೊಳ್ಳಿ ಅದು. ಸರ್.
$164 statement also produced. There is no allegation of any offense under this 376 or nothing.
376 is the
Illa,
allegation?
no such allegation.
The charge sheet is not agreed.
Charge sheet is filed. No such allegation.
SC ಆಗಿದೆ 159. SC is for 366. Yes. ಇದನ್ನೇ ಕೋಟ್ ಮಾಡಿ. ಬಟ್ ಎಲ್ಲ 10 days ಬಿಟ್ಟು ಕಾಪಿ.
Please.
Yes. Next.
130.
130? Rajshekar Reddy.
488A and B and 4.
Learned counsel so and so undertakes to enter appearance. Kodi settlement kodi. Parties are there? Immediate 320 application. Settlement, yes.
Settlement correct.
Yes. Signature. Next. 133.
33 ಆಯ್ತು.
ಜನ ಆಯ್ತಲ್ಲ? ಆಗೋಯ್ತಲ್ಲ? Yes. Now call the cases.
51.
ಇದು ಇದೆಯಾ?
For petitioner.
ತಗೊಳ್ಳಿ.
Sir,
Offense?
420, my lords. Civil suit is
420.
settled, my lords. 420, 465.
Where is the affidavit? ಬರೀ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಆಗಲ್ಲ. ಎಲ್ಲಿ ಸೆಟಲ್ ಮಾಡಿದ್ರಿ?
Civil suit, my lords.
ಎಲ್ಲಿದೆ?
I have produced that annexure L and M, my lords. I have produced the copy of the order, my lords. Compromise.
Compromise petition.
Compromise petition.
The madam petitioner so and so. The parties were
Respondent number 2 is in person present, my lords.
advocate ಇಲ್ವಾ?
No.
Compromise ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
The petitioner is before this court, petitioners are before this court, so and so Madi. The parties were before the civil court in OS 405 of 2021. But who will identify this respondent? Aadhaar card ಕೊಡ್ಬೇಡಿ ನನಗೆ ಈಗ. Who will identify ಅಂತ ಕೇಳಿದ್ದು? Counsel. Some counsel should be there ಅಲ್ವಾ?
Is the brother my lord.
ತೊಂದ್ರೆ ಇಲ್ಲ ನನಗೆ, I don't know. Then tomorrow there should not be a problem.
Nothing my lord.
You get some counsel to identify. ಈಗಲ್ಲ ವಕಾಲತ್ ತಗೊಂಬನ್ನಿ ಅಂತ ಹೇಳಿದ್ದು, ಅಲ್ಲಿ ಯಾರನ್ನೋ ಕರ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ಟ ಆಮೇಲೆ. ಎಸ್, ನಾಳೆ ಹಾಕ್ಲಾ? ಇಲ್ಲ, ಅಲ್ಲಿ ಪಾಸ್ ಇಟ್ ಓವರ್. 10 minutes you can get someone. Get. Yes. Next.
Continue. Hearing on I-77.
Traveling abroad. Who is traveling abroad?
Petition number 3, who is the applicant in this particular IA, my lord, is traveling abroad, my lord, because of he has to continue his education. He secured a
What is the offense?
419, 420, 465, and 468 and 471, my lord. They are innocent purchasers, my lord, basically. My lord, P3.
Interim order ಇದೆಯಲ್ಲ?
ಇದೆ, my lord. Even though, my lord, if
They are the ones, they have impersonated the signature by
They are purchasers.
purchases.
Yes.
Lots.
my lord, while purchasing the property, we have made a payment through DD, and then the DD has been encashed by P.
Where
Basuranju,
is
who
the
is
purchasers impersonating? The vendor may have been impersonated. You should look into it and come, madam.
Please, my lords.
When are you traveling?
my lord, tomorrow morning, early morning. my lord.
Tomorrow early morning. Why ಜಲ್ದಿ ಮಾಡ್ಕೊಂಡ್ರಿ?
No, my lord, actually, he has written the examination 6 months ago, my lord. Now he got that case, approval from US, my lord.
All right, well, the application is pending. What do you say about the application? Have you seen the application?
They filed permission to seek.
Madam, this will not do. You should get ready. They have filed the application true.
Please, tomorrow.
ಇದು ನಾಳೆ ಬೆಳಗ್ಗೆ 10:30 2:30 ಮೂವ್ ಮಾಡಿ. ಈಗ ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗಿರುತ್ತೆ. I'll take it at 2:30 and close it. ನಾಳೆ ಟ್ರಾವೆಲ್ ಮಾಡಕ್ ಆಗಲ್ಲ.
My lord, the ticket, he has already taken the ticket.
Defer the
My lord,
ticket. You are
he has
facing a
to do
crime,
his
sir.
Post-graduation, my lord. He has to do the post-graduation, my lord. Only the permission.
No problem, sir. We'll take it tomorrow at 2:30. You move it at 2:30. Yes.
My lord, argument on IA only, my lord. The further
Argument and IA, if they want to file objections, should I not give them an opportunity? Tomorrow we'll take. Madam, if you don't go through and come tomorrow, I'm going to grant this order.
No, my lords.
Yes. Permission ಕೇಳಿದರೆ ಅಂತ ಟೈಟಲ್ ಇದೆ, ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಅಂತ ನೋಡಿ.
Please, my lord.
Yes. Tomorrow.
38.
ನಾಳೆ ಮೂವ್ ಮಾಡಿ ಬೆಳಗ್ಗೆ. ಮೇಡಮ್ ನಾಳೆ ಅದು ಹಾಕ್ಸಿ ಬರ್ಕೊಂಡಿರಿ. ಆಗುತ್ತಾ? ಸರಿ ಮಾಡ್ಸಂಗ. ಎಸ್ ಆಯ್ತು, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಬರುತ್ತೆ. ಯು ರಿಮೈಂಡ್ ಮೀ ಟುಮಾರೋ. ಎಸ್, ನೆಕ್ಸ್ಟ್ ಸತೀಶ್ ಚಂದ್ರ.
A1 is already stay by the Salva Court, Your Honor.
A1 stayed.
Stayed.
Court,
By
yes.
the court.
Page.
ಅಲ್ಲ, ಅದರಲ್ಲಿ
Page.
office is noted and produced.
Which page, sir?
I am not produced it.
They are list on Tuesday in the fresh matters list. Produce that. Yes, next. Tuesday in the fresh matters list. Next.
For the petitioner and serial number 79, my lord, it's for an offense under 188 IPC.
That's all right. What is this office dispensation?
Only for typed copy, dispensation of typed copy, my lord. I have produced a certified copy. All the orders are already typed. It's only some notes on the left side.
This subject dispensation so and so allowed. List on any urgency.
My lord, it's for framing of charge.
When Tuesday fresh matters. Yes. Next.
PT?
Madam, dispensation I allow ಮಾಡಿ. Tuesday fresh matters. Next.
In this review petition, I appear for the respondent, my lord. The respondent was the petitioner.
ಏನ್ ರಿವ್ಯೂ ಇದರಲ್ಲಿ?
ಅವ್ರು ಕೇಳಿರೋದು ಏನು ರಿವ್ಯೂ?
ಕಾವೇರಿ ನೀರಾವರಿ ನಿಗಮ್ ಟೆಂಡರ್.
Tender matter, I was the successful bidder, my lords. Some stranger gave a complaint before the Lokayukta. Therefore, my lord, my tender got cancelled and they were in the process of issuing fresh tender.
Petition. What is the problem now?
Petition was allowed. Now, in the review petition at para 9, ground 3, my lords, page 9, ground 3, They say that they require some more direction from this honorable court. Because
what?
Once it is in the re-tendered status, they cannot issue the finances. That is what they say. They seek for a clarification or
No clarification. None appears for the petitioner. List the matter on 20th in the fresh matters list. Yes.
top of the list.
Why, sir? Bottom of the list. Yes. Next.
81.
My lords, I have filed contempt also, my lords, this. Because of this review petition, I am not able to.
Yavat is the contempt.
Contempt, my lords, notice has been issued. But
Yes, 20th will close it. In the fresh matters list.
Please.
Yes. Very good.
13-1 name.
Learned counsel, notice on Sharath Gowda accepts notice for respondent. Registered to print the name of someone. Yes, Prithvesh, ಏನಿದೆ?
13-1 name. 150% in source report, 15%.
For direction ಏನಿದು?
That's, it can be taken up tomorrow.
Yes. List tomorrow ಆಗಲ್ಲ.
Along with those 13.
Yes.
Along with 13.
All right. Next.
Great.
Tomorrow, next.
82.
A for correction.
IA for direction, this is that Uganda.
For direction, ಎಲ್ಲಿ? Shanti Bhushan.
He was here.
What happened?
What happened was on 26/8/2024, I issue an email with all the documents. Today at 1 PM, Kara responds. I just point out what has happened.
Have they responded positively or not?
They have said you have to revalidate your home study report. Now, again, the iceberg gets bigger and bigger. In fact, Your Lordship, to recall, these documents need not be produced at all because Your Lordship's order is very clear. It says you go ahead and you issue it.
Get Shanti Bhushan, get him. Now we'll pass some order here.
I'll try to get him now.
Get him, otherwise I'll take it day after tomorrow.
Fine.
Yes.
Great.
Try to get him now, otherwise day after tomorrow.
Please, I'm great.
Let's day after tomorrow.
Great.
Yes.
Admission 83. In this matter, charges framed in minutes on 15/3/2022 minutes.
Before, after?
After charges have been framed.
After
out
filing of the petition.
now. Much before that.
Much before the filing of the petition.
Charges were framed not.
They were not present on the last occasion also.
Cognizance is taken 1/10/2018.
Kodi. The learned counsel appearing for the
Framed on
respondent
15/3/22.
PN Manmohan and the learned HCGP in unison on verification of records.
The petition is
Submit
filed not
that
1
the
month.
petition is filed on 20th January 2022 and the charges had been framed.
On
Charges-
15/3/2022.
15/3, not after, not, I'm sorry. But the date is wrong. Not
Yes.
heard this matter on the last occasion. But 2018 complaint, Lord said notice that Lord, now it's stage of evidence. Therefore, Lord said Lord should not interfere.
Anyway, nobody is there. Interim order ಇದೆಯಾ? ಇಲ್ಲಲ್ಲ.
He wanted to travel abroad. Adike, he said he wanted to seek permission.
He is not traveling to this court only. Yes. No representation. We have the petition list after 2 weeks. Please. Yes. Next.
84.
Interim order ಇದೆ.
Lordship, kindly have done Friday.
List on 18th.
Let's say in this matter also frame charges
ಯಾವತ್ petition ಹಾಕಿದ್ಮೇಲೆ ಮುಂಚೆನೆ ಮೇಡಮ್.
prior to that, my lords. Let's it's charges frames on 29/11/2023, my lords. It's now in
After
stage for
list on 18th. Yes.
17th.
17th. Holidays. Holidays. Holiday na 17th. ಇಲ್ಲಲ್ಲ.
ಇಲ್ಲ.
No, 18th. 17th ಆಗಲ್ಲ.
13th. 18th is some personal.
19th.
18th.
stages for
ಯಾಕೆ
evidence.
ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಹೊರಟೋಯ್ತಾ?
19th ಸ್ವಲ್ಪ ಕೆಲಸ ಇದೆ ಅದಕ್ಕೆ.
20th.
ಬೇಡ. 18th.
18th. Next.
85.
ಇಲ್ಲ ಅಂದ್ರೆ 2 weeks. Yes. Madam? ಇಲ್ವಾ? There is no representation behalf of the petitioner. Telling Madi, the learned counsel of the petitioner has been continuously absent. Even today, there is no representation behalf of the petitioner. In the event there would be no representation, the petition would be dismissed for non-prosecution on the next date. List on 20th. Yes. Next.
86.
My lords, I appear for petition. I pray for 2
Just
weeks.
after 2 weeks, interim order granted earlier stands extended to the next date of hearing. Next.
87.
Same order. Madam, interim order ಇದೆಯಲ್ಲ?
Request is an early hearing, reason being visa is affected, they're not able to travel. It's an owner's petition wherein the building collapsed. Contractor is also responsible.
304A.
Please.
Respondent Burley, then traveling and we'll take it on 20th.
Please,
List on 20th. Heard so and so list on 20th.
89 is also connected, Your Lordship.
89 and the same, huh?
Please.
On 88. K. Vijay Kumar.
Respondent number 2 to 4.
Huh. Entry model idea.
Entry model. Before 24th, any date may be.
Yenidu.
So squashing of proceedings are offense is 466, 420. Forgery of documents. And
All right. List on 19th, madam. 18th or 19th. Idea entry model. Huh? 25th.
24th trial court, it is for charges are framed. After
entry model ilvali. 2 years in the kottilla andmele disposal adu.
most of the time, one time settlement and another, most of the time it did not reach. I am ready to address my arguments. One opportunity before 24th.
All right, then we'll 20th. Yes. List on 20th. 89 also 20th. 89 and 87. Shall we tag them?
They have connected one matter in 89, which is incorrect, Your Lordship.
D-link 89.1 and tag 89 with 87.
Please.
Yes.
On submission with respect
Next.
to 89.1.
Intermodal.
Idea. Intermodal continued. Yes, next.
My lordship, on submission, my lordship.
Appearing for the plaintiff, petitioner.
Yes, 90.
Lords, can you pray for a week's time, my lords?
Intermodal.
Yes.
List after 2 weeks. Intermodal granted earlier stands it. Vacating stay there. Learned counsel appearing for the second respondent seeks time. In that light, list the matter after 2 weeks. Interim order subsisting shall continue to the next date of hearing.
My lordship, with respect to 89.1, my lord. My lords. 89.
Order there. There's an interim order there.
Please, my lord. There is an interim order.
One dealing Kadmal interim order continue. Next, yes.
91. My lord, there's no stay in this is excise act offences. I'm the owner of the vehicle, my lord, but I was not present at that time.
Excise Act. All right, Adyavat Hakiri.
Tomorrow is a matter in the trial court, my lord.
List on 21st.
My lord, tomorrow is a matter in the trial court. It may be stayed till then, till the next date, my lord.
21st will dispose all the matters we have listed on Saturday. Yes.
Till the next date, my lord, because it's been on HBC for many weeks. It's not
All the
reached
other
actually
matters we
on
have
many
granted
dates.
stay. Yes. List on 21st along with all the connected cases not tagging but in seriatim. The concerned court shall defer its proceedings till the next date. Yes,
Obliged.
next.
92.
Engage in the senior counsel. Tomorrow.
Senior counsel tomorrow. 20th.
18K trial court charge frame ಇದೆ.
18th ಗೆ ಮತ್ತೆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಬರ್ಬೇಕಾಗಿತ್ತು ರೀಚ್ ಆಗ್ಲಿಲ್ವಾ ಲಿಸ್ಟ್ ಆನ್ ಥರ್ಸ್ಡೇ ಹಾಕಿ ಮಾಡಿ 12th 12
3 milots, offenses under 489.
Intermod is there?
Intermod is not there.
Then it's not there. Yes. List after 2
Next
weeks.
week, milots.
It's not a case for it had come before me any time.
Please.
List after 2 weeks and no order. Yes. Did it come?
Prepare for respondent number 2, so. Respondent number 2.
94.
Senior 21 court ಅಲ್ಲಿ ಇದೆ. Senior 21 court ಅಲ್ಲಿ ಇದೆ.
21 court ಅಲ್ಲಿ ಇದಾರ.
There is another criminal petition arising.
ಕೊಡಿ number ಕೊಡಿ.
4787 of 20.
List after tag this list after 2 weeks. Next. 95.
Second FR. First FR is stayed. Second FR is there, but
List after 2 weeks. IO. Next.
96.
Lordship, it's not a disproportionate of assets case. It's a misconduct case, Your Lordship. That misconduct by public servant, not a disproportionate.
Not 96 appearing for the petitioner.
List on 20th. Yen Mahesh idu?
Lord, the section 13 subclause 1A, the affair has been registered against the petitioner. There is a departmental inquiry conducted by the district judge, which says there is no role of the petitioner. Then also they have filed the charge.
Exonerate ಆಗಿದ್ದೀರಾ?
Please, my lord.
ಎಲ್ಲಿದೆ order of exoneration?
My lord, it is, no. Apologies, my lord.
Where is the observation?
Departmental inquiry which I have produced at Annexure C at page number 13. 13. Relevant portion is page number 22.
1 minute, sir. Vicharana Varadi.
Please, my lord. So conducted by the district judge.
Whoever conducts it. Why do you repeat that?
We have filed objection. There is
They have
beyond
filed
that
already.
ice meets in this case, Your Lordship. We'll make our
The
submission.
petitioner is before this court, calling in question the proceedings in CC, Special C,
Please, madam.
in a charge sheet ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ ಇನ್ನೂ ಹಾಕಿಲ್ಲ.
In crime number 7 of 2020, the learned counsel Mahesh CM appearing for the petitioner would submit that on the very same set of facts, the petitioner was subjected to departmental inquiry and the inquiry officer has observed as follows. In objection ಹಾಕಿದ್ದೀರಾ?
I filed objection.
In that light, there shall be an interim order of stay of further investigation qua the petitioner till the next date of hearing. List the matter on 25th in the fresh matters list.
Much.
Yes. Next.
For date in the
Huh?
P5, request for date in the next week.
95?
It was adjourned by 2 weeks. The request for the next week was
Next week. Interim order ಇದೆಯಲ್ಲ? A list after 4 weeks. Yes.
SCST matter. They
Yes,
take a
sir.
time many times.
97?
Petitioner in this case, my lord. Carl Tavern's case, my lord.
ಇದು A2 ನಾ?
A4, my lord.
A4. ಅದು A1 ಆದ್ಮೇಲೆ ಮಾಡ್ತೀವಿ.
ಹಾ.
List after 2 weeks. Yes.
Stages for evidence, my lords, charges framed in this.
No problem, madam. Nobody except A1 and A4 ಎಲ್ಲರದು ಕ್ಲೋಸ್ ಆಗಿದೆ ಈಗ. Carlton Towers, 2008.
2008.
98? Appearing for petition, my lord. My lord, there is 7 years of delay in this case, my lord.
Stay ಇದೆಯಾ?
No, my lord. In 2000
List on Tuesday in the fresh matters list. Yes. Next. 99.
Said that Lord should dictate Lord complainant's petition, defamation case. Cognizance taken summons Lord at that stage.
List on Friday ಹಾಕಿ madam at 4 PM ಅಂತ ಹಾಕಿ so that I'll dictate at least. Yes.
Very good.
Next. 100.
Remember, 100, my lord, may one submission, my lord. The case, my lord, is about 200 acres of land has been granted to various people, belongs to their own family members. Stay granted, my lord, on the ground that the sanction was not obtained at the time of filing of charge sheet.
My order.
Not your order, lordship.
The Lokaayukta matter.
100. Sorry.
Serial number 100, it is a Lokaayukta.
I'm sorry, my lord, it's 101.
Lordship, 100, Your Lordship.
Some other submission, Lord.
ಅಯ್ಯೋ ಭಯ ಪಡ್ಕೋಬೇಡಿ ಸರ್.
ಭಯ ಇದೆಲ್ಲ ಗಾಬರಿ ಆಗ್ತದೆ.
ವೆಕೇಟ್ ಮಾಡಲಿಲ್ಲ ನಾ ಇಂಟ್ರಿ ಮಾಡರ್.
100, Your Lordship. I appear for the respondent.
Can I?
Restoring the name in the revenue records. ಇದ್ರಲ್ಲಿ ಏನಿದೆ?
Yes, Your Lordship.
Yes,
There is
list after 2 weeks, entry order granted earlier stands extended to the next date of hearing. Yes, continue ಆದ್ರೆ ನಾನು will do it. Yes.
Department ಅಲ್ಲಿ ಇದು promotion ಸ್ವಲ್ಪ ಆಯ್ತಪ್ಪ.
ತೊಂದ್ರೆ ಇಲ್ಲ. With retrospective effect you will get. Yes.
Date.
101 ಏನಿದು?
This is the matter, my lord, 200 acres of land has been granted to various relatives of these people. The court grants stay order, my lord, on the ground that the sanction order was not there. The reason for sanction order, my lord, the accused was in custody because the 60 days period, my lord, the charge sheet was filed with the request saying that
The order. Yes.
with the request saying that sanction will be obtained. And the
No,
sanction,
no. Because the interim order is granted in some other case. I have
correct, my lord.
granted.
Subsequently, all other cases, my lord, quoting that interim order obtained in all other cases.
My lord,
ಓ ಇದೆಲ್ಲ 4.
Yes, my lord.
5 cases.
101.2 is arised of different crime number, my lord. Not granted to this matter.
All right. First ಕೊಡಿ ಯಾವ್ದಿದೆ?
Initially, the crime number, in crime number 157.
Which is the case where first interim order is granted by the coordinate bench? Which is that? ಅದು ಕೊಡಿ ಮೇಡಮ್.
But I am not challenging the same crime, said crime number, my lord.
Wait, ಒಂದೊಂದಾಗಿ. Except the confession statement, nothing is there and the sanction ಅಲ್ಲ.
No, there are financial transactions. Accused have paid money to the public servant. Through bank transactions have happened. Lands have been granted to their own relatives.
I have produced documents, Your Lordship. There was a different transaction between A2. A2 is a broker. Petitioner is herein had purchased a land and which was allowed through broker
All right,
by A2.
you get ready. Day after tomorrow in the fresh matters.
My lord, 101.2 may be dealing because it is not a result of same crime number, my lord.
Identical crime.
Identical, but in both the cases, I am the accused, but I am not challenging the earlier crime. The same set of fact, 2 cases registered.
ಯಾಕೆ ಪರವಾಗಿಲ್ಲ? ಇಂಟ್ರಿ ಮರ್ಡರ್ ತಗೊಂಡಿದ್ದೆ ಹೆಂಗೆ?
I'm saying set of fact, 2 cases registered.
ಎಂಟ್ರಿ ಮರ್ಡರ್ ತಗೊಂಡಿದ್ದೆ ಹೆಂಗೆ? ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮರ್ಡರ್ ಇದೆ ಅಂತ ತಗೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ ನಾನು ಹಂಗೆ ತಗೊಂಡು ನಾನು
ಡಿಪೆಂಡ್ ಆಗಿ ತಗೊಂಡಿದ್ದೀರಾ?
ಹೌದು ಸರ್.
ಆಯ್ತು.
Data is clubbed, my lord. Because they are result of same crime, not same crime. The crime is not different, my lord.
We'll dealing day after tomorrow.
Interim
13th. Yes.
interim order maybe.
Interim order subsisting shall continue to the next date of hearing in all these cases. ಅದು full details ಕೊಡಿ.
Yes, my lord. One more matter, my lord, has not been listed. I'll give the number.
ಅದು ನಂಬರ್ ಕೊಡಿ. 209 acres of government land bartered away.
On ground of sameness, this honorable court granted stay for me, my lord. I have not challenged the first case. In that case, I am accused. I'm facing the proceedings. In second case, on same set of facts, 2 FIRs registered against me. I'm seeking quashment of FIR, second FIR, my lord. Not the first FIR.
We can sustain that also. Yes.
102.
Chetan, list after 2 weeks. Interim order continue ಮಾಡಿ. Yes.
103.
For the petitioners, your lordship, the petitioners are accused number 9 and accused number 11, your lordship.
Second respondent, my lord.
Interim order ಇದೆಯಾ madam?
ಇಲ್ಲ, your lordship.
2 weeks time granted to file objections.
Offense ಏನು?
Your lordship, the offences are 418, 420, 465, 466, 468, 471.
Let him file his objections.
Your lordship, a date may be fixed.
Before me. All right, yes. List after 2 weeks. Objections, if any, by then. Yes, next. Move the matter. The registrar is directed to put up the matter immediately after filing of the objections. Yes, next. Chinmay.
104.
What's up for petitioners, please, lords?
What's this?
Lords, this is a case, please, lords, where justice could not.
Shanti Bhushan, sir. Uganda ತುಂಬಾ ಕಾಟ ಕೊಡ್ತಾ ಇದ್ದೀರಾ ಯಾಕೆ? I will have to pass some order then.
Just asked him for home.
Why are you asking all that again, overall again? I have directed to issue a certificate.
My lord, initially 2018 he had submitted. My lord, 2018 home study report that is expired after 3 years. Just that, my lord, he can notarize it and give it to me, my lord. We are ready to give it. I've just got.
ದಿನ ಒಂದೊಂದು ಕೇಳಿದ್ರೆ ಮತ್ತೆ ಅವ್ರಿಗೆ ಹೆಂಗೆ? What is this?
No, my lord. If your lordship may kindly see.
You are reducing the order to a nullity now.
I'm sorry, my lord. That.
Otherwise, what is the use of the order? Tell me. ಅಲ್ಲ ನೀವಂದ್ರೆ your officers should not be doing that. ಅಲ್ಲಿ ಇವೆಲ್ಲ ಕೇಳ್ತಾ ಹೋದ್ರೆ see I have directed you to issue the certificate.
Please.
Issue the certificate in accordance with law ಅಂದ ತಕ್ಷಣ you are going on asking things. 6 months ಆಯ್ತು, 1 year ಆಯ್ತಾ ಈಗ?
It says issue NOC in terms of the observations made in this order.
Certain documents were required.
It's not correct. Now you can't hold a roving inquiry now.
It's not that, my lord. We have just all the documents are produced except only one document, my lord. That's a home study report.
This
My lord, I've instructed I've instructed.
Otherwise, it should not. The findings in the order should not become useless.
No, my lord. I'll instruct them.
Either implement it or not implement it or challenge it.
No, my lord. That's not the intention, my
No,
lord.
true, but then why should you dodge the issue? You should tell your officers not to dodge the issue.
This only the reason is this, my lord. Your lordship in the order to state it in accordance with law.
That is why ಅದೇ problem ಆಗದು.
That is the reason.
In terms of the observation.
Lord, a mail is sent to my learned friend.
Well, he told me today morning something is sent.
12:29, my lord.
And now you want to get a home study report now. That is incorrect, sir. Yes, I'll take it on 13th. By then you bring about a solution.
Please.
List on 13th in the fresh matters list.
I apologize, my lord. I was on my legs.
That's all right. Idrad ಹೇಳಿ ಇದೇನು?
This, my lord, I need to file my objection.
Why are you the ROC na?
Ministry of External Affairs.
Really,
All right.
your lordship, if the stay was granted on the score that investigation has not been done. But coordinate bench, my lord, on the same set of facts and the same crime number, dismiss the petition saying it's there, my lord. They have attached that page number 163, my lord. Page 63.
Really?
It is a successive petition.
ಅರೆ long ago. 5 ವರ್ಷದ ಕೆಳಗೆ.
Observation in that case.
ಅದೇ ಅಲ್ಲಿಂದ ಏನು ಮಾಡಿಲ್ಲ ಅಂತ ತಾನು ನಾನು ಕೊಟ್ಟಿದ್ದೆ.
ಹೌದಾ? That is the reason your lordship granted.
Investigate thoroughly. What have you done?
That is
5 years.
so therefore this
Thoroughly investigation ಮಾಡಿಲ್ಲ.
Madilla.
ಮತ್ತೆ?
Instead of granting stay, my lord, that
No, now I will not vacate this.
action against the officer for not.
Departmental inquiry.
That's
Initiate and get that. Yes. On circular issue ಮಾಡಿ. It's better. The DG and IG issues a circular that if the investigations are not complete within 6 months or in a given case maximum 1 year, those IOs will face inquiry. ಬೇಕಾದ ಕೇಸಲ್ಲಿ 24 hours ಅಲ್ಲಿ ಮಾಡ್ತೀರಾ? Charge sheet is filed in 24 hours.
the explanation here is that their written letter, but I think writing letters will not serve any purpose, but they have to do.
Initiating departmental inquiry will serve the purpose. ಎಲ್ಲ ಬರುತ್ತೆ. ಸರಿ ಹೋಗಿ. Yes, we'll take this on 25th. Interim order subsisting will continue till the next date of hearing. They have not called you for investigation till date?
No, please, my lords. They've called, please, my lords, submission, please, my lords, as they've called every time the IO changes, please, my lords, we have gone and submitted the same documents. And
Even then nothing has happened.
nothing has happened. Now, please, my lords,
Close ಮಾಡಿ. ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಕೇಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಕೇಸ್.
Hardly a trafficking issue. Trafficking issue.
and please, my lords, they don't.
ಅಲ್ಲ 370 name of
370.
370 name of the
ಇವತ್ತು why do you 5 years ಆಗಿ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ? If you feel the offense is so grave, file it immediately.
they
What
say
stops
that
you for 5 years not filing charge sheet?
various document which they sought has not been received.
All right, sir. 5 ವರ್ಷದಿಂದ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
My lord, a submission, please, my lords. In fact, this matter was called before Protector of Immigrants, please, my lords. Even he is not passed an order. Because, please, my lords, the person who is alleging.
10 ಏನೂ ಆಗಿಲ್ಲ.
No, please, my lords.
ಮತ್ತೆ 370 ಎಲ್ಲಿ ಬರುತ್ತೆ ಇಮಿಗ್ರೇಷನ್ ಇಲ್ಲ ಅಂದ್ರೆ? ಅದಕ್ಕೆ ಏನು ಇಲ್ಲದೆ ಇರೋದಕ್ಕೆ 5 years ಇಂದ ಏನು ಮಾಡಿಲ್ಲ.
ಶಾಂತಿ ಭೂಷಣ್ ಅವರು ನಮ್ಗೆ ಕೋಆಪರೇಟ್ ಮಾಡ್ತಾರೆ.
Now my I'm impleted now.
On a lighter note, madam.
You can't tell that to him, sir. Yes.
Please, my lords.
We'll take it on 25th.
Yes, please.
We'll close it on that day. ಅವ್ರನ್ನ ಇಂಪ್ಲೀಟ್ ಮಾಡಿದ್ದು ಬಿಕಾಸ್ ದ ಇಮಿಗ್ರೇಷನ್ ಏನಾದ್ರು ಇದೆಯಾ ಅಂತ ಕೇಳಕ್ಕೆ. ಯಾಕಂದ್ರೆ ನಿಮ್ಮ ಹತ್ರ ಇನ್ಫಾರ್ಮೇಶನ್ ಎಷ್ಟು ದಿನ ಆದ್ರೂ ಸಿಗಲ್ಲ.
We have written letter to the immigration department and they have not.
See, now the information comes within 24 hours. That's why Shanti Bhushan is.
He does not even come within the definition, please, my lords.
That's why. 25th, yes.
105.
PV Patil name may be deleted.
Registered, delete the name of Baby Patil from the cause list. Yes, list after 2 weeks ಮಾಡಿ. Yes, sir. In all other matters where interim order is there.
Serial number 151, my lords. Compromise. 151, my lords. Respond number 2 is
bail. 1 ನಿಮಿಷ.
appear with advocate.
ಏನ್ ಕಾಂಪ್ರಮೈಸ್?
I have filed just now I have filed a compromise.
Just now?
Madam? Matter is settled.
ವಕಾಲತ್ ಹಾಕಿದ್ರಾ? ಯಾರು? All right. You got someone. Learned counsel undertakes to enter appearance for so and so. Registry to print so and settlement ಅಲ್ಲಿ.
Have filed. ಕೊಟ್ಟಿ.
ಇಲ್ಲದೆ. Shortest. Yes.
Serial
Now you
number
can
108. There are 5 connected matters.
1 minute.
108, my lord. There are 5 connected matters. All 5 connected matters are of 138 of Negotiable Instruments Act. And my lord, I've been trying to argue upon the IF filed, my lord. I'm not able to argue on the matter.
Vacating stay na?
Not there's no stay. I am for the petitioner, my lord. There's no stay granted, my lord. I'm not able to argue on that matter itself, my lord. But it is on 17th of.
Spiraling stay order da ಇದು? ಒಂದೊಂದು ತೋರಿಸಿ ಇನ್ನೊಂದು ತಗೊಂಡಿದ್ದದ?
My lord, no, my lord, there's no stay order in any of the matters. It's going in 1013.
It will come, yes.
Lordship, serial number 111.
My lord, in this case,
apologies.
Lord, in this case, there's a commercial OS there.
25th, sir. 25th.
Serial
My lord, on 17th.
108, 25th.
My lord, requesting at least on 17th, there is a matter in the lower.
108, 25th. That's all.
111, your lordships. It's at Unisha now.
110, you know. In which, sir? There's an interim order.
Covered judgment, civil matter, they are closed in the criminal case. civil case dismiss ಆಗ್ಬಿಟ್ಟಿದೆ.
ಆಯ್ತು, ಎಲ್ಲ let it come. File, sir, I'll take it on 25th.
It may be tagged with along with criminal section 6306.
30th. Yes.
May be tagged with 6306.
List on 30th in the fresh matters list, tag, sorry,
Along with tagged with along with the criminal petition
ಬರ್ಕೊಡಿ.
6306.
ಆಯ್ತು, ಸರಿ, yes.
of 20.
Serial 106, my lords.
One,
Interim order ಮೇಲೆ ಇತ್ತು.
Unishare ಯಾವ್ದು ಹೇಳಿದ್ರೆ?
111 your lordships. 111 series.
Connected matters ಎಲ್ಲ.
ಎಲ್ಲ connected matter.
Lordship has-
Any specific date and time may be fixed.
Israeli stay has been, they have gone to Supreme Court, my lord, Supreme Court dismissed this
No,
coordinate.
no, no, 1 minute. List day after tomorrow in the fresh matters list. 111. 13th in the fresh matters list.
Your lordships,
Interim order to continue in 2 months.
if I may request for Tuesday next week, your lordships, 13th, ಯಾಕಂದ್ರೆ
Urgency ನೀವೇ plead ಮಾಡೋದು.
correct lordships, some inconvenience of Friday. Otherwise I won't.
All right, 18th in the fresh matters list.
Grateful.
111 2 matters, interim orders to continue.
Interim order wherever subsisting will continue till the next date of.
116, 111, there are other 2 matters has to be connected. Can I give the numbers?
ಬೇಡ, ಇದಾಗ್ಲಿ ಆಮೇಲೆ. Yes.
My lord, serial 106, my lord. I
DM.
filed an IA for vacation of stay.
106 ಅಲ್ಲ, correct?
My lord, may not may place it.
I appear for the petition.
Vacating stay ಇದೆಯಲ್ಲ?
Same, but may not may place it on 24th or 25th, my lord.
25th, yes. 106.
Interim order may be extended, Lord.
116.
No, no, we are at,
115.
ಎಲ್ಲಿದು?
105, 106,
106 ಅಲ್ಲ, 111 ಆಯ್ತಲ್ಲ?
107, my lord.
107.
107, my lord. My lord, it's a charge sheet which has been filed against the father.
Charge sheet is filed.
No. For respondent number 2, my lord. The father has been stabbed by his own son. That's A1 and A2 is this wife. And they have given this petition to squash the charge sheet, but it must not be squashed.
So what?
Because
All right, let it come. Interim order ಇದೆಯಾ?
Illas, ma'am.
ಆಯ್ತು. List
The respondent.
For the respondent number 2.
18th. ಹೌದಾ? ಹಾಗಾದ್ರೆ ಬಿಡಿ, list after 2 weeks, yes. 108 ಆಯ್ತಲ್ಲ? ಹಾ. 109 KG ಅಯ್ಯಪ್ಪ.
109.
ಶ್ರೀಧರ್ ಕೆ.
109 is also connected with other,
ಅದೇ ಸೇಮ್. Connected with 111.
yes.
Yes, ಅದು ಯಾವತ್ತು ಹಾಕ್ತಾ? 18th ಹಾಕಿ ಮೇಡಮ್. Yes, next.
112.
2 weeks ಯಾರಿಲ್ಲ ಅಂತ.
7.
7 ಏನು? 13th. 13 ಆದ್ರೆ 20th. ಮಿಕ್ಕಿದೆಲ್ಲ 20th ಹಾಕಿ.
113.
I appear for the petitioners, your lordship. Respondents had to file objections today.
Interim order is there?
Interim order is there.
2 weeks, I will. Next.
114.
For petitioner, my lord.
Interim order ಇದೆಯಾ?
ಇದೆ.
2 weeks, I will. Yes, next.
115.
Lords, interim order is only 406 and 408.
18th. ನನ್ ಮುಂದೆ ಬಂದಿತ್ತ ನೋಡಿ ಒಂದ್ಸಲ.
That house of.
Yes,
No
ಬರ್ಲಿ.
such company in the existing address.
Huh?
No such company in the existing address given. Here,
Yes,
it's a
based on,
business transaction, my lord.
based on 2 weeks, just after 2 weeks, yes, next.
Covered by Lalit Chaturvedi matter, my lord.
116
18, my lords, may I request on 18th.
No, just after 2 weeks, yes.
116 is DA matter.
13, 20th, yes. Big group ಯಾವ್ದು ಕರಿಬೇಡಿ.
152 is
107.
All big group matters will give a date. Interim order wherever is there will continue. No individual case, don't mention, yes. ಅದು big group ಅಲ್ವಾ? 119 big group ಯಾಕೆ ಹೋಯ್ತು ಮತ್ತೆ? 24, 25. ಮೇಡಮ್ ಅದು big ಇದು PC ಯಾವ್ದಿದೆ ಅದನ್ನ 20th ಹಾಕಿ.
152.
118 B group.
It won't be called.
ರಿಸರ್ವ್ ಆಗಿತ್ತು. ಅದಕ್ಕೆ ನಾನು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಗೆ ಅಂತೇಳಿ
ಏನ್ ಕ್ಲಾರಿಫಿ ನೀವೇ ಮೂವ್ ಮಾಡಿದ್ರಿ. ರಿಸರ್ವ್ ಆಗಿದ್ ಮೂವ್ ಮಾಡಿದ್ರೆ ಅದು ಹೋಯ್ತು.
ಖಾಲಿ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಮಾತ್ರ ಕೊಡಿ.
ಆಗಲ್ಲ ಅದು. ಅಲಿಮಾ ಮೇಡಮ್
118, my lord. B group.
Serial number 121, my lord.
Enough. Yes. ರಿಸರ್ವ್ ಆಗಿರೋ ಮ್ಯಾಟರ್ ಫರ್ದರ್ ಹೆಂಗ್ ಹಾಕಿರೋದಲ್ಲ.
ಹೌದೌದು. ಖಾಲಿ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ದುಡ್ಡು ಯಾಕೆ ಕೊಡ್ರಿ ಅಂತ ಕೇಳಿದ್ರಿ. ಅದಕ್ಕೆ ನಾನು
ಇರೋದ್ ನಾಳೆಗೆ.
152 ಅಷ್ಟೇ.
ಎಸ್.
ನಾನು ಅದಕ್ಕೆ ಕೋರ್ಟಿಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ. 152.
ಇಷ್ಟೊತ್ತಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರೆ ತೊಂದರೆ ಆಗುತ್ತೆ.
ಸಾರಿ.
Regarding further hearing matter, serial number 130
ಇದೆಯಲ್ಲ?
be connected with serial number 42 and taken up at court.
Wait. We'll see. ಹಾ ಸರ್.
ಕೋರ್ಟ್ಗೆ ಯಾವ ಟೈಮ್ ಆಗುತ್ತೆ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್, ಎಸ್.
ಡೇಟ್ ಓನ್ಲಿ
ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಲ್ವಾ?
ಖಾಲಿ ಇದು ಮಾತ್ರ ನನಗೆ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಮಾತ್ರ. ದೆನ್ ರೆಸ್ಟ್ ಆಫ್ ಥಿಂಗ್ಸ್ ಐ ವಿಲ್ ನಾಟ್ ಸೇ ಎನಿಥಿಂಗ್.
ಕೊಡಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿರಿ ಅದು ಇಟ್ಕೊಂಡು.
Not relating to the date, your lordship.
No, nothing now. All men. B group will come later.
Two unconnected matters are being clubbed in 117.
ಯಾವ್ದು ಸರ್ ಅದು?
117 and 17.1. They relate to two different incidents. 117 and 17.1, your lordship. I appear for the petitioner in 117.1. The first petition which is being clubbed by the general order has no correlation with the
2019 ಯಾಕೆ ಬಂತಿಲ್ಲಿ?
that is a separate incident, your lordship.
Dealing 117. Yes.
And your lordship, I don't have an interim order. May I request?
No problem. You don't have an interim order.
The respondent prayed for time on the last occasion.
We'll see. It will come on
One date, your lordship.
20th.
My lord, serial number
Senior bench
118.
Oh, that's okay. Let's see then. Works matter, huh?
Works.
Then let it be. Yes. List on 24th.
My lord, serial number 100.
Teacher, that's why probably.
Huh?
Complainant.
Irli, let it be.
Filed a case against
Now, if all of you stop, I will start. Stop. Yes. Halima madam kodi. Bail matter kodi.
Yes, ma'am. And for the petition. Let the offense alleged under section 324, 326.
One minute.
Yes.
Why is bail refused? By the
Because it
Sessions
is
Court, why is it
criminal
refused?
Because it is offense to be tried by Sessions Court 307. It is all. There is no.
Yes, madam.
There are 5 injuries caused, my lordship. Out of 5 injuries, 3 injuries are grievous in nature. One injury is on the left part of the chest, my lordship, which is a vital part of the body, my lordship.
Charge sheet is filed.
Yes, please, my lordship.
Charge sheet is filed.
Yes,
My
ma'am.
lordship.
Yes.
25/6/24, charge sheet is filed, my lordship.
All right.
And 5 eyewitnesses are there, and recovery of the weapon is as per the instinct of the accused, my lordship.
Hmm.
And also, under 307, my lordship, if hurt is caused, the imprisonment may extend to life imprisonment also, my lordship. Hence, the petition may be dismissed. It's a very grievous, heinous offense. 5 sali kochiradu, my lordship. Photos are also.
Sali?
Tap, yes, my lordship.
ಚಾಕು ಕುತ್ತಿರೋದು ಅಂತ.
Who is your accused number?
I'm so lucky.
Sole accused.
All accused.
Yes.
Even
And
FSL
it is actually case of scuffle, my lord. The petitioner also has sustained injuries. They have suppressed that matter. There is no any investigation into that.
As per the FSL report also.
What is the condition of the What is the condition of the victim?
Sorry, my lordship.
What is the condition of the victim?
Discharged, my
Long
lordship.
back.
Discharged after.
Long back.
What was the reason for the assault?
There was a scuffle. They both of them went to buy the pants from the scrap boat.
He is a
They are the
scrap dealer, my lord.
scrap material dealers. So there it was delayed. The fellow who is supposed to sell the fans had not come. So there was some like they accused each other. I mean, why this delay and all that. So there happened some scuffle. That's all, my lord. And 326. Yes, I have already.
326.
Grievous injuries, there is, he has been, yes, my lord, he has been discharged. It is, the petitioner also sustained injuries. He is there inside for the last more than 5 months now.
Rightly so. Yeah, no, nothing wrong.
But he has
You
come
can't
to
take somebody's life
within few
so
days.
casually.
The hospital. No, now this is a question of trial, my lord. It will take long time now. Charge sheet is filed. He is not required for investigation. And
ಇರ್ಲಿ ಸ್ವಲ್ಪ ದಿನ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
Lord, 5 months in the ಆಯ್ತು. 5 months.
So what?
More than 5 months ಈಗ 7/4 ಗೆ 7/4 ಗೆ arrest
I
ಆಗಿದೆ.
thought there is nothing, your way you are telling there is nothing.
Report also, my lord.
326 and 307, 307 ಅಲ್ಲಿ 5 ತಿಂಗಳು ಒಳಗಿಡುವುದಂದ್ರೆ
ಇರ್ಲಿ ಬಿಡಿ. 420 ಅಲ್ಲೇ ಇರ್ತಾರಂತೆ, 307 ಇರ್ದೆ ಏನು? Yes. We'll grant, we'll see. Yes.
In the FSL report also, the blood stains on the dragger and the cloths of the accused all are matching a human origin and O group blood, my lordship.
human origin petitioner ಇದು ಅಂತ
Let me
ಹೇಳೋದು.
go through it. 13th. Yes. Not a case for showing so much indulgence. 13th, yes.
Blood, 5 months ಇಂದ ಒಳಗಡೆ ಇದಾನೆ.
ತೊಂದ್ರೆ.
More than 5 months ಆಯ್ತು.
307. Yes. Adu Nandakumar is waiting, I think. Yes.
Number 130. Pending orders. 130.
What, madam?
Come back another day, my lord, in view of the.
It's a waiting. Yes.
My lord, serial number 49, my lord.
Adeno.
Breach of promise to marry.
Breach of promise of disposal. We'll post it on 18th. 18th or 19th fresh matter.
My lord, before 13th, my lord. 13th sessions ಅಲ್ಲಿ.
ಏನಿದೆ?
There is no stay, my lord.
ಏನಿದೆ?
Evidence.
All right, list the matter on 20th. There shall be an interim order of stay of further proceedings before the concerned court. Settlement aliradu. Breach of promise, yes.
Grateful, my lord.
Nandakumar.
Lord, any day.
Coffee time is over.
In fact, I just wanted to tell your lordships one thing. I wanted to leave from office and come there. I had come back for some BC matter. I started hearing my learned friend, Mr. Chowta. I was.
You thought you should be in the office.
No. I did not want to miss a word of what he says. I was following every word of what he was saying. I really wanted to compliment him on the lucid manner in which
the court would join you. Yes.
That's why I did not leave and come. I was.
Because he's always in depth, in detail.
I really want to place it on record that it was a wonderful exposition for me, because it's not an area I'm very familiar with. So I very much learned.
I will also join you on all that.
So grateful for it.
Yes. Yes, sir. Yes, Chowta sir, ಏನು?
Same that matter, my lord. My opponent is Nandakumar.
ಅದಕ್ಕೆ ಇದ್ದೀರಾ?
I'm waiting for only that.
Oh, this is that international fraudsters, ada?
Yes,
We are not
domestic.
Domestic fraudsters. ಅಲ್ಲ, ಅದರಲ್ಲಿ
Transaction is domestic.
But I play some documents are placed. I'll just place it. Your lordship may fix it.
Another day will have.
Any day. But I don't.
One ನಿಮಿಷ. 20, madam, 21st, 83 hours.
21st, if it's possible, no difficulty.
ಯಾವ್ದದು? ಹೌದಾ? 21st ಹಾಕಿರ್ತೀನಿ.
ಆಗ್ಬೋದು.
Yes.
Great.
ಏನಾಗ್ಬೇಕು?
Civil transaction.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ಲ ಅಲ್ವಾ? ಆಯ್ತು.
There is an email, my lord.
21, 21. 21. Yes. ಅದೇ 115, 21st ಹಾಕಿ.
Email transaction is there to take back to goods, my lord. In spite of it.
ಯಾವ್ದು ಕ್ಯಾಶ್ಯೂದಾ?
Hello, my lord. This is with regard to one tiles.
Tiles industry.
Sale of tiles.
All right.
And there is a recovery of money from me. But we have stated, my lords, your tiles, which we are.
ಈಗಲೇ ಆರ್ಗ್ಯುಮೆಂಟೇ ಮುಗಿಸ್ಬಿಟ್ರಲ್ಲ ನೀವು. ಎಂಟ್ರಿ ಮಾಡಿ 21st. Yes. Yes, Satish.
21, my lord.
Lord, three matters, my lord, disproportionate asset. Date was given to today.
Not listed. ಅದು ಫಸ್ಟ್, ಸೆಕೆಂಡ್, ಥರ್ಡ್ ವೀಕ್ ಅಕ್ಟೋಬರ್ ಹಾಕ್ಬಿಡಿ.
May I request for tomorrow, my lord?
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ?
ಇಲ್ಲ, fresh matter. Lord, it was listed.
ಹಾಕೋಣ ಎಲ್ಲ 22 ಅದಕ್ಕೆ ಮಾತ್ರ ಹಾಕಿ 20th ಹಾಕಿ ಅಷ್ಟೇ.